Hello again, everyone. I think I finally got the go signal. Well, I think we're on air. Still good, Pao? Yes, I think we can start. So again, thank you, everyone. I think you can hear me. Everything is good. We did a bit of a tech run and hopefully everything is working. Again, thank you so much for joining us today. I would just first and foremost like to commend my friends, my colleagues, youth from all around the world who organized and worked for weeks to organize this event. And I'm just really proud how we pull this off together. And I'm very excited and happy that young people are joining in and taking part in important conversations such as this one, and in fact, leading the conversations. So to formally start the event, I'd just like to, again, quickly introduce myself for those who didn't hear the first time. I'm Nicole Ponce. I work for the Normandy Chair for Peace. I'm from the Philippines, but now I'm based in Normandy. And I'm also part of the World Seed for Climate Justice, and I handle the Asian front for the campaign. So without further delay, I would like to give the floor to Alan Ware. Alan Ware is a peace educator and international peace and disarmament campaigner originally from New Zealand, but has lived in the United States. And he is one of the leaders of the successful campaign to prohibit nuclear weapons from New Zealand. So Alan is a mentor and in fact part of the advisory group of the World Suite for Climate Justice, and is also a member of the Normandy Chair for Peace, who handles the climate justice line. So to officially open the conference, I would like to give the floor to Alan for some welcoming remarks. Alan? I think seems like Alan has dropped off. Maybe we can circle back to Alan. He was here at some point, but then maybe he has some internet connection problems. So if that's all right with you, I would just like to proceed with the next. Oh, Alan is here again. Hi, Alan. Can you hear us? Hi, Alan. I can see that Alan is here, but he hasn't turned on his mic.
He just sent a private message that his video and audio is disabled.
Okay, maybe we can help with that, Pao. I don't know why it's video and so while we're working that technical issue, I think David is here. David, the same as Alan, is a longtime mentor. He's the co-director of the Environmental Law Program of the William Richardson School of Law in the University of Hawaii. He's also a member of the Normandy Chair for Peace. And I would be very much happy if David could open the session as well, because he's been a long ally and supporter of the ICJ-AO campaign, and he's been there from the very beginning and has had given support and advice to our friends in the Pacific as well. So no better person to open the session than David Foreman.
Aloha, everyone. And if Alan is able, please feel free to interject, because Alan has much wonderful experience to share that he has been sharing. Again, my name is David Foreman. I may not look it, but I am also Filipino. My mother's from the Philippines, although I've been born and raised in Hawaii. Not born, I was raised in Hawaii. On behalf of the Normandy Chair for Peace, I want to thank everyone for joining us this evening or this morning for all of you. The Normandy Chair for Peace is headed up by the chair, Tony Aposa, Emeritus Chair, Professor Nicholas Robinson from the Pace University in New York. The general coordinator is Emily Gaillard, and Pascal Bollion is the director of French National Research Service, who's been a wonderful advocate. And all of them, I think, would join me in congratulating Nicole and all the other youth that have really been the force behind this whole movement, at least with respect to the ICJ advisory opinion. Nicole, did you want to join back, Alan, or would you like me to continue? Okay.
Please continue, David.
Okay, no problem. I just wanted to share with you that I had the privilege of meeting the founders of the Pacific Island Students Fighting Climate Change, who started the ICJ AO campaign. I met Solomon Yo at in an event back in July of 2019, and just really an impressive young man. Introduced me to a number of NGO activists, members of the Vanuatu government, Chris Barnett, who I've since had the pleasure of listening to speak at the COP27 and in other events, as well as elders and youth in Vanuatu, and members of the media and other subject matter experts doing some really strategic public relations oriented work as they prepared for meetings with the Pacific Islands Forum. And so those grassroots efforts eventually built towards the creation of the World's Youth for Climate Justice, and folks like Nicole and many others around the world joined with the Pacific Island Students Fighting Climate Change to create the World's Youth for Climate Justice, which is really an impressive, not only for the determination of the youth and the imagination of the youth, but the inclusivity of the youth. Their leadership style is really something that should be emulated across the globe. And I just wanted to share that, Hewlett Schnakenberg and Vishal Prasad, who's now coordinating with Pacific Island Students Fighting Climate Change. There are so many people that we could list. Many of them you'll hear from this evening. But also, it's very important to recognize that if not for Vanuatu stepping up, the government of Vanuatu, we would not be where we are today with respect to the ICJ-AO. Some of the speakers will be addressing the petition before the ITLOS Tribunal, and also the action that was filed in the Inter-American Court of Human Rights. So we've got this on three different fronts. It really does take a village. So these combined efforts are something that it's important to recognize, but not just the Vanuatu and the other nations that co-sponsored the ICJ advisory opinion, but Blue Ocean Law, Margaret Veverinki, who I understand was an instructor of the students at the Pacific Island Students Fighting Climate Change, with Justin Rose, who kind of planted the seed in their class. So, sometimes it's important to think about what inspired them. I think those folks inspired the youth in the Pacific. As for myself, I was inspired by Attorney Aposa, who came to Hawaii, and I really didn't consider myself a climate activist until I met Tony. I was very involved in environmental issues, but it was Tony asked me when he came to the University of Hawaii. We co-taught a class on climate justice for future generations. He came back the following year, hosted a play shop on the North Shore, brought in experts from all over the world, just to brainstorm about, what could we do after serving for 20 years, representing one of the Pacific Island nations in the climate conference. He was frustrated at the slow pace, and he proposed this idea of going to the International Court of Justice. And so I, at his instruction, hosted what was called the Tony Aposa Intergenerational Moot Court. I asked Paulo, I don't know if he saw my message, there is a website available where there were memorials that were drafted by students as if there were an advisory opinion. And so I'm not mentioning this for any self-aggrandizing reason. It's really as a resource. That's what it was meant to be. That's what Tony Aposa and the other experts wanted to create for people. So hopefully folks will find that useful. It's on the environmental. I'll try to post it later if it's if Paulo is not able to do that, or somebody else. But the other thing I wanted to mention before turning this over to Alan is that I was only able to meet with Solomon and others because the NCP provided the funding to do it. I was on my way to a conference in Fiji, and the NCP supported that. I know also that Tony had spoken in The Hague, and Margareta Veverinki was there too. So I expect, that cohesiveness helped. And Alan, I think, can say a little bit more about the importance of those collaborative efforts, and that we've got folks that have been working on this. He's not much older than me, but he's been working on issues on behalf of future generations for decades himself now. And rather than take any further time, I think I would turn it over to Alan and thank him for all of the work he's done to advance the efforts of the youth. So thank you all.
Thank you very much, David. Thank you for those very enlightening words. And I'm very happy that Alan has finally joined us and his audio and video issues are fixed now, because Alan is a longtime mentor. I met him in 2019, and since then he is a force in this campaign. And I'm just very happy that he could join us. And rather than take up the time, I would rather Alan speak, because he has so much to say. Alan, please take the floor.
Thank you very much, Nicole. And I'm joining you from Aotearoa, which is the Indigenous name for our country, New Zealand, in the Pacific. And this is such an important issue. Thank you so much for Nicole for organising this forum, but also to the youth for initiating this campaign. The world is burning up. We see it now. Climate change is not something for the future. It's something which is happening now, but it's impacting everyone now and into the future. And it's so important to do more on this issue. It's insufficient what's happening with the governments at the moment. And it doesn't really matter whether your government is doing well or is not doing well, unless there's a collective effort to do much better. Then we're going to see these storms. We're going to see the destruction of the oceans and the destruction of the climate and ecosystems, which is already happening. In my country, Aotearoa, New Zealand, we've just had horrific cyclone and floods, which has wiped out orchards and other food supply throughout, like, the central North Island. And we're just one country that's facing these sorts of events already. I know Nicole had something very similar in the Philippines recently. Horrific storms in the Philippines that was wiping out villages, and we're seeing it in the Pacific Islands with the high tides, the ocean's washing over islands already. We already have climate refugees, so climate change is already here. We need to act now, and this initiative is reflective of the urgency of the situation, and also reflective that not enough has been done, and it's not going to be done just through the negotiations and like the COP process, because that's lowest common denominator. You can only get so far as governments agree. The law is so important. The law that exists is to protect current and future generations, and that law has to be applied, and it's been applied a little bit here and there in some of the domestic court cases, but that's not sufficient. It's not good enough just for one country or 3 countries or 5 countries to be pushed by their courts to take the action which is required. We have to have the whole world being pushed. That's why it's so important to go to the International Court of Justice. This is the world's supreme judicial body. It's part of the United Nations. Every United Nations member, that's every country in the world, when they sign on to the UN, when they join and sign on to the UN Charter, it's right there in the Charter. The International Court of Justice is the supreme judicial organ for the United Nations. It's really good that David mentions there are other bodies also taking up this issue under the Convention of the Law of the Sea and the Law of the Sea Tribunal and others. These are all really important. But in my mind, the International Court of Justice is the most important one. That's the one that can have the most effect, that applies to everyone, applies to all countries. Also, the International Court of Justice can take up all parts of law, not just treaties, not just agreements, which again is just what countries have managed to agree to, but customary law, the law that is basically what is required to protect civilization. This is so important. Customary law is much stronger than just the treaties and the agreements. Customary law protects current and future generations. And we're so blessed to have experts in customary law involved in this campaign, like David Foreman, like Professor Emily Gaillard, like Tony Aposa, like Nicholas Robinson. These are some of the experts in customary international law who are part of this initiative to take the issue of climate change to the International Court of Justice. A huge thanks to Nicole. Nicole has not just brought this event together. She is so dedicated to this that she's moved from Philippines to France in order to be able to be more effective. I know that's really difficult for you, Nicole, to leave, but particularly when there's, climate is already impacting your communities. But you're doing it because you know that based under the Normandy Chair for Peace, it elevates your capacity to engage youth in cooperation with legal experts, in cooperation with political experts, on this campaign to ensure that first, this question does get to the court. And that's where we can commend and highlight and thank Vanuatu, the other 18 countries, so the co-sponsors, for listening to the call of Pacific Island students fighting climate change, I Am Climate Justice, and the World Youth for Climate Justice, which are now all working together, who first took it to the Pacific Islands Forum. And Vanuatu picked up the baton, but then said, we need other countries to come with us. So there are other Pacific Island countries alongside. New Zealand is one that's joined. I'm very happy that my government has joined as one of the 18 co-sponsors of the resolution that's now in the UN General Assembly, which will be the authoritative body to take the question to the International Court of Justice. And not only to take the question to the International Court of Justice, but once the court gives its decision, then there'll be the implementation. And so we've got I think, the most important political body of the United Nations. Some say it's the Security Council. I don't agree. Security Council is only 15 countries. I think the most important political body of the United Nations is the UN General Assembly, because that's every country is a member, every country has a vote, every country has a responsibility to act, and every country in there has a responsibility to implement the resolutions that are adopted. It's the UN General Assembly that's been tasked with this resolution, the draft resolution that's there at the moment, to take the question to the court, and then the court will then deliberate over this, and we have a responsibility as civil society to be very actively engaged in the deliberations and make sure that the best scientific evidence, the best stories, the best examples of the climate impact is taken into the court, so the judges will have the capacity to be able to make the best decision possible. And I have confidence they will. Then after that, the General Assembly, along with civil society, will then have to implement it. And I have confidence that because I have been involved in a similar case in the past, back in 1994, 1995, I was leading the initiative in the UN General Assembly to take the issue of nuclear weapons to the International Court of Justice. We succeeded, despite the political power of the nuclear weapon states. We got the case into the court, and we managed to get scientific evidence, people's stories into the court in order to get a really good decision from the court. And that's been really important at helping to ensure that we haven't had nuclear weapons used in armed conflict, and also that there is some progress towards eliminating nuclear weapons. So seeing that possibility, from our campaign back in 94, 95, and 96 was when the decision came down from the court, I'm really confident that this is going to succeed on the climate change issue and make a real difference. So that's why I'm fully supportive. That's why I'm really inspired by Nicole and the other young people from World Youth for Climate Justice who are leading this initiative, which is excellent, but also that it's done in cooperation with legal experts, with political experts who have been through this in the past, who sort of know how the court works, who know how the United Nations works. It's a really fantastic team effort. So I'm really excited about this. It's something which is needed, it's something which is going to make a difference, and it's something which is happening. So thank you so much to Nicole and the young people for getting this up and going. We're totally behind you and looking forward to a wonderful campaign that will make a difference and help protect the climate and the planet for future generations. Thank you, and back to you, Nicole.
Thank you so much, Alan. I could not have not said any better than how you put it. Thank you so much. And like what David said, it really takes a village to put all this together. And I'm still overwhelmed and in fact a bit surprised how far how far we've come already. We've got 105, in fact, counting and counting countries who are now co-sponsoring the ICJ-AO resolution. And when we say that we stand on the shoulders, like the youth are standing on the shoulders who came before us, courageous leaders, you are definitely one of those. When we started this, I had no idea how the international community, the system worked, and you were very patient in explaining how things went, and you gave us a crash course into how we could do this whole campaign and start. So thank you very much for your support. It's indeed invaluable. And I hope we made you proud now that we're taking on this campaign. And so now I'd also like to give the floor to two young people, my colleagues, my friends, who are leaders in this as well. I'd like to introduce Mamita Dasgupta, a young lawyer affiliated with the Supreme Court of Bangladesh, and she's also working as a research fellow for the Center for Climate Justice and Bangladesh. So she will speak about the importance of the ICJAO campaign, of course, in the perspective of a young leader and a young lawyer. Mamita?
Thank you. Actually, I'm now in trouble with my technical matters, but I'm trying to sort out this. Thank you for considering me as a speaker. And the ICJ opinion, we all know about this. 18 nations led by Vanuatu formally published final draft resolution for ICJ advisory opinion, which is now open for co-sponsorship. And it is going to be the Agenda 70 of the 77th session of UN General Assembly. This draft has published with two main questions, and these questions are covered the interstate and interstate obligations of the states relating to climate change and climate systems. And both of the questions have parts to cover the present and future generations specifically. And these questions are specifically concerned about the greenhouse gas emissions and adverse impacts on present and future generation both. So impacts on present generation are already there in evidences. It is foreseeable, and it is apprehended that it will be increased in future. So it's the time to take steps. And if we see the recent cases, Sachi versus Argentina, it was a case placed in the Committee on the Rights of the Children. And though there was the petitions were rejected by the committee for failure to exhaust domestic remedies, these petitions has some excellent findouts. And 16 children against filed these petitions against Argentina, Brazil, France, Germany, and Turkey. They claimed violation of rights by failing to sufficiently address the climate crisis. And it was filed 2019 and decided 2021. The court found that they have not exhausted the domestic remedies, but the court has also found that they have enough grounds to file these petitions. So the court found that extraterritorial jurisdiction was there, and they have positive interpretation, positive findings regarding interpretation of control and significance of directness and foreseeability. Court found that the impacts were foreseeable and the extraterritorial impacts are also foreseeable and can be controlled. So there was sufficiently proved violation of rights. And potential harm of the states' acts or omissions regarding their carbon emissions was reasonably foreseeable. Victim status was justified by establishing that they have personally experienced significant harm. So this case was failed due to not exhausting domestic remedies. Similar other cases can be succeeded if the domestic remedies are exhausted, is similar procedures are adequate procedures are followed. And so it is very important, and ICJ advisory opinion is very important for this type of cases. And the matter of present and future generation, specifically future generation. Who are the future generation? Who are adolescent today? Who are children today? Who are not born today? Or who are going to be born within 50 or 100 years? As we are thinking about carbon emission line, carbon emission border 1.5 degree within 2100. So there are matters to be discussed about the persons yet to be born. And generally, we see the rights for the persons existing or at best persons who are in their mother's womb, but not the persons who are yet to be born. But it is in this case, the different court opinions, different court findings are supporting the rights of future generations who are yet to be born. So these are very much different, and these are very much exciting for a lawyer that the person who are not born yet have some rights to be defended legally and to be defended in the courts. And this person is being represented by the persons existing today, who are adolescent today, who are children today, and who are young people today. So by saying this, I am stopping here, and I hope the best for the campaign. Thank you.
Thank you so much, Mamita. I see that Attorney Aposa is here. I would just like to say a quick hi to Attorney Aposa. Thank you for joining us here today. And before I ask you to take the floor, I would just introduce Aditi first. Our next speaker. Aditi is a researcher of the British Institute of International and Comparative Law. Her research is focused on climate change litigation involving businesses and the integration of climate change laws with human rights laws. So Aditi is also the academic task force and legal advocacy coordinator for World's Youth for Climate Justice and the executive assistant for the Climate Change Law Specialist Group of the IUCN. Hello, Aditi.
Hi, can you hear me?
Yes.
Oh, that's great. My video was working some time ago, but I think it's, on my screen, I can see that it's disabled, but, oh, that's great. Thank you so much, Paul. Yeah, so thank you so much, Nicole, for organizing this amazing conference. And of course, David and Alan for such kind words. And we greatly appreciate all your support. And I don't think we also couldn't have been here without any of you, not just both of you, but even everyone else who have been supporting us for so long. Following all the points that are rightly highlighted by my fellow panelists, I think we cannot dismiss the importance of the involvement of youth, but not only from the Pacific, rightly so, but also from across the world, as Professor Foreman actually highlighted some time ago. While I was actually asked to talk about the meaningful participation of the youth, I also thought that I could highlight the impact that WICJ as a network, as an NGO now, have created in the last 2 years through this through our participation into this AO journey. So even before we were officially registered as an NGO, we had a vision of mobilizing states from all continents. We therefore had these regional fronts in Asia, Europe, and Pacific to legitimize the movement. And we used to build capacity and in these regions, but at the same time, we simultaneously managed to band 16 students from across 8 universities to produce a legal report called Human Rights in the Face of Climate Justice. This was a comprehensive legal report and something that we did not know each other, and we still managed to draft around 190-page report. So I think that was a first, one of our first steps that built as established us in the eyes of a lot of academics as a foundation. So the report was first launched in 2021 at the High Level Political Forum. And now we also have the second edition of the report, which includes all the latest developments until November of 2022. As I mentioned earlier, the initial launch snowballed our movement. We got traction from civil society and academics and lawyers. And this was something that paved our way immediately into COP26, so you could actually meet negotiators, diplomats from states to put forth what our demand was and also explain why we need state support for such an advisory opinion. Regardless of the outcomes, political outcomes of COP26, WICJ was established as a movement, like a proper movement in the eyes of many states and countries, which I think was an important step for us, a stepping stone rather, a milestone rather. And since then, we, as World's Youth for Climate Justice, have expanded into Latin America, South Asia, Southeast Asia, Africa, and we have Pacific and Europe, with our partner organizations, the PIF, CCC, as also mentioned earlier. We have been successful in mobilizing civil society youth from multiple countries in all these regions, and they have been pushing their governments to support Vanuatu's resolution and to support efforts in adopting this resolution that Vanuatu has put forth at the United Nations General Assembly. We have also managed to equip, maybe in a very tiny number, but at least we've managed to equip students and youth to engage in meaningful campaigning at an international level, while we also continue to raise the profile of such demand of an advisory opinion. We have diversified our activities not only in capacity building, but we also involve students in written contributions like legal symposiums, blogs, articles, and many more. And we've partnered with NGOs that work for rights of nature and also for ecocide law. So that's how we've been trying to expand our reach as much as possible. This in turn has given us some nice fruits, and we have now, our work is now proliferated into many circles, along with academia, lawyers, and even now governments. Most of our activities that we organize and will always organize are in consideration of maximum participation of the youth, because we do understand the importance of leaving behind a livable future. As highlighted by Professor Allen, like we know, we can see the realities of, we can see in front of our eyes the realities of what is happening across the world. And that is why we think it is important to equip the young people with these kind of tools. As you all know, and I say this with immense pleasure, that these efforts, we can see these efforts now materializing. And as of today, we have 115 states that are co-sponsoring Vanuatu's resolution at the United Nations General Assembly. And while we understand this is just the beginning and building on this impact, and also continuing meaningful participation, I'm also happy to announce our next collaborative effort, which will be a document that will be launched on 13th of April after the United Nations General Assembly vote. The document is a handbook, which is authored by the Legal Advocacy / Academic Task Force of World Youth for Climate Justice, PIFCCC, in partnership with the 7th Center for Climate Change Law, Columbia Law School, and a public international lawyer, as many of you may know, Edgardo Sobins. The working title of the handbook is Youth Climate Justice Handbook, and it is a comprehensive document explaining the existing and relevant laws and legislations that govern the climate change regime internationally. The purpose of the handbook is to provide wholesome information to states, lawyers, academics, as well as youth and, of course, civil society. The handbook will consist of 3 documents. First will be a policymaker summary, which is authored by Dr. Justin Rose and a few of our members from WICJ's academic task force. The second document will be a legal memorandum, which will be authored by Edgardo Sobins. And the third document will be a legal status report authored by the 7th Center in support of WICJ's academic task force yet again. Along while we anticipate the launch and while we are hoping it is successful, our aim is that this sends a ripple effect across states and countries, and they decide to be supporting parties before the International Court of Justice. Among many others, we see these efforts as meaningful participation of the youth in this political journey for climate justice through the AO. And I understand that we are on a time, so I'm going to conclude very quickly and say that we at World Youth for Climate Justice sincerely hope that these efforts are not only meaningful contributions, but they also actually turn into legacy contributions for our children and for the generations to come. Over back to you, Nicole. Thank you so much.
Thank you so much, Aditi. Beautifully said. Thank you both to you and Mamita. It's always inspiring to see young people leading the conversation. And I always say we're not experts yet, but I know I consider you both experts, considering how the amount of time and energy you've spent on this. So I'm very happy that you were able to join us. And of course, Sir Tony Aposa, the man behind the doctrine of intergenerational responsibility, my personal mentor, and has inspired for sure so many of us here. He has graciously joined the opening session, and I know we're running out of time, but I would just really like to give the floor to him because he's such an inspiring person, and without his work is basically a pillar for the works of Special Rapporteur David Boyd and the right to a healthy and sustainable environment, and even the concept of rights of future generations started because of Aposa versus Factoran. And I would just like to give him the floor to inspire everyone as well. Attorney Aposa.
Yeah. Hello, good afternoon. Congratulations to Nicole, to Paulo, and to the Youth for Climate Justice Group. And hello to friend Alin, to friend, I see Aya, and I see Matthew there. And it is amazing that what was once a simple dream is now happening. And congratulations to all of you, and also to Margareta. Is Margareta there? Is Margareta there? Yeah, it was Margareta, we were in kissing. And this was just a simple dream that we had. And now it is so amazing that it is finally in the UN General Assembly with more than 105 co-sponsors. I just heard last night from Nicole that the Philippines has finally co-sponsored. I see Asia We there, and Asia was with us and with David Foreman, Alin, and some friends, Nick, Victor Tafur, and Nick Robinson. We were all there when we had a ceremonial filing in the Philippine mission in 2019, and now it is real. Now, what is the value of an ICJ advisory opinion? First of all, it is non-binding, it is non-enforceable. But what is the value? The value is that it will clarify the duties of states as good fathers of the families of humankind. It is known as the bonus pater familia, the of humankind, to clarify what are the duties of states as good fathers of the family of humankind to care for present and future generations of human life. Not only of human life, but to other forms of life on earth. And more important, it is also very inspiring for others, not only for the states, but also for ordinary citizens to take action to remember that this is not just for states, but for states to come up with policy and for people to begin taking action on themselves to lead. I do not want to call it fight against climate change. We will turn climate change into a climate of change. And on April 19, David Foreman is going to be there. Nicole will be there. We will launch, last October, we launched the Good Stories movement in the Philippine mission of the United Nations. And on April 19, we will hold the same event. We will look for good stories of people who are doing good things for the environment, especially to change climate change into a climate of change. And remember, my friends, that inspiration, when a person is inspired, you do not have to tell him or her what to do. He or she will do what is needed to do, because inspiration is the highest and most powerful form of leadership. Good luck and congratulations to all of you, and good luck. Okay.
Thank you very much, Tony. I'm so happy to see you, and I'm sure everyone here is also very happy to see you. Thank you for being an inspiration to everyone. And I think that sums up our opening session. Thank you everyone for staying in. And I would just like to, again, remind you that the interpretation button is working. So just in case you need that, we have simultaneous translations. And before we move on to our regional sessions, again, I'd just like to emphasize why we're doing this in the first place, why we're covering 6 regions. It's because we want to emphasize and discuss clearly the nexus between the connection between climate change and human rights, and how best to contextualize that and discuss the issues within the regional context and what an advisory opinion can do to address that. Because coming from someone who didn't know, I mean, I'm a lawyer now, but I didn't know anything about the advisory opinion or how the international law worked. So for me, it was really helpful that the likes of Alan and David taught me and explained to me how these things work and how it could be used as a tool, and international law in general could be used as a tool to address these issues. And I feel like there's a need to emphasize and contextualize the issues, because we're dealing with different issues from different regions. So it's best to discuss that fully and exhaustively. That's why we have these different regional sessions. And now, thank you everyone. I think we can now proceed to the first session, which is South Asia. And I'm very happy to have our moderators for this session, Para Bukas and the Asian Research Institute for Environmental Law, who are also our partners for this event. And without them, we won't have this conference. So thank you very much. And I hope you'll have a very fruitful and productive session. I'll give the floor to our session moderators.
Hello, good afternoon, everyone, and welcome to the first session of our 12-hour interregional dialogue. So our first session is all about the importance of an ICJ advisory opinion on Southeast Asian environmental law and local communities. So this session is brought to you by Para Bukas, a women-led Asia-based environmental consultancy firm working on legal and policy issues related to climate change, the environment, and sustainable development. Its mission is to bridge the disconnect between law and policy and environment and development, a gap that is particularly sharp in the context of environmental law and domestic practice and implementation. We are also in partnership with the Asian Research Institute for Environmental Law, a law institute focused on providing practical solutions to environmental law problems. Ariel adopts a multidisciplinary approach to solving environmental issues, emphasizing ecologically sound measures and participatory methods. Its mission is to transform the environmental and social governance landscape of the ASEAN region by creating a new paradigm of environmental justice, firmly anchored in environmental rule of law. I am your host today, Sofia Caralde from Para Bukas, and I am very excited to be here with you and, of course, our very inspiring and well-rounded panelists. But before we start, I would like to greet every woman in this virtual platform a very happy Women's Month. Today's session takes inspiration from the world's youth who have been passionately campaigning for climate action and human rights to protect the rights of current and future generations from the adverse impacts of climate change. So without further ado, let me call on Attorney Cecilia Therese-Kiao, Para Bukas Operations Director and co-founder, to give her opening remarks.
Thank you, Sophia, and good afternoon, everyone. Thank you so much for joining us in this historic time of youth action to bring climate justice to the International Court of Justice, or the ICJ. In the Philippines, at the national level, the Commission on Human Rights has finally released the report on its landmark national inquiry on climate change. The CHR found legal grounds to hold fossil fuel companies, or the carbon majors, accountable for all acts to obfuscate climate science to the prejudice of the right of the public to make informed decisions and ultimately delayed meaningful environmental climate action. This landmark petition was the second attempt to frame climate change as a human rights issue and the first to be accepted by a national human rights institution for investigation. This is a clear manifestation and a definitive finding of the link between the climate crisis and human rights. In the Southeast Asian region, the Association of Southeast Asian Nations, or ASEAN, has begun its preparations for a regional environmental rights framework that could possibly be adopted by 2024. Now, in the international arena, the world's youths are bringing the issues of climate change and human rights to the ICJ, the principal judicial organ of the United Nations. While the ICJ has no binding authority, one of its main functions is to provide legal advice through advisory opinions, which could have a persuasive effect on courts at all levels. Para Bukas supports the WYCJ's campaign and believes that an ICJ advisory opinion could bolster the Philippine Commission on Human Rights resolution on the National Inquiry on Climate Change and Human Rights, as well as other initiatives in the Southeast Asian region to recognize the climate change and human rights nexus and to enforce rights arising from it. We hope that our session can give you a better idea as to the significance of an ICJ advisory opinion to Southeast Asia, and to help us find opportunities to support each other as we move forward in this campaign. Thank you very much, and I wish everyone a pleasant day.
Thank you so much, Attorney Niner, for that wonderful and very insightful opening remarks. So to continue our session and to give us an overview of climate change and human rights in Southeast Asia, please welcome Matthew Baird, the Director of Asian Research Institute for Environmental Law. Hello, Matthew.
Hi, Sophia. Thank you very much. And it's great to be here. And I echo both the early introduction to acknowledge International Women's Day that happened on Wednesday. And also, hopefully that Paolo will be able to put in the chat box a link to the Seeds of Justice webcast that Ariel organized with some amazing women, including from Asia, from Parabukas, on the role of women in environmental law in Southeast Asia. And I echo Attorney Niner's observations and also the introductory observations. This is really quite an extraordinary time. It's a great opportunity. It's where youth voices have come together with country aspirations to produce the resolution that hopefully now with 115 sponsors will go up to the United Nations General Assembly. And yes, it will take a certain bit of time before the International Court of Justice looks at some of those elements within the resolution. But at the same time, as Sir Tony said, you know, one of the extraordinary things about an advisory opinion and why it's relevant is it will help provide opportunities for governments to then look at what they must do or what further steps they must take. But more importantly, one of the things is about the legal consequences for those states who have failed by their acts and emissions or who have caused significant harm to the environment as a result of their activities and contributing to climate change. And I think that issue about loss and damage and a bit about liability is very, very important. So without further ado, I'm wanting just to give a little bit of an overview in terms of the way I'm framing this sort of human rights in the face of climate change within Southeast Asia. And so one of the things that we have to realize, of course, is that climate change is not just the sole risk. You know, we talk about the triple planetary crisis of climate change, pollution, and biodiversity collapse, as these are the three sort of key elements that are all coming together in what is now coming to be seen very clearly as a major existential challenge for us all. Climate change is this sort of force multiplier for potential adverse environmental and human rights impacts. And so for me, this liability for climate change impacts is going to be the key part of the advisory opinion. You know, part of the opinion also identifies that the $100 billion, the amount of money that was identified at the Paris Agreement and before that needed to be spent on dealing with the adverse impacts of environmental issues and climate change issue and biodiversity issues, that has not been funded. That money has not been found. We still are able to give billions and billions, hundreds of billions of dollars to the fossil fuel industry as subsidies, but we can't spend the money on actually protecting the environment and stopping what we know is going to happen with respect to climate change. And we've also seen, and this is some of the great work that has been done by the World Youth for Climate Justice and other organizations, declarations of climate emergencies throughout the world, recognizing that these impacts of climate change are real and are happening now. And this perhaps for me, you know, is this idea that when the IPCC, the Intergovernmental Panel on Climate Change, issued their interim report, that there was likely significant consequences of exceeding this 2.5 degrees Celsius target to, you know, we're not even saying we're going to keep our climate temperature the same, but the temperature is going to increase. But the cause, it's clearly anthropogenic. In other words, humanity is causing this, especially through our addiction to fossil fuels, to coal and to gas. And more importantly, that it was likely that this exceedance over this 1.5 degrees or 2 degrees would be happening. Indeed, now we know that we are likely to go over the Paris Agreement mandated target of 2.5 degrees with major consequences to the environment and to the health of our ecosystems and to ourselves. And this is from The Economist, which is a conservative economics magazine that focuses on economic practice. But it talked about no safe place, the 3 degrees future. And this was looking at the date from July 2021. And so this report from the IPCC, which is the scientists coming together with the policymakers, identified where there were increase in hot extremes, the most significant extremes of temperature. And we can see from this chart since 1950, almost every single area, including Southeast Asia and East Asia, is predicted to increase with a high degree of confidence. But in addition to this high increase in extreme weather events is also the increase in heavy precipitation, heavy rain events. And that leads to this dreadful bringing together of both increased floods, but also increased droughts and increased extreme heat events, all of which, especially in our region that we know of, will cause more and more significant environmental particular impacts. But within ASEAN, we are in a really interesting situation as to what we can do going forward, using some of the language, some of the methods, some of the ideas behind this advisory opinion. The ASEAN Charter includes a requirement that one of its purposes is to promote sustainable development so as to protect the region's environment, the sustainability of its natural resources, and the high quality of life for its people. In addition, we also have the ASEAN Human Rights Declaration that has celebrated its 10th anniversary last year in Cambodia. And within Article 5, that it was restated by the heads of government of ASEAN, that every person has the right to an effective remedy to be determined by a court or other competent authority for acts violating the rights guaranteed to that person by the constitutional law. And that's important because that's also a national right, not just the right that states have to go before the International Court of Justice, but the idea that we should be able to do these at national levels. And I think as was mentioned, the idea that the Philippines Human Rights Commission has identified some of the issues that the carbon majors have caused and the liabilities may also give us the opportunity of using this Human Rights Declaration to take action against some of those polluters in national courts. The other important thing in ASEAN is that the ASEAN Human Rights Declaration, well before the UN resolution, the General Assembly resolution, recognized the right to a safe, clean and sustainable environment. In Article 28F, there was a right under the ASEAN Human Rights Declaration for every person to an adequate standard of living for himself and herself and his or her family, including the right to a safe, clean and sustainable environment. So within ASEAN, we really do have this recognition that there was, and it has been in existence now for 10 years, the right to a safe, clean and sustainable environment. And as we can also see over the last number of years, especially in the last few years, we've seen some really important events and documents come out where youth voices are finally being heard in ASEAN. 2 years ago, we had the children's rights to a safe, clean, healthy and sustainable environment in the ASEAN region, which had principles and policy guidance. In addition, the UN ESCAP has been, and other organizations have been supporting climate justice for children, youth, and future generations. The idea that youth voices are now finally being heard by decision makers. And that, I think, is a really important opportunity for us in ASEAN to keep lobbying governments and the UN and other international bodies on the importance of ensuring that youth voices, children's voices are heard and acted upon and part within the decision-making process. So I just quickly wanted to sort of outline some of those key issues about human rights and climate change. And one of the things is that we have to remember that the obligations are of states for human rights compliance. It's one of those things that even with the development of the business human rights guidance and many other, the framework on human rights and the environment, they all identify the obligation of states for human rights compliance. Now, I'm an environmental lawyer and I love suing corporates. I love also suing governments to ensure environmental law, legal compliance, because often there are clear requirements under environmental law that could perhaps be used to introduce some human rights issues in those legal challenges. We also have to then identify how we can develop the liability for corporations who emit greenhouse gases and contribute to the impacts of climate change. And I think this is where the ICJ opinion, advisory opinion, looking at that question of liability is very important, although it relates to states. And one of the things that the Philippines National Human Rights Commission, which is then being talked about in other human rights commissions within the ASEAN region, is the idea of the liability of corporations, maybe not on an individual basis, but certainly as part of a class action about those who are continuing to emit greenhouse gas emissions. In South Asia, I've mentioned that we will see increasing impacts of flooding as well as significant extreme heat event. The consequence of that are things that we already see: storm events, typhoons, the loss of food security, but more importantly, this increasing challenge to resource allocations. An issue about disaster risk management that is going to be more and more relevant as these disasters and natural disasters become more prevalent, but also the impacts increase. In addition, we are seeing now with ocean acidification and still the ongoing development of our coast and coastal zone, we're seeing loss of coral reefs, seagrasses, mangroves, and fishing stocks. All of these are impacting on the ideas of oceans equity, the need for our billion people who rely on around the world, who rely on the sea for their livelihood. And within Southeast Asia in particular, and within certainly many of the islands in Indonesia and the Philippines, we are going to see a significant challenge to those sustainable livelihoods. We also see the dangerous impacts for Indigenous people protecting lands and biodiversity. We see in countries like Thailand, when national parks are being challenged because of encroachment, and that forest dwellers who have protected those lands and protected the biodiversity are seen as being those that need to be removed. So this is a real challenge for Indigenous peoples who have protected the land and who have made sure that those areas are still functioning with their biodiversity intact, while other areas outside their lands have been destroyed for profit. These are going to be dangerous times for Indigenous people because there are still people who want to despoil the environment for profit. We also see a growing challenges for environmental and human rights defenders, not only in Southeast Asia, but also in the Pacific. Those people who are trying to protect their communities, their subsistence, their environment, are now being targeted even more by those seeking to exploit and destroy. So one of the things we need to do is to make those human rights obligations binding on the corporate sector. And I think we can use environmental law breaches to raise these human rights impacts. Once there's been a breach of a license, either for an environmental impact assessment or a development or pollution, then we can raise the human rights impacts. For example, the impact on air pollution that prevents people from access to right to health or being able to go to education. But more importantly, if there are issues that are done that take away affect people's livelihoods and securities, fishing stocks and others, these can also be raised in environmental law cases, of which there are many great environmental lawyers in the Philippines, to raise those human rights impacts as a consequence of those environmental law breaches. Tragically, countries, and I refer to Australia, but also Indonesia and other countries, are still funding coal and gas developments for energy. And this is something that will need to stop. The transition has to be advanced. And that's also not only because of climate change impacts, but because of the extraordinary consequences of air pollution. And we're seeing massive air pollution impacts throughout Southeast Asia. Now that COVID is sort of receding in some ways, we're now realizing that the air pollution issues are one of the most significant human rights issues that we are facing now. And finally, that idea about liability and payments for adaptation and mitigation, payments for natural disasters need to be by polluters and countries that have supported and promoted fossil fuels. And that will need to be clarified. Certainly this ICJ opinion is that first step to clarify the obligations of the states. But those ideas that companies, the private sector that has profited, and governments that have failed to act since, the Framework Convention on Climate Change, for example, in 1992, and respond to that, are those countries and those companies that should be held liable for damages and for payments to fund natural disaster rehabilitation and response, and to fund adaptation for communities. And so one of the things that I also wanted to share with you today is something that is quite exciting within the ASEAN region. And that is that the ASEAN Intergovernmental Commission on Human Rights has been leading the dialogue since 2014 on human rights and the environment. And it convened a meeting in 2014 on human rights and climate change and the impact of climate change on human rights. And that has led to a number of discussions and raising the idea that human rights and climate change are intertwined. But we can now see that over those last 9 years, those issues of biodiversity collapse and pollution, air pollution in particular, but water pollution as well, and waste management like plastic pollution, have all identified that these are huge environmental consequences that have significant human rights implications. So one of the things that the Asian Research Institute has been working with AICHA over a number of years, and now working with UN Environment Programme and UN ESCAP, UNICEF and UN Human Rights, is working on the idea of this Framework Declaration on Environmental Rights. And just last week, at the 36th meeting of the ASEAN Intergovernmental Commission of Human Rights in Indonesia, the AICHA Commission endorsed the formation of the Terms of Reference and the working group to start the process of consultation on a Framework Declaration on Environmental Rights for ASEAN. A number of reports have been written. So looking at things that have happened in the Escazú Agreement, for example, in Latin America and the Caribbean, and earlier on in 1992, 30 years ago, the Aarhus Declaration of the Economic Commission for Europe. And these are some of the key elements that we'll be looking at, and this will be part of an extensive period of discussion and debate. In the Philippines, I understand the Human Rights Commission has already convened an initial working group. I was addressing in Thailand, the Thai Human Rights Commission with the framework body on environmental NGOs on lessons that could be learned from Latin America and the Caribbean, the Escazú Agreement and the Aarhus Convention for ASEAN, which obviously needs to be an ASEAN type of framework that has to be in accord with the ASEAN way. And there are a number of issues, one of which are the procedural, access to justice, access to environmental information, public participation, free prior informed consent for Indigenous, special attention to women, children and vulnerable groups, and key supporting rights for environmental and human rights defenders. But one of the other things is the idea of picking up on this ASEAN Human Rights Declaration to look at substantive rights in terms of the safe, clean, healthy and sustainable environment, supporting environmental law principles of the precautionary principle, the polluter pays principle, supporting and enhancing environmental impact assessment, which is a huge issue within the region, but also protecting the environment, including biodiversity, terrestrial ecosystems, oceans and fisheries. So We know we have the emergency. We know we need to act. There are so many people who come together to ensure that our actions can lead to lasting change. And one of the things that I would like to leave us on when considering, the environment, human rights, climate change issues, reflecting on that the opportunity to develop a framework agreement on the environment over the next 2 years is, what do we want to do, and what do we want to ask our friends and colleagues and associates? Do we want business as usual? Well, unsustainable, unethical, and ecological collapse. Do we want to try harder? Well, is that more of the same? Is there going to be any real change? Is it really just insufficient? Or is it time, as our youth have been telling us, that enough is enough, that we have to be ambitious, we have to regain our compassion for humanity and the environment, and we have to focus on our ecological renewal. It's no longer business as usual. It's no longer to just try harder. We now have to say, enough is enough. Our future is ours. Let us now take control of that future. It's a great opportunity to be here. I thank all the organisers. I thank the youth for making sure that soon the General Assembly will be having to decide on its advisory opinion and the recommendation from Vanuatu and the 115 governments. Thank you very much indeed, and good luck for the rest of the symposium.
Thank you so much, Matthew. And I like what you said, that it's the youth's voices are finally getting heard at the international arena. And I like what you said about how different countries here in ASEAN are doing something to address climate change, or to at least link climate change and human rights. And as we can see in ASEAN declarations, there is a substantial amount of basis that could amount to this. And it's just, I think it's more of a push to everyone to lobby and to continue making our demands known to this national institution, because we have the basis already. It's just we need to work more on these issues. And thank you so much, Matthew, for that very informative talk. And I know my fellow law students here on our Zoom call is also interested in how litigation is working with regards to environmental law, and considering a lot of forums of law, considering that carbon majors are not usually residing in one state. And then we are also talking about enforcing state obligations and making them accountable for their failure to act on climate change, and even if they have contributed to worsening impacts of climate change. So thank you for that, Matthew. And so allow me, excuse me. Okay, allow me to introduce our esteemed speakers now for our panel discussion. I will be introducing all of them now to ensure that the discussion flows smoothly. So let me call on Attorney Asia Wee. Asia is a young lawyer and a legal fellow of Environmental Legal Assistance Center in Palawan. So ELAC help communities defend the earth through legal empowerment and strategic litigation. Asia is also a member of the Asia Pacific Youth Advisory Group on Environmental and Climate Justice. The Youth Advisory Group aims to unite the experienced and dedicated young people working on environmental and climate justice in Asia Pacific region. They work towards strengthening the environmental rule of law by promoting the work of environmental defenders and climate activists through greater protection, visibility, and legal empowerment. Let us all welcome Asia Wee. Hello, Asia. Next is Mr. Ramon San Pascual. So Sir Mon is the Executive Director of Healthcare Without Harm, Asia, an international NGO that seeks to transform healthcare worldwide so that it reduces its environmental footprint, becomes a community anchor for sustainability, and leader in the global movement for environmental health and justice. Having worked with an extensive network of parliamentarians, health professionals, and community and civil society leaders, Sir Mon has helped form and strengthen coalitions of advocates upholding health and social justice in the Philippines and across Asia and Pacific region. Hello, Sir Mon. Next up is Ms. Marleya Muñez. So Ms. Marleya is an independent nonprofit organizational management professional facilitator and trainer on gender and human rights, climate change, and forestry. Ms. Marlea was appointed as a director and executive director at the Department of Environment and Natural Resources here in the Philippines, as well as the National Commission on Indigenous Peoples. And she had the opportunity to work with environmental science for social change. She also works with several NGOs as a volunteer and technical service provider. Ms. Marlea is a member of the Women's Initiative for Society, Culture, and the Environment, otherwise known as WISE. She is currently working on Web Info Act, which aims to capacitate Indigenous women leaders of communities with rich natural resources. Hello, Ms. Marlea. Lastly, on the list, we have Dr. Antonio Lavinia. So Dr. Lavinia is a leader, teacher, thinker, lawyer, and a social entrepreneur. He's currently the executive director of Manila Observatory and a professor of law, philosophy, political science, and governance at several universities here in the Philippines, including the Ateneo Loyola Schools and Ateneo Law School. He has been a human rights and environmental justice lawyer for 30 years, starting his law career as an advocate for Indigenous peoples and local communities, fighting development aggression by logging and mining companies, and in some cases by government, pursuing environmentally destructive projects. He has also been a senior environmental government official, formerly a lead negotiator of the Philippines on climate change and biodiversity conventions. He has worked on environment, development, and governance for several domestic and international organizations. Please welcome Dr. Lavinia. Hello, Dean Tony. And then I would also like to introduce to you Ms. Patricia Nicdao from Para Bukas, who will be moderating our panel discussion.
Thank you so much, Sophia, for introducing our esteemed panelists. Once again, to the audience, I'm Pat Nicdao, and I'll be facilitating the discussion this afternoon, of course, with the panelists. It's truly an experience to be with inspiring and passionate advocates, and of course, to be able to hear their insights on important campaigns for the current and future generations. I'm sure everyone's excited to hear from our panelists, so I will move on with the discussion. First, to Attorney Asia. May we have Asia here on the spotlight? All right. Hi, Asia. We learned that you had been one of the active volunteers during the early days of this campaign to seek an advisory opinion from the ICJ on climate change and human rights. So, what moved you to support this campaign? How long have you been involved in this campaign? And what are the unique strengths in the youth that enable them to lead this campaign?
Okay. Thank you so much, Pat. So yeah, I am Asia from Asia. So I was involved in around 2018, 2019. So I got in touch with Nicole and Sir Tony that time. I was a law student back then. So at that time, I was thinking, before I met them, I was thinking of climate change as in the perspective of a traveler. So I was thinking, oh no, if climate change, the effects of climate change happens, what will happen to the reefs that I go to when I snorkel? What will happen to the nice beaches and islands that I go to camp, or the mountains that I camp? So it was like that. And then I got in touch with Nicole and Sir Tony that time. And then I got more into the legal aspect and the global, the gravity of it globally. So I just wanted to know more. So when there's an opportunity, I volunteer. Whenever there are gatherings, I try my best to attend. And then at one point they said they want to go to New York for a legal mischief. And I was like, okay, what legal mischief? But it's gonna be a nice trip for sure. So I said, okay, I wanna join. I wanna meet other young people who are in this fight. And then when I got the experience there was super nice. So I got to meet a lot of familiar faces here. David, Aline, and the others I saw earlier. Yeah, and then so locally we are also trying to organize I Am Climate Justice. So it's a more Philippine youth um, initiative for local mobilizations on the ground. And then at that time, since I was super involved, I noticed that us young people, we have so much energy. So it's the energy can finish a lot of things in a short amount of time for as long as we're very interested and into it. So I think that's very important and unique about young people because yeah, the energy is with us and we also have a lot of time. I remember when I joined them in New York, I was a law student then. So I was more than willing to skip 1 month of law school to join this very interesting campaign. Yeah, but for all the law students out there, don't it's not very advisable. Yeah.
So, Asia, what do you think are the unique strengths of the youth aside from having a lot of energy and passion to enabled you guys to lead this campaign?
Yeah. Aside from that, I think our generation now, with the presence of the internet, with our access to information, although not 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 everyone, but a lot, especially in the middle class, um, we we are able to educate ourselves for as long as we're interested, and then partnered with that energy and time, we are able to reach or do a lot of things and approach things very creatively. So the old formulas doesn't apply anymore because we are able to think of new ways to approach problems, and it's just very fresh and fun. uh yeah, I think it's very important that the youth energy is like fun and not very depressing.
That's very inspiring that you have been active in this ever since you were in law school. And we all know how difficult the law school journey is. And of course, guided by many environmental mentors here in the Philippines. Indeed, ang mga kabataan or young people are full of energy, are innovative, and very passionate about these social issues. So as a young environmental lawyer, for you, what is the importance of an ICJ advisory opinion on climate change and human rights to the communities that you work with?
Okay. At first glance, when I was initially asked to answer this question, I thought the advisory opinion is so up there, while local communities are like it's so far from them. It's not within arm's reach, to put it simply. However, I think it will be relevant, especially if we do our part, no, of doing our part in working with local communities, empowering them, and then finding ways on how this instrument can be used as a tool to fight for their rights, to seek for accountability, to make their governments serve their interests in relation to the climate crisis right now. So I guess for those who are law students here specifically, probably that will be my challenge to you when you pass the bar eventually. That yes, climate change is very important. International negotiations are very important, but I think it's also like equally important to touch bases with those on the ground because it is their lives who are the most at stake. It's their livelihood, it's their security to water, to food. There's so many things at stake. And I think after the international exposure at that time, I was led to that reflection that there was so much youth energy for climate change internationally and also in the schools. But then how about the local communities who are actually affected by the impacts of climate change? Who is there to work with them, to make use of the available tools right now legally for them to assert their rights. And it is in this part that the advisory opinion would be nice, because it's going to be an additional tool. Like, for example, if there's another coal plant somewhere that's going to open up, it opens, it's another tool for a lot of things like climate mitigation, and then building your arguments. I'm sorry, I'm too fast. Oh,
Go on, Asia.
oh yeah. And okay, Sophie is asking me to shout out to Ateneo Law. There.
All right. So I totally agree. It's true that the term ICJ advisory opinion and even international negotiations can be daunting at first, especially for people without legal background. Even the issue of climate change and environmental justice can be daunting at first sight, but these discussions and negotiations are very crucial for people, especially the youth worldwide. So thank you so much, Asia, for sharing your experience and story to everyone in this Zoom webinar. We will go back to you later in the open forum. I'm sure the audience have so many questions about your experience joining in these international negotiations. Thank you so much, Asia. Next, we have Sir Mon from Healthcare Without Harm.
Hello. Hi, Pat. Good to see you again.
It's good to see you again, Sir Mon. It's been so long.
Yeah.
So, Sir Mon, you've worked extensively with parliamentarians here in the Philippines and, of course, worldwide, healthcare professionals, and local communities on climate change and social justice. So, what are some examples of climate change interconnectedness, or what they call nexus, and human rights, particularly to our right to health?
Yeah, and let me focus on health as that's where we are working on. In 2015, it was said that the crisis on climate is also a crisis of public health. And therefore, if we consider the worsening climate condition as a human rights violation in itself, and what therefore is being violated in terms of health. So let me reiterate that health is a fundamental human right, indispensable for the exercise of other human rights. Every human being, each of us, is entitled to enjoyment of the highest attainable standard of health conducive to living in a life of dignity. When we fought for reproductive health law in the Philippines across more than a decade of the struggle, we had to bring out to light that reproductive health is an essential reproductive right, particularly among women. That is the right to choose, the right to decide on their bodies. But now that I'm into healthcare without harm, working in the Southeast Asia, we view health now in a broader light and how it is related to climate change and how it becomes a human right issue as well. Now, what is an example of rights to health? It includes access to adequate healthcare facilities and services, and therefore it is also a measure of equity. And it also relates to the social determinants of health, which includes access to food, water and sanitation, safe and health working condition, housing, and that being free from poverty. Now, in healthcare without harm, we believe that the healthcare sector has an important role to play in all of this. Come to think of this, in as much as the healing mission of healthcare professionals is a duty that for which they took their oath, and yet the healthcare sector in itself is responsible for a carbon footprint equivalent to 4.4% of the global net emissions. That is such that if it is a country, the healthcare sector in itself is the fifth largest emitter on the planet. So that provides a very profound contradiction. Whereas you provide healing, but you also do harm. And this is, we take the full responsibility in Healthcare Without Harm over this fact when we came out with that research in 2019, the carbon footprint of healthcare. And then the following 2 years in 2021, we released the how to journey towards low carbon healthcare. Now, we are convinced that it is only through the power of collective action that we will achieve change. And therefore, we work across the globe, across Southeast Asia, on innovative solutions and initiatives to collectively seek and reduce the environmental of healthcare delivery. In this instance, environmental health and climate change are two connected issues that are impacting on health. And therefore, we want to elevate the voice of the sector on the health impacts of climate change and air pollution. Now, a very recent incident, and for which we are still dealing with in the Philippines, is the oil spill in Mindoro. Now, recently, as the cleanup goes on, there are already reports coming from communities and the affected population of reports about experiences of nausea, headaches, and other ill effects of that oil spill. To the most common, ordinary fisher folks, their families, that had nothing to do with that barge of oil that spilled onto their waters. There are also questions of what is the impact of plastic packaging on our own health as we consume the very food that comes out of that plastic package. There's also an established study on the health impact of air pollution, which also directly related to fossil fuel. And therefore, in every time that whether an industry, a policy of the government would propel further change of the climate, whether by providing privileged kind of financial support to the oil industry, or whether it is by minimizing or by not changing and not revisiting the air pollution quality standards in a country, then there's a violation that is ongoing that impacts on health. And this is where we appreciate the work of the young people to bring this to the table and put it onto the table of the ICJ, to which we think this will be very beneficial even to our own work the moment it happens, and for which we support you fully. Thank you.
Thank you, Sir Mon. It's very disheartening hearing and seeing the news lately, especially with what happened in Mindoro. And Asia also commented that it has reached the coast of Palawan. So a lot of people and communities are really affected by this. And I agree, Sir Mon, that the healthcare sector has a huge responsibility in our fight against climate crisis. And I specifically like the line that you said, that the crisis on climate is a crisis on public health, and vice versa, of course. We see how plastic pollution, fossil fuel extraction, or even oil spills that happen in Mindoro, and POPs, or toxic chemicals, negatively impacts public health, especially of the marginal sector, children, women, and like the agriculture sector. So, Sir Mon, as a healthcare advocate, how do you think this ICJ advisory opinion can support your work here in Asia?
Towards the end of last year, Healthcare Without Harm released a document on what how we view the whole question of just transition. As we now advocate for the big emitters to begin seeing their own guilt and their own responsibility and accountability with all the adverse impact of global warming, particularly to countries like the Philippines. Now, in that just transition, we would want to bring about that. We aim to bring about a social, environmentally responsible change as a transitioning to low carbon economy. That would mean as well impacting workers and communities that may be adversely affected by the transition, ensuring that they have the necessary resources and support to adapt to these changes. It would provide us a better handle, whether it is a legal or moral or that human right angle, to begin asking hard questions. And this we do in a lot of ways in our own battle with the on plastics. We don't view plastics as an issue alone of disposal, of simply making better our waste management system, whether in the hospitals or in the community. We think that the whole issue of plastic is a question of production and a question that is right in front of the gates of the big companies that are earning big money out of simply dispensing whatever products in small plastic packages, yung mga what we call as tingi-tingi. So if at all we will be able to gain a huge or small victory over these various struggles that all would point out to the responsibility of the industry on fossil fuel extraction, that's where the just transition do come in. And if we have this handle of a legal acknowledgement that there is someone has to pay for all the human rights violation in that human-induced climate change that is taking place quick and really felt by communities, just like the oil spill that we're talking about in the past days, then we appreciate ICJ making that opinion favoring communities. Thank you.
Thank you so much for your dedication to this fight, Chairman. Of course, to the entire Healthcare Without Harm Asia. I'm sure you've inspired everyone here in the Zoom webinar to join the campaign for a socially responsible change towards a low carbon economy, and of course, our push for corporate responsibility, or the polluters pay principle. Thank you so much, Sir Mon, and we'll continue the discussion later at the open forum. Next, to our panelist, Ms. Marleya. We're excited to hear about your insights on this issue, especially coming from the community and indigenous sector experience. Ms. Marleya, there has been significant research on the disproportionate impact of climate change on women and girls. So can you share examples that you've observed from your work, and have any interventions, policies, or programs been made to address these impacts?
Hi, I'd like to start with I'm inspired because we are talking to the youth, and we were once in that stage of our lives. But of course, we are still here not to pass the torch, as I said, but we will continue to light torches for people to walk along with us in this advocacy for the climate and for the peoples. I'd like to focus on basic examples that are anchored on the human rights, social, economic, cultural, civil, and political rights. So what are the impacts that I have seen from the communities where I have been working with or cooperating with, especially with women leaders, IT women leaders? For the social aspect of our rights, aside from the health that was already discussed by Sir Mon, I'd like to add that we have increasing situations of lack of access to education and right information. Why? Why is this related to climate change? Because they are intertwined with these two rights, no, are intertwined with what they have on the economic side that will enable them to actually access education and right information. The climate has changed the seasons of planting and fishing, and our communities are catching up with methodologies and measures on how to deal with these changes. So if they used to plant at a particular time, just like what happened to the onions issue, right? So there was a delay because of the changes in the seasons. And apart from that, there are activities that are happening promoted by government. For instance, there are communities in Palawan, for example, that are subjected to mining operations. When you have your ancestral domain being operated on by mining companies, they collect certain mineral resources. They promise not to touch the rest of the resource, but of course that's not true. They cut the trees and they bother the soil. So what happens? The topsoil, which is actually very thin, where our indigenous communities are dependent on, are actually flushed down to the downstream. So what happens? You have less productivity. If you have less productivity, you have less income. If you have less income, you have less access. So that's how it is related. So the changes in season and aggravated by the responsible giving of permits to companies that are not responsible in addressing their methodologies or their procedures in doing their projects. So in terms of cultural, some areas have actually been affected, especially the sacred places. So if you have changes in terms of the when the water would come, the level of rain, the level of heat, then the landscape as well is affected. So if the landscape is affected, the way people behave in terms of where they should shift from one place to another would be affected. Again, it's connected to their productivity, it's connected to their time. How much time do they consume? If they move to another place, which is farther than the places they used to go for their economic benefits, then that means they will have lesser time for their families and for their communities. Then if they have lesser time for their families and communities, then their other rights in terms of being able to participate in community activities like decision making, like being part of planning activities in the municipalities will never be given opportunities because they are out in the field. How can they go to municipalities or in city halls for land use planning if they're out in the field? How can they be consulted for investment planning if they're out in the field? Okay, so that's part of their civil and political rights as well. They cannot be and they will never be heard or listened to. In terms of impact on, I would like to add on the social aspect because the women leaders and the young women in the communities are wanting of enabling conditions and enabling measures for them to actually lead. Why? Because most of the communities are led by men. I have nothing against men, but the training or the capacity building are focused only to men. So what happens when there are changes in seasons that I mentioned? People will move from one area of activity to another. The sharing of activities will be affected. The women will be left to activities that they're not used to, they are not trained to, and the men will be out there to seek for other sources of living or income. So there will be a gap in terms of economic situations of their families and then their communities. So the relationships will also be affected because, as they said, love is not enough. When economic issues come into the family situations, love goes out of the window. But that's just to simplify things. The biggest situation or the biggest problem that we have now for young women and women leaders in the communities, they are not given the opportunities equitably to lead, to address what's happening in their respective land or ancestral domains, to actually have a say in land allocation and land uses, because the changing climate would require them to also move from one traditional way of doing things to another. And they are not able to do that. There are no enabling conditions.
That's very well said, Miss Marleya. I felt it, and it's nice to hear stories from the ground how climate change really is a human rights issue. So, Miss Marleya, how could the ICJ advisory opinion on climate change and human rights support the women and girls in the indigenous and local communities that you have worked with?
First, I'd like to state that instead of the government to provide interventions for young women and women leaders to be capacitated to lead and make changes or make significant contributions to the communities, the government is actually leading some projects that are giving more burden to young women and our women leaders. Therefore, if we have an advisory opinion from ICJ that will connect, as simply as I've said, the human rights and climate change, and will make sure, or I will not make sure, but will in fact encourage or urge our government to go by the law on indigenous people's rights. I think this is the only human rights law that we have directly for indigenous peoples, and yet it's not being followed in a sense to be biased for them, but it's being used to actually suppress them. So the Philippine Commission on Human Rights can be part of the core team. I should call them a core team to make sure that the Philippine Commission on Women, the National Youth Commission, the Center or the Council for the Welfare of Children will come together. They're all under the office of the president, except for the Commission on Human Rights. And then they get advice, the technical advice from the DENR, the Department of Environment and Natural Resources, from the Department of Agriculture, and then operationally, they work with the local government units. I don't know if that's difficult. It's not difficult. It's a matter of people really knowing what they do, right? The communities, the IPs have their ancestral domain sustainable development plan, protection development plan. If they don't have those, then the government should have them come up with a plan instead of pressuring them to accept projects that are not consistent with their vision. I don't think there is a cultural community that has a vision that the forest in their ancestral domains will be replaced by a mining operation. But since the government has delegated the basic services to these companies like education, food, and all that, then they have no choice. But what if the government should really do their job? You don't need those companies to provide for education. You don't need those companies for the roads. You don't need those companies for the seeds, right? So let's do our job. And I'm really inspired because I saw Attorney Aposa, the father of Mandanas. I think we should remind the government that the government is just the agent of the state. The state is the government, the people, and our territory. Let's work around that. Let them work for the people, especially for the young women and for the women in the communities. This is a cliche, but I think this is still true. If you work with women, they bring along their families, they bring along their communities, change, positive change will happen. That's all.
Thank you so much, Miss Marleya. And again, happy Women's Month to you and everyone in this webinar, in Zoom webinar. It's true that in 2023, the government, local and international governments should do their work and they should do better. Local communities, especially indigenous communities, have been exhausting all means to protect the environment. And all stakeholders should step up and do their job, especially those with most power and with most resources. Again, thank you so much, Ms. Marleya. We will have an open forum later. Actually, for the audience who are tuned in now, we have a question and answer box that you can put in your questions. So later, after the panel discussion, we can our panelists can address and respond to your questions. So last in our panelist is Dr. Lavinia. I'm sure a lot of people here already know Dr. Lavinia. Dr. Lavinia, we believe that you are teaching environmental law in various law schools here in the country. Do you think that environmental law and policy in Southeast Asia adequately recognizes climate change as a human rights issue? Are there any new developments or efforts in the laws and policies in the region that can strengthen the climate change human rights nexus?
There's still a lot of work to do. Obviously, it's better than when I started doing this 30 years ago. One of the first environmental law in several schools in the Philippines and part of a cohort of
Dr. Lavinia?
Southeast Asian lawyers that began special law. It's a challenge in Southeast Asia of our governments or authoritarians. So there, can you hear me? Sorry, am I lagging?
Yes, okay na pa.
Sige.
All right.
But we're getting progress because in our region and in Asia in general, we have been at the international level pushing climate justice and the human rights link. And so we're able to show that domestically, we have to do the same thing. In the Philippines, it's easier because we have at least a legal culture that recognizes human rights, recognizes indigenous people's rights, recognizes people participation in environmental law. And so when we teach environmental law, we do emphasize the fact that this is not about nature alone or about the atmosphere alone, but above all, this is about people, and that it's a justice issue. My own work, myself, nowadays, I have been focusing on the ground work in Mindanao with indigenous peoples. I got involved with defending the Lumad schools in UP, in Cebu, and in Davao that the Duterte government tried to close down. And in the process of pushing back and defending them, I realized that this is a climate justice issue. The Lumad schools were created by communities because their old schools were destroyed by climate events. And the struggle or the issues they're faced with, the development aggression issues they're faced with, are all also pose threats to climate. And so, both the forest programs that they have to, or the forest activities they have to fight, or the extractive industries that that are being pushed on them. So the explicit connection between climate, environment, and human rights is very obvious in the Philippines, and I would say also in this region in Indonesia, in Malaysia, in Myanmar, in Cambodia, and so that way, at least in the universities, there is a recognition that human rights law and environmental law are intimately intertwined.
And Dr. Levine, why do you think an advisory opinion from the International Court of Justice is crucial in creating the legal nexus between climate change and human rights? How will its non-binding nature affect its potential influence on laws and policies?
That's a good question. And the first thing first, it doesn't matter whether it's binding or non-binding at this stage, because we are still, in terms of international law, the foundational stage, especially in jurisprudence, because we don't have a much of international jurisprudence. We have country jurisprudence already in several countries, but we don't have the international jurisprudence. An advisory opinion is the first step that you do that. The most famous advisory opinion in the last, let's say, 40 years was in the case of U.S. versus Nicaragua, which the U.S. lost and the Nicaraguans won. That did not stop the U.S. from, sabotaging the Nicaraguan revolution, but it gave the Nicaraguans, in their foreign policy and their engagement with other countries, sure footing that they were in the right place. So an advisory opinion would have that effect of basically telling developing countries, the youth in the most vulnerable countries like in island states, that the world recognizes that legally you have this right, and therefore you have to act as if you have this right, and then seek to change the behavior of the bigger actors that do not recognize this right. And believe it or not, eventually they come around. I'll give you an example, Pat. The United Nations Declaration on the Rights of Indigenous Peoples was negotiated for a while in the UN. And it was finally adopted. Some of the biggest countries in the world, the United States, Canada, a few other countries actually refuse. Our colleagues in Indonesia, a good example, I worked with a lot of them through the years. In the early years, they wouldn't recognize indigenous peoples' rights. They would actually say there are no indigenous peoples in Indonesia, which of course is factually not true, anthropologically not true. But all that has changed in the last 20 years. When advisory opinions, when declarations are done, these are all soft law. These are not binding law. But as I teach this subject in several schools this semester alone, 2 or 3 schools, and 2 in Mindanao, 1 here in Manila. And I teach public international, and we actually take up this advisory opinion and how should it be decided. And it's very clear that the liability based on environmental and human rights grounds, developed countries and other countries that continue to behave as if there was no climate crisis is very obvious and self-evident, actually.
Thank you so much, Dr. Lavinia, for sharing your decades worth of insights and experience in international and national law. And of course, you're truly an inspiration to us all here from the panelists and of course the audience. It's true that we have a lot of things to do, and I'm sure we from the youth sector is ready to take on the challenge. We've heard from the previous panelists about the challenges and experience from the ground. So it's really great to hear positive news at the very least that there are there have been great strides in the movement in the legal aspects, especially with the passing of the UN DRIP and even the UN DROP in 2018, which was also, I believe, campaigned by organizations in Indonesia. Thank you so much, Dean Tony. So that ends our panel discussion, but we still have an open forum where we can ask questions and all of the panelists can address the questions from the audience. Time truly flies fast when you are enjoying what you're doing. So for sure, our audience also enjoyed listening to the different perspectives and approaches of our panelists to climate change and human rights, that they are already burning with questions and not fossil fuels. The floor is now open to questions from esteemed speakers. So again, if you have questions, you can raise your virtual hand and organizers will acknowledge you. And I believe you can turn on your speakers and ask your questions directly to our panelists. Or if you're feeling shy, or if you can't turn on your videos, you can also drop in your questions in the question and answer box. And I can read your questions out loud. So are there? I'm sorry, I don't see the audience. So if anyone is, organizers, just let me know if anyone is raising their hand. But actually, someone already sent in some of their questions through a private message in our Zoom. So maybe I'll read it first if anyone is still like needs time to think of their question. So to anyone in the panelists, the first question from the audience is, what are the implications of an ICG's AO to South Asian countries most vulnerable to climate change negotiation position in loss and damage? I think I need to say it again. It's quite wordy. So what are the implications of an ICG's AO to Southeast Asian countries most vulnerable to climate change negotiation position in loss and damage? So anyone from the panelists, if anyone wants to answer it?
See, I can start.
Yeah, Attorney Asia.
Okay. I'll give the Philippines as an example, no, since we're very vulnerable also. The advisory opinion, like I said earlier, will be a tool, and advocates and people on the ground can use it to lobby with their governments to do certain things. Like, for example, since there's a clear, if it gets answered the way we want it to, if there's a clear obligation between the state to protect its citizen in light of the climate crisis, then maybe it will be a tool for us to lobby with our government to more proactively negotiate or lobby in the international scene. Because the past how many years, the Philippines is not very, it's not at its best when it comes to international negotiations on climate change. So that's my brief answer to that.
Thank you, Attorney Asia. I believe you were able to answer that perfectly and concisely. Anyone from the panelists would like to add? There are actually 2 more questions privately sent to us from the audience. This is the next question is also in line with the first question. Anyone from the panel, what do you think the ICJ should carefully consider in its crafting of an advisory opinion of the obligations of states in respect of climate change? So I guess, yes, Terman.
Yeah, let me go back to the earlier question.
All right.
Because right after the very good development on loss and damage fund in the last COP, health NGOs came out with a statement that says in part that limiting warning to 1.5 degrees is essential to avert catastrophic health impacts of climate change, but still it will require phasing out all fossil fuels. And therefore, only full fossil fuel phase out will deliver the maximum health benefits from clean air and clean, healthy, and sustainable environment. And even if we welcome the loss and damage fund, the real path to delivering relief to countries bearing the brunt of climate crisis is to phase out fossil fuel.
I agree, Sir Mon. Loss and damage is one crucial aspect to our fight against climate change and, of course, climate justice. But at the end of the day, if you really want to stop the issue, is to go from the very source, which is to stop fossil fuel. Absolutely stop fossil fuel. Thank you, Sir Mon, for that answer. And on the second question that I said earlier, I feel like it would be good for Miss Marleya coming from the IT and women's sector to answer it, of what you think the ICJ should carefully consider in its crafting of an advisory opinion on the obligations of state in respect of climate change, maybe coming from more of the social and cultural aspect that should be added to it.
Yeah. First, I think we should take note that the Philippines is not part of that resolution asking for the ICJ advisory opinion. So, and the current trade condition of the Philippines is that the government is not so keen about engaging on UN-related changes in its policies and programs. So that's our context. So therefore, the ICJ should consider that particular unique situation of the Philippines. Aside from the fact that it should stop the positive thing of having ICRA, of having Magna Carta of women, of having the responsible mining in the mining industry, looking at the free and prior informed consent process and processes, because this has developed into various forms that I could no longer recognize. So they should come as a tool, but beyond that, as practical as possible, that can be understood and can be practically used. How? If that document comes to me as a trainer, and if it is so easy for me to explain that to the community can actually make that as a reference in their community resolutions, it will pass the test of being simple and being significantly contributing to what they're doing in the communities. If not, then it will just be up in the air. So it will my message is that it can only be useful if it is understood, it is practical, and it can be used under the current frame conditions of the Philippines. Because we cannot wait. We cannot wait. Right.
I agree, Ms. Marleya, that we shouldn't forget who we're doing this for, the very people we're doing this for. And Attorney Asia also mentioned this earlier, that these negotiations and papers can be very daunting and highfalutin to people. So it's very important that the advisories and everything that we write and make are still relevant and understandable to the very people we are doing this for. Thank you so much, Ms. Marleya. And for the last question, maybe to Dr. Lavinia. Do you foresee any challenges at this point in successfully campaigning to request the ICJ for an advisory opinion?
Right now, there doesn't seem to be any major challenge other than sort of legal or doctrinal in nature. There doesn't seem to be a strong political challenge, for example. So this should be doable. I think we should prepare for a time when the ICJ will actually call for hearings and hear people give the theory for why certain rulings, certain doctrines can be laid down here to guide people. So the challenge here is really more whether the ICJ see the utility of an advisory opinion. And I think that's a case that should be easy to make. We tend sometimes to when we work in this area, we tend to be impatient, tend to be frustrated, and there's a reason for that. On the other hand, just these few months, we made a very big step internationally, negotiating a new treaty on marine biodiversity in the high seas. No, I've been following that. If you asked me 10 years ago, I would say impossible. But look, they agreed on a treaty, including the United States agreed on a treaty. And of course, different ratification has to be done. So those who say that international law is dead, international law in the environment is dead, well, I would say, as both a practitioner, an advocate, and also a teacher, that you're actually wrong. And there's a lot of things that we can still do to move forward. Thank you.
All right, sorry, I was on mute. Thank you so much, Dr. Lavinia. Indeed, international law and environmental law are very much alive and are making great contributions to our fight against climate change. That's the end of our open forum. Thank you so much to our esteemed panels for your valuable insights on the importance of the ICJ advisory opinion on climate change and human rights, and the remarkable role of the youth in this campaign. Once again, thank you so much to all of our panelists and Matthew for your opening message earlier. All right. To formally end the program, I would like to call on Attorney Alaya De Leon to give us the closing remarks.
Okay. Hi, thank you, Pat, for the introduction, and I echo the gratitude that has been expressed for our speaker and our panelists. It's been very inspiring, very educational, and also a really good mix of insights and points of view that really round out our understanding of the issue of the importance of the ICJ advisory opinion in various levels and various contexts. And we really thank our panel, Aisha, Sermon, Marleya, and Dean Tony, and also, of course, our very active audience for taking the time and joining us in our efforts in anticipation and in support of the UN General Assembly's vote requesting the advisory opinion on climate change from the ICJ. So we're very optimistic and hopeful that this will push through. Just to quickly, we are almost at time, but I think I can try to run through some of the synthesis points, which it's been a very, very rich discussion, but I'll try my best to pick out some of the highlights. We've heard from our speakers that it is really an extraordinary time when the world's youth are taking the lead in these efforts to ensure climate justice. We have all felt their energy and their passion, and they are an inspiration to, they are really an inspiration to all of us, and especially I just want to also give a quick shout out to the team from Para Bukas and also our other youth colleagues from Ariel that have really worked to make this whole webinar and this panel discussion possible. We are no longer youth. We used to be youth, and now we have more and more younger people are joining the cause, and we are so inspired and energized by their active participation and engagement and leadership, of course. And we have seen how the youth bring a lot to the table with their creative approaches and technological know-how. I think it's really important. We also heard that the climate crisis is linked to many other crises in social justice and human rights. Many of these issues are very clearly interlinked. We heard many clear, concrete examples from Sermon and Marleya on the interconnection between the drivers of climate change and how these impact social, economic, and cultural rights, impact health, safe food, livelihoods, land tenure, and the practice of traditions. So the intersectionality of all these issues with climate change and rights is very clear, very stark. And we have many people working on these issues, but there's no question that we have to address these issues in an interlinked and interconnected way. The speakers also emphasized that women must be given opportunities to participate in all efforts across the board, policies, programs, and other interventions to address climate change and more broadly, ensure sustainable and equitable land and natural resource use and management. And of course, we always acknowledge the importance of the role of women, even more so this month, today and this month, where we are celebrating Women's Month. And coming to the ICJ advisory opinion and why it is important. Why are we honing in on the advisory opinion? In this webinar and in many other initiatives of the World's Youth for Climate Justice, for example, our speakers have pointed out that the advisory opinion is relevant to communities across Southeast Asia because it can be used as a basis to demand more accountability from governments, particularly mandated agencies, and also the private sector. And as a tool, I think we heard that term used a few times, it can be a tool to advocate, to empower stakeholders on the ground, and also as an advocacy tool for just transition, for example, so that climate solutions leave no one behind. It can also frame hard questions around how many of today's crises are interconnected and who should be held accountable. So the word accountability really is one of the most important aspects of this advisory opinion. And of course, the clear obligation of countries that we want to see come out of this opinion can be used by advocates to lobby more effectively. And we heard from Dean Tony that even if it is not binding, the advisory opinion, it will still be a valuable basis for international jurisprudence to develop and for behavior from bigger actors for change. So even if it is not something legally binding in the, let's say, traditional sense, it is still very persuasive and can still motivate changes in bigger actors, such as the carbon majors, and also as a basis for international jurisprudence. And just to the some points from the open forum, what are the important points for the ICJ to consider? Sir Mon pointed out the importance really of phasing out all fossil fuels, that this really is non-negotiable if we want to achieve our 1.5 degree target of limiting global warming and achieving climate, health, and sustainability goals, and also to fully realize the potential of the movement around loss and damage today or recently. Without this phasing out of all fossil fuels, these other goals will really not be fully achieved. And we also heard from Marleya that the ICJ should approach this opinion in the most practical and accessible way that can be understood not only by countries, but also by communities. Only if it is understood and can be explained and used that it will really be an effective tool and effective advocacy instrument at the national and local levels. And lastly, on the challenges that we might anticipate or encounter, we heard from Dean Tony that any challenges may be legal and doctrinal in nature, But in terms of the politics, there doesn't seem to be any strong political challenge. So he leaves us with a very optimistic message, I think, optimistic tone that it should be doable to have this opinion. And in terms of the utility of the opinion, the ICJ is also likely to find the utility in issuing this opinion. And in terms of what we can do in the meantime, stakeholders, advocates, we need to be prepared for when the ICJ calls for hearings, meaning we also have to be able to present the facts, present the evidence, so that there will be no question about what the findings should be in terms of obligations and accountability of those who are causing the continued warming of the planet. And also that international environmental law still has a big role to play in moving things forward. So I hope that does justice to the many, many important and unique points made. And thank you again to our speakers. I will turn it back to Pat for the final message. Thank you.
Thank you so much, Aya, for synthesizing all our takeaways from this session. And it was really a lot. It was a long discussion. At this point, on behalf of Parabukas, the Asian Research Institute for Environmental Law, and the World's Youth for Climate Justice, we would like to thank our speakers, Mr. Matthew Baird, and our panelists, Attorney H.O.V., Ms. Marlea Muñez, Mr. Ramon San Pascual, and Dr. Tony Lavinia for joining us and imparting valuable lessons to us. We would also like to thank you, our audience, who took the time to listen and participate in our session. Again, thank you, everyone, and have a good day ahead. Thank you so much, everyone.
Salamat, everyone. Thank you.
Thank you. Bye.
A very good morning, good afternoon, and good evening to all of you who have joined us today for the 12-hour interregional dialogue, Human Rights in the Face of Climate Crisis, a youth-led initiative to bring climate justice to the International Court of Justice. This is session 2 on the Asia and Pacific region. We will discuss on the nexus between human rights and climate change and pay attention to the key issues on climate change in the Asian and Pacific nations and the role of advisory opinion. This session is moderated by the World's Youth for Climate Justice, and I'm your host, Dulki from Sri Lanka. Before starting our session, I have to share the amazing news that 10 additional countries have co-sponsored the initiative, resulting in a revolutionary number of 115 countries supporting the request for an advisory opinion on climate justice from the International Court of Justice. The voting at the United Nations General Assembly will take place at the end of March, and co-sponsorship is still open. Please call on your governments to support and vote yes to the ICJ Advisory Opinion Resolution. A kind reminder that interpretations in French is available. We have 4 distinguished speakers who graciously accepted our invitation to speak in this regional session. And also the Q&A session will be open for after each speaker. So please keep your questions ready or type them in the Q&A box. I would first like to invite our first speaker of the session, Professor Dr. Kokila Konesinghe. She's a professor in law and the acting head of the Department of Public and International Law of the Faculty of Law, and also the coordinator of the MPhil and PhD programs in the Faculty of Law, University of Colombo, Sri Lanka. She's the founding director of the Center for Environmental Law and Policy of the University of Colombo. She's a member of the Commonwealth Futures Climate Research Cohort 2021 and 2022 of the Association of Commonwealth Universities and has represented Sri Lankan official delegation at the United Nations Climate Change COP27 in Egypt. She's also the first advisor of the WICJ Asian Front. Her book chapters and research articles have appeared in locally and internationally reputed journals and publications. She won the University of Colombo Senate Award for Research Excellence for Legal Studies in 2020. Professor Konesinghe, thank you so much for joining us today, and the floor is yours, ma'am.
Thank you so much, Dulki and the organizers. May I kindly request to make my cameras available? Okay, right. Thank you so much. Ayubowan, and this is a very much privilege for an academic who is very passionate about environmental protection, particularly climate change, and from Sri Lanka, the Asian and South Asian region particularly, to speak and contribute at this World Youth for Climate Just Forum. And first of all, I must appreciate and give full credit to the youth who has engaged and organized, coordinated this much needed effort. And it is very special because it is particularly by the youth. So we talk about intergenerational equity, and we talk about present generation's responsibility towards future generation. So I think it is very, very ideal situation and a platform that I have been privileged to talk. So thank you very much for the organizers and Dulki from Center for Environmental Law and Policy from Faculty of Law, University of Colombo in Sri Lanka. So it is my utmost pleasure. And when I was invited, I thought that what should I share? So there were a couple of options for me, and I could share some of the updated information on Sri Lankan climate change context and the contributions we have made, or I could have shared some of my current research, which is particularly in climate change and rights of nature approach. But finally, I found a very fascinated area to share with all of you. Why I tell that it is very fascinated? Because in 1997, there was another advisory opinion given by International Court of Justice on threats and use of nuclear weapons. And in the panel of judges, there was a dissenting opinion expressed by one of the judges, who happened to be a Sri Lankan. And today, in 2023, this young group of activists in climate change, Voice for Climate Justice, we together voice and we together request for advisory opinion on an issue and an environmental challenge, just like in 1997, as a Sri Lankan myself contributing to it. So I thought it is a very interesting combination if I make a comparative analysis of 1997 advisory opinion on nuclear weapons and today advisory opinion on climate justice. So it's a nice combination. So I started my research on this and then I found many interesting reflections on this. Therefore, let me share my screen and discuss about how I would see this comparison and how I would recommend and give you some ideas to improve your dialogue towards requesting for advisory opinion by the International Court of Justice. May I have the sharing option, please?
Ma'am, it's it's already given to all panelists, ma'am.
Can you see the screen?
Yes, ma'am. We can see the screen.
Right. Thank you. Right. Now, you can see the picture of this Honorable Judge C.G. Veeramantri. I'm sure if there are law students here, this name is very familiar because in Hungary versus Slovakia case, the same judge gave a magnificent ideas on sustainable development, intergenerational equity, and precautionary principle, and many other international environmental law concepts and principles. So in this particular judgment, in this particular advisory opinion, Judge Veeramantri gave a dissenting opinion. And I kindly invite everyone to go through his dissenting opinion, which is
Professor. Okay. Ma'am? Ma'am, you're on mute.
Am I connected?
Yes, now
Yes.
connected, ma'am. So
apologies. What I was telling.
Could you please share the screen again?
Yes.
Thank you so much.
So in 1997, Judge Veeramantri mentioned, I quote, "My considerate opinion is that use of nuclear weapons is illegal in any circumstances whatsoever. In principle, it contradicts the fundamental principle of dignity and worth of human person on which all law depends. It endangers the human environment in a manner which threatens the entirety of life on the planet." I can't see any other similar way or any other better way to bring out our argument on climate justice. As climate justice today endangers human environment in a manner which threatens the entirety of life on the planet. So, in this particular advisory opinion on legality of threat or use of nuclear weapons, the General Assembly applied this application to under Article 296 of the Charter of the United Nations, just like the World Youth for Climate Justice is going to do from the International Court of Justice. And the International Court of Justice gave an advisory opinion. And lessons learned from this advisory opinion in 1997 for the advisory opinion that we all are going to apply for, that broader application of international environmental law was reflected in every judgment. And also application of customary international law define general norms of international law. Now, this particular definition on general norms of international law as well as application of customary international law is very important, because this particular argument on climate change has not established properly within the legal jurisprudence anywhere else. Therefore, it is very, very important that we get an advisory opinion, just like in 1997 nuclear weapons advisory opinion, on what is the application of international environmental law and customary international law. So that definition will give a heavy weight to our argument. And also future projections from this 1997 case, that the court held that this threat of use of weapons, nuclear weapons, would be lawful or unlawful in an extreme circumstances. Yeah. So in an extreme circumstances of self-defense. Now, Judge Veeramantri did not agree with this. He said under any circumstances, use of nuclear weapon should not be accepted. But the majority's opinion was under the self-defense, the use of nuclear weapons should be allowed. So that is why they have mentioned here would be lawful or unlawful in an extreme circumstance of self-defense. Now, there is an obligation to pursue good faith and to conclude negotiations leading to nuclear disarmament in all its aspects under strict and effective international control. Now, may I request all the young people, all the youth around the world who are joining here with us today to pay attention to the last paragraph of this slide. That is, in 1997, in the advisory opinion, the ICJ mentioned that they invited all the member states, state parties to the UN to take actions to conclude negotiations leading to nuclear disarmament. Now, we are also in the same position with the climate justice. So the negotiations and climate carbon emission standards are not being applied and take actions at the same level by all the nations. So there's this South-North dimension, South-South dimension, and there's a lot of debates between industrial countries and emerging economies. So therefore, I think it is very, very important to take a judgment as an advisory opinion by the ICJ, mentioning that all the state members have the responsibility and every state should act in good faith to conclude negotiations for a productive outcome. And these are some of the environmental law principles which were discussed in this case. And also these principles can be used by us in this particular advisory opinion on climate justice, intergenerational equity, common heritage principle, precautionary principle, and you can see all the principles that I have mentioned here, and also common but differentiated responsibilities principles. And let me elaborate on the advisory opinion on climate change. Now, just like in 1997, we have this the youth have now begun to ask for requests for advisory opinion by the ICJ. Now, the advisory opinion seeks to clarify the obligation of states to protect the rights of current and future generations from adverse effects of climate change. Now, this is very, very important because the debates and the disagreements and not taking responsibilities towards accomplishing the proper standards of carbon emission by certain standards who happen to be, unfortunately, the worst emitters in the world. Now, with this advisory opinion, I think there is a binding, not legally binding, but morally binding, and also before the international law, I think it's a kind of a naming and shaming process is there unless you comply with the necessary required carbon emission standards. So therefore, ICJ's judgment on as an advisory opinion, it will be very, very important and a significant contribution towards this particular case. And the objectives, as I identify, to clarify and define international environmental law principles, and secondly, to lead the nations to work out climate negotiations, just like Judge Veeramantri mentioned in 1997. So it is the duty and the responsibility, according to the principle 21 of the Stockholm Declaration, states have responsibilities as well as duties towards protecting the nature by their actions. Therefore, the states should work out climate negotiations productively and positively, and also to influence every member state to cooperate with global climate standards. So international law principles founded, I mentioned couple of principles that can be founded, and future projection, if I may elaborate. Now, the states should comply with the global standards and take the like they are within the available scientific facilities, the maximum cooperation should be extended by the states towards climate change and other global standards. Now, how can we make use of this advisory opinion? Now, this will be as I mentioned, that 1997 nuclear weapons advisory opinion and also climate justice opinion, this is a comparative analysis of the two cases. So I would invite all the audience to do this comparative analysis and get what there are many similarities in the both cases if you do the case study. So we can make use of many arguments and also many justifications and philosophical debates that were discussed in this nuclear weapons case. And Sri Lanka, as a climate vulnerable state, I think we look forward to have this advisory opinion, because we as a state have done enormous contribution towards the protection of nature and prevent climate change. So we have taken many precautionary actions, even though we are down the list of emitters, because we contributed to the climate carbon emission at a very minimal standard, but we contribute enormously as much as possible towards the protecting the earth from climate change. And also, this is maybe the only way forward for the protection of humanity for future generation. And also, I would like to mention rights of nature towards ensuring protection, conservation, and evolution of natural objects, not only human beings, but also natural objects. And also, human beings should act as custodians of nature. So this is an ideal situation as far as I see, that getting this advisory opinion and we act as custodians of the entire nature. And fairness and rationale, as well as non-discrimination and equality, are another principle that I would like to highlight in this case. Finally, let me conclude with Judge Veeramantri's statement, and let me quote: no one knows how widely such lethal radioactive particles may be diffused, but the best authorities are unanimous in saying that the war with H-bombs might possibly put an end to the human race. Now, while I'm reading out this, I also invite the audience to reflect on this and see the similarities that we can bring out these arguments with the climate change, because the whole world, entire world, is facing the same threat, even worse threat to nuclear weapons with the climate change today. Let me quote again: we appeal as human beings to human beings. Remember your humanity and forget the rest. If you can do so, the way lies upon to a new paradise. If you cannot, there lies before you the risk of universal death. So with paying gratitude to this Honorable Judge Veeramantri and his dissenting opinion in nuclear weapons case in 1997, let me conclude stating that the support and advice and guidance is given to this particular project gave me immense pleasure, and I will continue to do so, not because I am an advisor for the Asian region, but I am a human being who is living, and my final survival will be rely on this judgment and the way forward, as well as my kids and the future generation. Thank you so much. Ayubowan.
Thank you so much, ma'am. Thank you so much for sharing this wonderful presentation and your expertise. I am sure that all of the participants in this conference have learned a lot, not only on the advisory opinion on the climate justice that we are seeking, but also on the important advice, dissenting opinion by Justice Veeramantri in the advisory opinion on legality of the threat or use of nuclear weapons. Thank you so much, ma'am. I myself learned a lot, as always. I learn every day from you. So many thank you. And if there are any questions, then I would like for the participants to ask them. The floor is open for questions. Yes, I see Mr. Muhammad Imran has raised his hand. Sir?
May I?
Yes, please, sir.
Okay. Thank you, Professor Kokla. Muhammad Imran. I teach in Villa College, Maldives. I was a student of Stelina Jolie, ma'am, a year ago. Yes. So thank you for this interesting presentation, especially the comparative study between nuclear weapon case and then the climate issue. So do you think the way, ICJ, ICJ did not exactly clarify whether, use of nuclear weapon will be prohibited or not. But can we argue that the countries which are involved in high number of carbon emission are also creating some kind of threat the way, nuclear weapon creates, having just the idea that a country has a nuclear weapon itself a big threat, right? You don't have to say anything. Can we, like small island countries like Maldives, Sri Lanka and other, can they argue that these highly industrialized countries are also creating a threat to the small island countries just by, being who they are?
Yes,
That's
Imran, thank you so much. And it's pleasure to meet someone in the neighborhood. And yesterday we had our MPhil and PhD inauguration at the faculty, University of Colombo. And then we in fact met a couple of students from Maldives. So it is very pleasure to meet you. And I really agree with you. Actually, that is exactly why I use this comparison between 1997 and 2023. This whole debate, the political debate between North and the South, it is eternal and I don't think it will ever solve. So we have to deal with it. So how are we going to deal with that? Now in 1997, this case majority was with the opinion that they brought out this self-determination, self-defense argument. Lawful and unlawful depending on the special circumstances of this particular self-defense debate. And Judge Veeramantri opposed that. He dissented and then he said under any circumstances test of nuclear weapons should be not accepted. So the same argument actually in 2023 the World Youth for Climate Justice will have to face, because the world's most worst emitters are from industrial world. Some of the emerging economies like India and China also contribute in Brazil, South Africa, all the emerging economies. So how are we going to compromise this at the negotiation table? Because now polluter pays principle, common but differentiated principle, precautionary principle. Now look at these international environment law concepts and principles. They will define the parameters of state responsibility. And if you look at customary international law, Principle 21 of the Stockholm Declaration also provide states can take their own decisions according to their environmental policies and development policies, but they have state responsibilities not to cause harm to the neighboring states or beyond space. So this particular arguments can bring in. So I quite agree with you, Imran. Of course, the industrialist countries and the developed countries would not agree with this particular argument because they are the worst emitters. So you can see the number of developed countries who are in the Kyoto Protocol, who step out of the Kyoto Protocol and who are in the Paris Agreement and who are now almost getting out of the responsibility parameters. Now, many industrialist countries have not come up to the expectations. Of course, in EU, we can see some of the positive responses, but other than that, we can't see any sufficient contribution by the developed world. So again, in this particular case also, I'm anticipating that argument of getting out of the responsibility mechanism. So we have to anticipate that we have to better equipped with the philosophical arguments bring out by Judge Veeramantri in 1997. That is exactly why I want to show this youth that this judgment is. So please go through the dissenting opinion of Judge Veeramantri and see how you can defeat the argument, because anticipate that argument. The industrialist world will never give up bringing out that argument and stay out of the responsibility mechanisms. Yeah. Thank you, Imran.
Thank you.
Thank you so much, Professor. Thank you so much, Mr. Imran. If there are not any other questions, then Kokila ma'am requested me to release her at 4 and it's already 7 minutes late. So ma'am, thank you so much for joining us today. And we really hope that you will continue to guide us the World Youth for Climate Justice Asian Front and support us with all our future endeavors. And thank you so much, ma'am, for joining us. And thank you.
Thank you, Dulki. All the very best and Ayubowan.
Thank you. Okay, so we have our next speaker of the session, Mr. Alan Ware, who also speak in the opening session as well, and he has kindly stayed to speak in this session as well. He's a peace educator and international peace and disarmament campaigner, originally from New Zealand. He has lived in the United States and Switzerland and now resides in the Czech Republic. Mr. Ware is the co-founder and the global coordinator of Parliamentarians for Nuclear Non-Proliferation and Disarmament USA Peace and Disarmament Programs Director for the World Future Council Germany and Director of the Basel Peace Office Switzerland and International Representative of Aotearoa Lawyers for Peace, the New Zealand affiliate of the International Association of Lawyers Against Nuclear Arms. He previously served as Executive Director of the Lawyers Committee on Nuclear Policy. Mr. Ware founded and directed the Mobile Peace Van and co-founded a number of other peace education initiatives, including Our Planet in Every Classroom, the Cool Schools Peer Mediation Program, the UN Decade for a Culture of Peace Schools Outreach Program, and the Global Campaign for Peace Education. He was a member of the Department of Education Advisory Group that developed the New Zealand guidelines for integrating peace studies into the national school curriculum. Mr. Ware was one of the leaders of the successful campaigns to prohibit nuclear weapons for New Zealand in the 1980s and to achieve a ruling from the International Court of Justice on the legality of the threat or use of nuclear weapons in 1996. He has co-founded a number of international peace projects and networks, including Abolition 2000, Middle Powers Initiative, Move the Nuclear Weapons Money, Unfold Zero, and No Fistues Global. He has won several peace awards, including the Right Livelihood Award, Alliance for Nuclear Accountability Award, World Peace Award, United Nations International Year for Peace Award, and Winston Churchill Memorial Trust Award, and has also been nominated a number of times for the Nobel Peace Prize. Sir, I welcome you to speak in the session too, and it's a pleasure and it's our honor to meet you and listen to you today.
Thank you very much. It was lovely to also see on screen photos of my dear friend, Judge Weeramantri, that Professor Kunasingi was introducing, who indeed was an incredible lawyer, a judge, humanitarian, visionary mind, and an inspiration to me. In fact, my first career wasn't in law, it was as a teacher. And I got inspired to get into law because of one of the cases that Professor Kunasinga mentioned, the nuclear test case in the Pacific. So I'm from Aotearoa, New Zealand. That's where I'm calling from today. And in our region, the nuclear weapons development involved the big powers, the United States, France, the United Kingdom, testing the weapons. By testing, it means they detonated them. And so they were exploding them in order to create bigger, more accurate nuclear weapons for the nuclear arms race. And that testing, even though it was conducted miles from populated areas, the contamination from the radiation from those nuclear tests has caused devastating health impacts, particularly on women and children in the Pacific, and continues to do so because the radiation lasts for generations, and the genetic damage it does in our bodies is passed through generations. So the nuclear weapons, it's not just if they are used in a war, it's the very production and the testing of them is already impacting on future generations and is violating the rights, the right to life, the right to health, the right to a clean environment of many people. And in the Pacific, we've felt that very strongly. And when I saw the impact of the nuclear test case in 1975, I was staggered. Until then, I hadn't even known there was an International Court of Justice. And then my country, New Zealand, along with Australia and Fiji, took France to the International Court of Justice over the nuclear testing in Mururoa. By that time, the United States and the United Kingdom had already finished the nuclear testing in the Pacific, but France was still doing it. And the interesting thing was, even though France declared, well, we're not going to accept, what comes out of the court, we're a free country, they stopped the atmospheric testing the very next day. And to me, wow, I found this is really intriguing. Here we have a court that not everyone subscribes to. It's not compulsory jurisdiction for everyone in the world, like, the courts in our countries are, and yet it can still have an effect on what the countries are doing. So I then started looking at, well, law seems to have a lot more impact than I realized, including in the international realm. And I saw other cases, Nicaragua taking the United States to the court in 1982 over the United States support for the Contras. So the United States was supporting armed mercenaries, basically, who were fighting in the Nicaraguan government. And again, Nicaragua won the case against the United States, and that civil war ended very soon after. The military aid that the US was giving dried up. The US Congress adopted law saying you can't do that to the president. And then Oscar Arias, the president of Costa Rica, used that decision of the International Court of Justice, the Nicaragua versus US one, to build the framework, the legal and political framework for the Central American Peace Accords, which basically ended all the civil wars in Central America. Now, interesting thing is that you go through the history of the cases of the International Court of Justice, and you find time and time again that they actually help resolve these disputes, and they end up creating outcomes that end up protecting the people. And yet we hardly ever hear about it. You don't hear about it on the news. And that's why I got involved in this initiative to take the issue of nuclear weapons to the International Court of Justice. My country, New Zealand, decided nuclear weapons are bad. We're going to ban them. Our allied countries, the ones we were in close association with, did not like it. They thought that we were giving cover to the Soviet Union, by being nuclear free. So they were putting boycotts on us, economic sanctions on us, saying we couldn't do it because we had military alliances. So we decided, well, we'll take this case to the court. But what we felt was it was better to take the issue of nuclear weapons to the court, not our dispute with America or our dispute with France or our dispute with the United Kingdom over their nuclear weapons issues. So this is where we did this advisory opinion, which Professor Cornesing had talked about. And that's when I left New Zealand and moved over to New York to set up the process for getting the UN General Assembly to adopt the resolution, which is like where we are at the moment now for the climate case, and then take it to the court. And one of the things, some of the lessons I think on this process from this one is, one, you may be politically weaker than these powerful political elements, like small country New Zealand and other small non-nuclear countries challenging the power of all the nuclear armed states in the world. The permanent members of the Security Council, the ones who have incredible lobbying power, and they were lobbying hard to make sure we didn't get this decision from the UN General Assembly, but we beat them because we had the moral majority. And I say that in the positive way, the moral, ethical majority, that the nuclear weapons, these are immoral, they're unethical, they're inhumane, and illegal. And that's what the legality part we needed to have affirmed by the International Court of Justice, because the nuclear weapon states were saying, there's no law banning nuclear weapons. Show us the treaty that we've signed on to, saying we're not allowed to use them. There isn't one. So that's why we need to go to the court. And here's where I come to a couple of things that Professor Konesinga mentioned. And that is that the court, and this is a really important thing, the International Court of Justice is not just dealing with treaties. And a lot of people think that international law is just based on the treaties that are agreed between countries, but it's not. International law is much broader than that. And that's where Judge Weeramuntry has contributed so much, because he has demonstrated through his legal writings, through his books, and then later on through his position on the International Court of Justice, the truth of what is the body of law that is applicable to key issues, whether it's nuclear weapons, whether it's climate change, whether it's water resources and the environment. The body of law is broad, and this is accepted in the Charter of the UN and the Statute of the International Court of Justice. They say 4 sources of law. The first one is treaties and agreements. Then the second one is customary principles of law that are accepted. Next one is like judicial decisions, and then the next one is the writings of legal and experts. So you have like these 4 sources that actually build in to the decision. So when we came into the court, it's true, there was no treaty that was prohibiting the threat or use of nuclear weapons, but the customary law included international humanitarian law, laws of peace and security, the UN Charter, and then the general principles of law applicable. And you apply those to nuclear weapons and you come up with a decision which the court said, the threat or use of nuclear weapons is generally illegal. That was the conclusion. So what does that mean? The threat or use of nuclear weapons is generally illegal. Professor Konesinga mentioned the part, but we can't really work out whether they're legal or not in the extreme circumstance of self-defense when the very survival of a state is at stake. But even in that circumstance, international law still applies. Basically, what it means is that the court affirmed that the threat or use of nuclear weapons is illegal in 99% of cases. And that 1% that's remaining, they said, we can't work out whether that's legal or not. And Judge Weeramuntry was saying, even in that 1%, it's illegal. So that was his dissent. It wasn't against the main thrust of the decision of the court. He just basically said, look, there's no uncertainty even in that 1%. And he was right on that. That since then we've had the decision from the UN Human Rights Committee in 2018 applying human rights law to nuclear weapons. There was no caveat. The Human Rights Committee said that the threat or use of nuclear weapons would violate the right to life, full stop. And this was really important, but the first one was also because in 96, it was 96, July 8th, when the ICJ gave its advisory opinion, that phrase, the threat or use of nuclear weapons is generally illegal, is basically turning the Lotus Principle on its head with regards to nuclear weapons. The Lotus Principle is that if something is not specifically prohibited in international law, then it's permitted. And the court said that no longer applies to nuclear weapons. So before the decision in 96, nuclear weapon states could basically plan whatever type of use, threat of use of nuclear weapons they wanted to, and no one could really challenge them. Now, the law says no. We assume that the use or the threat of use is illegal unless you can prove otherwise. You would have to prove that a threat or use would be legal. This is starting to develop and it's quite strong, what we say is a normative taboo against the threat or use of nuclear weapons. And that's strong. We've seen that even from the G20 leaders, for example, which included the P5 plus India, so 6 of the nuclear armed states in November last year. They actually agreed in Bali, the G20 summit, that the threat or use of nuclear weapons is inadmissible. They didn't quite get to the totally illegal and 100% times, but that's really close to that. So this is really important. It shows that the legal path is really, really important. It has an impact. and that the law is much broader than just the treaties. So all this paves in well for the climate case, because we're facing some similar obstacles. There's very powerful political forces, that want to keep the fossil fuel industry going. They create lies, about, well, our economy could not survive, if we don't, continue with our fossil fuels, and to fast track to a green economy would destroy jobs, would destroy economy. These are all lies, but they have so much money and so much power that they're very persuasive and got political power. But here, this is where a decision from the International Court of Justice will basically clamp them down. And it's like, it'll be superior to their arguments. They will no longer be able to say, well, in our country, we can't go fast to a green economy because our next door neighbor isn't doing it. We'll be at a disadvantage. They won't be able to say that because the decision from the court will apply to everyone. So that's why it's important. It's more important. I mean, the national cases are important. The Uganda case in the Netherlands is important. The case in the Philippines, which established what we would also want in the International Court of Justice. But it can't just be done at a national level, because then you've still got nations competing against each other, and some will feel constrained and others won't. And we're not going to get the combined action that we need from the entire global community. That's what the International Court of Justice can provide. That's what we can build. And to do that, we still have to beat them, not just in the General Assembly, which is the current campaign. Get your country to join as a co-sponsor. But then once it gets into court, we can't just leave it to the judges. It's going to be very important for us as civil society to work with like-minded governments to present both the scientific facts, the examples that climate change is already here, the damage that it's doing, the economic cost of climate change to balance against, what it'll cost to change to a green economy, which is less than what the economic cost of climate change will cause if we allow this to keep going. So all these facts and the scientific evidence has to be there, but so too do the stories, so too do the personal stories of people and communities that have been impacted by climate change. And I'll give an example with the nuclear weapons case. There was legal arguments from both sides, from the non-nuclear states presented about why nuclear weapons are bad and illegal. From the nuclear weapon states, they were saying how nuclear weapons keep the peace, and so why they're imported. Then we had the stories come in, and the judges, you could see, were like weighing up one with the other. Then we had some personal stories coming in, and I think the most powerful one was Lejong Eknilang from the Marshall Islands. And the Marshall Islands is one of these places which has been impacted by the nuclear tests. 67 nuclear tests from the United States. It took Lejong 3 days to travel to get to the court because the Marshall Islands, there's no direct flight from the Marshall Islands to The Hague. She had island hop, to Hawaii, and then to the United States, and then it took 3 days for her to get there, but it was worth it. When she spoke on the court, she spoke about her personal experience as a woman in the Marshall Islands who had 8 miscarriages. She wasn't able to give birth to a live baby. Some of those miscarriages were deformed. One had one eye, another one looked like an octopus. She was telling these stories, not just her. So many women in the Marshall Islands had the same experience of giving birth to things they could not even describe, how they're so deformed. And this was in a country, where the nuclear tests, when they were conducted, were done a couple of 100 miles away when the wind was blowing in the other direction during peacetime, when the governments could decide we want to do it safely, which you can't do during wartime. And so what they demonstrated is that any use of nuclear weapons, no matter if it's dropped on a military target a long way away from civilian population, will impact indiscriminately on humanity and on the environment. There is no way to stop nuclear weapons from being indiscriminate, which was the arguments the nuclear states were using. This came up, so the court then confirmed, said the destructive impact of nuclear weapons cannot be contained in time or space. Once they came to the conclusion, the final result on the law was going to be evident. They were going to find against nuclear weapons. I think they're going to find the same with regards to climate change, time and space, the impact on future generations, climate, it knows no borders. I think they'll come up with the same understanding, which will then lead to really strong legal obligations. And the obligations are both negative, what you can't do, you can't keep pumping carbon into the atmosphere. The positive obligations, what you have to do, you have to shift fast to a green economy, and you have to look at people and communities who are already being impacted from climate change and work out how to restore those communities. There are already communities destroyed. There's already climate refugees. So the court come down with both, but we will need to participate to make sure that happens by being there, by working with like-minded governments, by bringing the stories to the court, and also bringing the issue, the case in the court to the public, so they know that it's happening. The media won't just turn up there unless we tell them to turn up. The media won't go think it's significant unless we tell them it's significant and tell them why. So that's where the work of the World Youth for Climate Justice is so important. The Pacific Island students fighting climate change, where this grew up from, educating young people about, look, there's this International Court of Justice. It means something. It has an impact. It's going to, if it comes down with a good decision, which we believe it will, it's really going to make the huge difference that we need, on the stalled area of climate action. So get them behind it and make this a big buzz. And if we make it a big buzz, then the media will then make it a big buzz, and that will ensure that the follow-up then happens, which is really important after the court comes down with its decision. So I'm, as I said, really inspired by all this. I have so much respect for the young people who are leading this campaign. Also, thanks to the governments who have listened to the young people, and it started with the Pacific Island governments first, Vanuatu, and then some of the other Pacific Islands, and now 115. So keep this up, have hope, have faith that you can get this case to the court, that you can win it, it'll make an impact, but don't just sit back and let others do it, get involved, and everyone can make a difference. Thank you very much.
Thank you very much, sir, for sharing your experiences and your expertise, and also for the kind reminder that our fight just starts. We have a lot to happen after this March. And it was really such a pleasure to hear you speak, and thank you so much. And we have a request that we should leave the question and answer session to the very end of the of this session. So I will move on to our next speaker. We have Justice Dr. Masroor Salekin from Bangladesh. Sir has more than 17 years of experience as a judge, a researcher, a teacher, and a legal practitioner. He completed his PhD in law from the University of Galloway, Ireland, funded by the prestigious Hardiman Research Scholarship. And his research topics include environmental justice, judicial activism, separation of powers, and collaborative constitutionalism. He completed his Master of Laws in International Law and Development from the University of Nottingham as a Schwenning Scholar. He's currently working as an additional district and session judge in Bangladesh Judiciary. His scholarship has been published or is forthcoming in Environmental Liability, Law, Policy and Practice Journal, Law, Environment and Development Journal, IUCN Academy of Environmental Law Series, Judicial Administration and Training Institute Journal, South Asian Journal of Environmental Law and Policy, and the Bangladesh Law Commission Digest. Currently, he is an adjunct faculty at the Bangladesh Aviation and Aerospace University, Dhaka International University, and Bangladesh University of Business and Technology. Sir, we would like to welcome you and thank you so much for accepting our invitation to speak on the session. And over to you, sir.
Thank you, Dulki. Am I audible?
Yes, sir, you're audible.
Yeah, so good afternoon. I must appreciate World Youth for Climate Justice and all the partner organizations for arranging this event and working so hard to gather worldwide support for a UNG resolution requesting an advisory opinion from the ICJ. And definitely thank you, Dulki, for inviting me to this very important event, which has given me an opportunity to join the global fight against climate change. And I must agree with what Professor Kokila said and Eleanor said. The advisory opinion definitely has a huge role to play. And this is just the beginning. We must not sit idle and wait for something happens. Definitely, we have to work hard to make this happen in the coming days. And being a citizen of a developing country, Bangladesh, I know how crucial the fight against climate change is and the significance of this noble initiative. So today I will discuss how a developing country like Bangladesh is suffering for the changing climate and how the government and the courts have reacted in that regard. And focusing on the climate case Ireland, my discussion will also show how important an advisory opinion by the ICJ can be, not only for Bangladesh, but any country in the world. So as I said, my presentation would be mostly related to climate injustice, the procedural inequalities, and need for an advisory opinion from my country perspective. And obviously, this would be very much related to any of the countries in the world, particularly the small island states and the developing countries who are suffering most because of climate change. This picture explains everything, I guess. This is the poor people who are the most vulnerable to climate change crisis. This one picture from the left-hand side is from Bangladesh, and the right-hand side picture is from India. Both shows the misery of the people who are suffering from flood. They have to leave the houses behind. Many of them lost their houses, and they have to live in the government cyclone shelter projects for like months and days without any food for many days, or maybe one meal in a day. So this is really terrific. Like, I mean, they are suffering the most, and they have no one to say their voices and to hear the voices. So we must understand the nexus between climate change and human rights, and to understand the full impact of climate change. So we have to understand how countries like Bangladesh are facing the trouble and the vulnerability of climate change. Bangladesh is considered one of the most climate vulnerable countries in the world. And according to Global Climate Risk Index of 2021, Bangladesh is ranked 7th among the countries affected most in 2000 to 2019 due to climate changes. Though its contribution to global warming is negligible, less than 0.48% of global emissions, the country is impacted by all the adversities of climate change. And I think the same happening with India, Sri Lanka, Pakistan, Maldives, we all are suffering the same way, though we have very little contribution to global warming. And Bangladesh is susceptible to floods, tropical cyclones, storm surges, and droughts. Climate change will exacerbate many of the current problems and natural hazards to the country faces. As we all know, sea level rise is the biggest threat for Bangladesh among all the external drivers. And about 12.34% to 17.95% of the coastal areas will be submerged due to SLR by this century, which is really unfortunate and really frightening. We also are facing heavier and more erratic rainfall during the monsoons, resulting in higher river flows, river bank erosion, increased sedimentation in river beds, as we have seen in the pictures at the very beginning, and how people have to leave the houses because of floods. Along with this, melting of the Himalayan glaciers, leading to higher river flows in the warmer months of the year, are also adding more crisis to the whole problem. So all these changes threaten the food security, livelihood, and health of the poor, people living on river islands and along the coastlines, among the poorest people in the country. They will be seriously affected, as will others who lose their land to river erosion. Extremely poor households throughout the country, including many female-headed households, will suffer the most from climate change. As the pictures again shows, like in cyclones, people are losing the houses, the homes, how drought is affecting the country, and how people are suffering from lack of food, resources, and capacities. And climate change hazards is not only affecting the people living in the rural areas. This is also affecting the people who are living in the urban areas, because higher rainfall will definitely cause more serious problems, and sewers frequently back up in the monsoon region in the urban areas of Bangladesh. As with many other countries in the world, the Bangladesh government has also adopted a number of policies saying that, this will definitely help to win the fight against climate change. We have the Bangladesh Climate Change Strategy and Action Plan of 2009, which has been updated in 2022. We also have many other national level policies like the Bangladesh Climate Change Trust Act. We have National Adaptation Plan. We have Bangladesh Climate Fiscal Framework, Disaster Management Act. The list is very long. I'm not going to read out every detail of this whole list, but we have a number of policies. And what is most important is that we have National Solar Energy Roadmap. We have the Bangladesh Energy Efficiency and Conservation Master Plan. We have Renewable Energy Policy of Bangladesh. So it seems that the government has adopted a number of policies, but are they really impacting our lives in the practical level? If we go to just one example, like the Renewable Energy and Energy Efficiency Initiative in Bangladesh, we have seen that the government has a number of policies in this regard. But unfortunately, renewable energy production accounted for only 1% of the country's total power generation, which is very much negligible. So whatever the government has been trying, that has not been tested, that has not been properly implemented, and there is lack of accountability and transparency in the government initiatives. According to the Deputy Chief Information Officer of the Ministry of Energy of Bangladesh government, the main problem in planning for solar power is the scarcity of land. Many initiatives linger due to land shortages, and they are looking for a way out to solve the land crisis. This would be highly challenging in a densely populated country like Bangladesh, because no matter, the lands are not going to increase in our country. Definitely the population is increasing on the other hand. So I'm not seeing any point how the government is thinking to deal with these issues of renewable energy, of the scarcity of land issues. And since independence, the government of Bangladesh, with the support of development partners, have invested in several projects like the flood management scheme. We have the flood protection and drainage scheme. We have coastal embankment project, over 2,000 cyclone shelters to provide refuge for communities from storm surges caused by tropical cyclones, and 200 shelters from river floods. We have comprehensive disaster management projects, including community-based programs and early warning system for floods and cyclones. But unfortunately, the government initiatives were not sufficient to ensure climate justice in the country. There is a lack of accountability and transparency while dealing with funds and implanting various climate change policies. Definitely, we all want justice, and we all are with World's Youth for Climate Justice and this call for UNGA resolution to have a ICJ advisory opinion. And not only these problems in implementing various policies of the government, we are also suffering from various procedural inequalities. Research shows that in Bangladesh, access to information, public participation in climate decision making, and access to justice has been suffering due to cumbersome proceeding, bureaucratic inertia, costs, and long delay. We have several laws which are requiring access to environmental information requested in national laws, but there are instances of defying laws by public authorities who also chase general people for the alleged violation of the law just to justify their own development projects. We have relevant laws and policies which hasn't increased the participation by the poor people who are having lack of access or public participation in different government-run development projects. We have heard the name of the Rampal Power Plant project, which has been initiated by the government in the Sundarbans, which is threatening for the Sundarbans as well. But the local people had a very little chance to express their opinion regarding that particular project. So how our courts have been reacting to this whole thing? As we all know, that the courts are the only institution in the state machinery that allows people to hold government, agencies, corporations, and individuals accountable for any violation of the fundamental rights. However, the path to the court is never easy and is strained with hurdles, making it difficult for individuals to access the forum to defend their rights. Considering the difficulties, judges have emerged as a protector of the environment. Following the instances from other South Asian countries like India, Pakistan, and Sri Lanka, judges in Bangladesh have also attempted to expand access to environmental justice by relaxing several procedural norms. Our courts have recognized the constitutional right to the environment back in 1997. And this growing trend of judicial environmental activism in Bangladesh has stimulated legal and environmental activists to challenge various government actions and inactions under the umbrella of the flourishing right to the environment. And judges have turned to be a savior of the environment. We have seen several cases where the court have issued directives to the government, either regarding air pollution or regarding industrial pollution. As you all know, even though the courts have been trying, the air quality of Bangladesh, particularly the capital Dhaka, has not been very good. In the last couple of months, we have been fighting really hard to have the #1 position in air pollution in the world ranking, which is a shame, I would say. But although the courts have been very active in various environmental issues, the courts have been silent on any climate change issues or any issues which related to development-induced initiative of the government. For example, the Rampal project, which is a coal-based power plant near the Sundarbans, which is the largest mangrove forest in the world. The project's impact area falls more than 10-kilometer radical distance, which is within the environmentally critical area of the Sundarbans. When this issue was taken to the Honorable Supreme Court of Bangladesh, the High Court Division refused to intervene. A public interest litigation was filed seeking direction to the government to stop the construction of the coal-fired power plant until an assessment of the project's environmental impact was done. Even UNESCO issued notifications to stop this particular project. But the court, while summarily rejecting the petition, termed the attempt by the petitioning lawyer to be overactivism and actuated by publicity motive, which is again a big shame. So we also are facing problems in the public interest environmental litigation in Bangladesh. In our country, PIL is suffering from the lack of accessibility for the poor due to its elitist character, undermining the focus on social justice and socio-economic empowerment of the poor and disadvantaged. The rights group organization who have been behind the most PILs are driven by limited resources. That's why still today, we don't have any climate litigation in our country. Though we have examples from Pakistan, they had the first climate litigation back in 2012, even before the famous Argenta case or even before the famous climate case of Ireland. So definitely we require urgent climate action, and this is very crucial for Bangladesh. According to World Bank's Group's Country and Climate Development Report for Bangladesh, without urgent action, including further adaptation and resilience measures, the country's strong growth potential could be at risk. Climate change will hit poor and vulnerable people the hardest, as we all know this. Average tropical cyclones cost Bangladesh about $1 billion annually. By 2050, a third of agricultural GDP would be lost and 13 million people could become internal climate migrants. In case of a severe flooding, GDP could fall as much as 9%. And as I said, climate litigation, we have no examples in Bangladesh of filing any applications by any of the organizations or any individual, and therefore the court hasn't come up with any decision. But as we have seen in other countries, that climate litigation can be a very effective thing to make the government pair up new policies. For example, the climate case Ireland, where the Supreme Court of Ireland quashed the government's national mitigation plan because the plan failed to specify the manner in which it was proposed to achieve the national transition objective as required under the 2015 Climate Act. Subsequently, the government is working towards adopting a new policy for Ireland. As I already mentioned, in Pakistan, through the Asghar Lighari case, where the court decided that the national government's delay in implementing the country's climate policy framework violated citizens' fundamental rights, provided a new dimension to worldwide climate litigation. In Bangladesh, though the courts are very active in environmental issues, we haven't seen any climate litigation. Here, what advisory opinion can do? It can obviously serve as a basis for domestic climate litigation to the extent a country's domestic courts differ to advisory opinion about international law. It can also aware the people regarding the right. As the youths have already risen, I hope that all people from 5 years old till 90 years old, everyone should come forward. And if they are aware, I believe that the International Court of Justice has to make a decision and the countries has to come forward. We have seen enough, I think, and it's time for us all to work forward, because this advisory opinion definitely will be a platform, will be a big foundation for many people who are working to save the planet, to save the environment. As Professor Kokila said in the beginning, we have to work for our kids, for other kids, for the future generation, and for our generation, because we have to survive our lives, and our future generations have to survive as well on the same environment that we are leaving behind us. So this advisory opinion could also serve as a basis for a strong institution to climate justice in many countries. As we know, in Bangladesh, we had one Environment Courts Act of 2000. Unfortunately, the government has only established 3 courts out of 64 districts. So I would say such kind of initiative by the ICJ might also influence the government to to have more strong institutions to ensure climate justice, which will be make justice available for the poor people who has a lack of access to justice because of there is a lack of institutions for ensuring justice. So here I conclude, and thank you again, Dulki, and thank you the whole team for organizing this wonderful event. Thank you very much.
Thank you so much, sir. Thank you so much for shedding the light on the immense issues that are faced by developing nations, including Bangladesh, Sri Lanka, and India because of climate justice, and the impact an advisory opinion from the International Court of Justice can make, not only in the international arena, but also in the national legal frameworks as well. Thank you so much, sir, and thank you so much for accepting our invitation once again. Now I will move forward to the final speaker of our session, Mr. Mohammed Imran. He's from Maldives. He's a lecturer of public international law at the Faculty of Sharia and Law, Villa College in Maldives. He also teaches LLB and LLM programs offered by the University of West of England, Bristol at Villa College. He completed his master's from the South Asian University, New Delhi, sponsored by the SAARC countries, and the BA LLB from Aligarh Muslim University, Aligarh. He has got several articles published in reputed law journals such as Asian Journal of International Law, Indian Bar Review, IUP Law Review, and etc. He has been the co-editor of 2 books, Access to Justice, Need for Reforms, published by the Faculty of Law, AMU Murshidabad Center, and the Technology-Based Violence Against Women, published by Riki Publication as a project with Kalki Soch. We are honored to have you today with us, sir, because you will be discussing the impacts of climate change on an extremely vulnerable state such as the Maldives. And thank you so much for accepting our invitation, and over to you, sir.
Thank you, Dulki. I hope I'm audible perfectly.
Yes, sir.
Thank you for kind invitation and introduction. So I don't have PPT, I'm sorry for the audience, but I will try to be as precise as possible and mention some of the important issues which are, somewhere relevant more for the SID, small island countries, than for other countries. So I'll start with the observation that I know this advisory opinion is going to help all the countries irrespective of their, whether they are vulnerable to climate change or not. But with this advisory opinion and the discussion that we are having, we should focus mostly on vulnerable, if not the most vulnerable countries, because generalization of the problem of climate change will also, ignore the problems of the vulnerable countries. For example, India also has a problem of climate change, but India did not support this resolution. And I'm not sure if they are going to become supporting the advisory opinion somehow. Pakistan also did not support, Bhutan did not, in South Asia alone. And Pakistan and India, both including Bangladesh, all the South Asian countries are vulnerable to climate change. The thing I wanted to mention, for example, let's say if there is a sea level rise in upcoming 5 or 10 years, maybe few centimeters, Maldives may submerge under the sea, but it will not impact India, to that extent. And therefore, it is important to address this. From my perspective, this advisory opinion from small island countries' perspective, not from Bangladesh or India. I'm sorry, I'm trying to be blunt, but it's important. So for Maldives, it is so important that Maldives has started this practice of called land reclamation, right? So they've started making new artificial lands because they don't have land. Just to give one data from Maldives government, among all the areas that Maldives has in its jurisdiction, 99% is covered with the seawater, and only 0.331% is dry land. Other lands are wetland; they are not dry land. You have to create artificial islands and others. So there are more island countries like Maldives in the world, and also like Maldives is it's a piece of land which is fragmented into small islands, unlike Sri Lanka. So Sri Lanka is like one big island, but Maldives, you split the Sri Lanka into different pieces, that would become Maldives, which makes more vulnerable. Now, to talk about Maldives, I have divided presentation in 3 important segments. The complexities that Maldives has, and then what are the initiatives that Maldives has taken so far, and how this advisory opinion can help. So, as I just mentioned, that Maldives is one of the most vulnerable countries when it comes to sea level rise. In Maldives, the issue of development, sustainable development is also high, because Maldives gets a lot of aid from UNDP, Max Planck, European Union, US, and so on. And also, it is one of the countries which gets highest. I mean, even during COVID, it was a country that received highest investment, foreign investment for infrastructure and tourism business. So in Maldives, the issue is not about the development versus environment. It's about existence versus sustainable development, right? And therefore, any act of infrastructural development is very tricky. For example, in India, one can argue that you have to protect the forest because you have enough land. But let's say Maldives tries not to create an artificial island and saving its lagoon and reef area. It will save the existing ecology for a few years, but that island may not remain there in few years, like maybe in 10 or 20 years, right? So when a piece of land is not livable, someone has to do something. And when Maldives tries to create an artificial island, it is going to lose the beauty, going to affect the ecology, environment, and lagoon. So it's more tricky than for other countries. And talking about its internal laws that Maldives has, starting from the constitution, Article 22 of the Maldivian constitution also says that it is a fundamental duty of the government of Maldives to protect the ecology, biodiversity, and the natural environment of the Maldives, including the beauty, because that is how the tourism business works. So protection of beauty of Maldives in terms of reef and lagoons and everything is also important for the government of Maldives. Quickly on the contribution that Maldives has made in terms of its state practice, we don't have cases from the Supreme Court, and that is, I think, because of the democratic erosion due to their own internal politics. But aside that, different governments since 2008 and also before have taken some good initiative with reference to climate justice. One very significant is Mali Declaration on Global Warming and Sea Level Rise of 1989. This, I mean, in Southeast Asia, this is one of those important declaration that was submitted to UN General Assembly. And in this declaration, Maldives did not only talk about having a long-term and short-term plan for climate justice issues and exchange of information between SID's countries, but it's also asked the small island countries to use or seek assistance from UN and other agencies of United Nations to clarify the rights related to climate justice. I think I would like to interpret this in a way that this is the current advisory opinion is just extension of same kind of idea that small island countries were having. Seeking assistance from ICJ or having an advisory opinion is one of those aspirations that this declaration had. In 2021, and I'm just skipping a lot of information, but we can have that in question and session. In 2021, when the Maldives was chairing the Human Rights Council, the Foreign Minister of Maldives, Mr. Abdullah Shahid, he tried to invite countries and tried to seek their attention on the issues of climate change, even when the COVID was dominating all the areas of research and investment. So I think for Maldives, climate change has always been important and you can say a top priority when making a policy. But apart from these things, there is one thing that we have to address, and this is, I mean, among all the climate change issues, the first priority that I want to mention that Maldives has right now is maritime delimitation. So everyone must be knowing about the case between Mauritius and Maldives regarding the maritime delimitation. So what's happening is that due to sea level rise, island countries like Mauritius and Maldives and maybe Sri Lanka also they are going to lose some pieces of land, right, compared to big countries. And in its submission to United Nations International Law Commission, Maldives has said that any loss of land should not change maritime boundaries between the countries established by the treaty. For example, India, Maldives, and Sri Lanka has tripartite agreement regarding equidistance maritime limitations. This idea of Maldives that it will not change maritime boundaries is important because under international law, there is no guarantee to the state that is going to be submerged. For example, Tuvalu, I'm not sure if Tuvalu can claim any kind of sovereignty over the land, which has been lost. And also, there is no positive obligation on any state as of now. That's why we have this advisory opinion. And if you see the Montevideo Convention, it says that to be a state, you need to have a territory. So imagine about the countries who don't have a territory, and even Convention on the Law of Sea says any island will not become just a piece of land for the purpose of state. It has to be livable. I mean, there has to be habitations. If people can't live on the piece of island, piece of land, it cannot be considered as a territory in the sea, right? So it's like Maldives submerging under the sea, and you can't live here, but still there is a land, right? That land may not be considered as good enough to claim the status of state under international law if you go for the definition of Montevideo Convention on clause 3. And that's a very serious concern for countries, small countries like Maldives. So all these things, if we take together, we can understand that how important this advisory opinion is going to be for any countries which is going to be, which is affected. Among other things, we also know that small island countries are the least emitters of the carbon emission, right? And they are the first victim of the carbon emission in terms of sea level rise. Okay, so there are certain debates that say that those countries who are going to, polluter pays principle, I think Professor Kokila also mentioned, but there is no customary international law which actually says that the countries who are going to emit or emitting carbon are responsible for the loss of land or sea level rise directly, right? Or at least we don't have any, let's say, a fund, climate change. I think Bangladesh created one climate fund a few years back. I'm not sure if it is still there, but they have it like internally. So we may also think of having some kind of climate change fund to support the countries who are fighting climate change, because I know both Sri Lanka and Maldives has high debt to pay from IMF and from any other countries. And if we see their income, so let's say if their total income of both these countries are 100, out of 100, 60 to 70% goes to climate change issues, right? Creating artificial island maybe, and investing in the areas to mitigate the effect of the climate change. And then these countries have to pay the debt also from IMF, or let's say for taken from any other country. And then there remains little to contribute for the development of the country. And so it is going to affect the education, the sustainable development, food security issues. So everything is, if we club together, has a lot of effect on how the world sees these countries' position, right? And these countries are not vulnerable just because where they are. These countries are also vulnerable on how others are treating their territories. So we have this transboundary harm principle. Although the direct effect of transboundary harm, has this idea that the countries can claim reparation, but the sea level rise is not the direct effect. It's a indirect effect. So a country in like India and China are emitting carbon. A country in, let's say, some places in America, there are highly industrialized countries. How much carbon emission they do has a deep impact, right? But we can't directly, there are scientific proofs, but it is not as direct as someone, let's say, having a factory in his country and the pollution directly goes to the other country in the neighboring country, because that is more visible, conceivable. But the impact has been proven by the scientists, I think, regarding the sea level rise and the carbon emission. So with these things, I think I'll end, and I would like to have, if there are any questions, we can be a bit more engaging. Thank you, Dulki.
Thank you so much, Imran sir. It was really fascinating to hear you speak, and to be honest, I didn't know that India is not supporting for the advisory opinion. So we have make note of it, and now our members from the
India's a big
WICJ
player,
will
so we
be
can't afford to
working
lose
on
India.
this.
Yeah.
So thank you so much, sir. And now I'd like to open the floor for questions. If you have any questions, then you can raise your hands or type your and share your questions in the Q&A box. Are there any questions?
I think someone's typing. Just Mr. Sir is typing, I think, something. It looks like maybe Sir can speak, then that would be better.
Sir, you can, Dr. Salekin, sir, you can speak if you like.
I was not typing, like someone else was typing, maybe.
Okay, okay.
It shows, I thought maybe you're...
No. I've been waiting for questions if there's any.
Yeah.
Does that mean we do not have any questions?
Maybe we all are very clear that, advisory opinion is
the
most important thing. It should come.
Yes.
There is no confusion regarding this particular issue. So
yes. So it's already 5 p.m. So I guess we can conclude this session. And I thank all of you, to Professor Kokila Konasinghe, Mr. Alan Ware, Justice Dr. Masroor Salekin, and Mr. Muhammad Imran for taking your precious time and sharing your expertise and insights on the advisory opinion on climate justice from the International Court of Justice. And thank you so much for joining the session 2 of this conference series. And I would like to invite all our participants, if possible, to join us for our next sessions as well. We have our next session 3 on Europe, starting at 5:30. So until then, thank you so much, and take care, and thank you for joining. Thank you. Bye-bye.
open and connected, that works too. So see you in a bit.
Everyone. We'll just be on break for a bit. But while you wait, we'll be playing one of the episodes of Seeds of Justice in the theme of this month's celebration of women empowerment, or the International Women's Month. Thank you.
Welcome to Seeds of Justice. This is Series 3, Episode 3, hosted by the Asian Research Institute for Environmental Law. And this episode is co-organized with the Asian Development Bank and the United Nations Environment Programme. I'm moderating the discussion today, and my name is Georgina Lloyd. I'm the Regional Coordinator of Environmental Law and Governance at the United Nations Environment Programme Regional Office for Asia and the Pacific. In today's episode, we celebrate International Women's Day, and we're going to be discussing breaking the glass ceiling for women in international environmental law and national environmental law. In fact, the whole field of environmental law. But we're also going to link this to this year's theme for International Women's Day, and that is digital, innovation and technology for gender equality. This represents a call to consider and address the disadvantages of women and girls in policymaking, better integration of women and girls into the digital era, and the creation of a more secure, accessible, inclusive, and equitable digital world. Of course, this theme has links in the field of environmental law and how legal professionals engage with technology. I'm joined today by 3 incredible women. The first is attorney Gali Ramos, Vice President of Oceania, Philippines. Gali, you co-founded the Philippine Earth Justice Center, a non-profit which institutes environmental cases and uses accountability tools to promote good governance while assisting stakeholders' compliance with environmental laws. So I want to start with asking you, what has inspired you to become a lawyer for the environment?
Thanks, Georgie, and thanks for having us here. It's really a very interesting. I think this started when I was small. We were always exposed to the environment. Nature was our playground, but it was Tony Aposa who really is responsible for me shifting my focus. I was a corporate lawyer, and then he invited me if I can join him in the newly established Integrated Bar of the Philippines National Environmental Action Team, helping him as a deputy for the Visayas, where I was then based, and that really changed everything. And I'm just so thankful. I had no one but I have Tony Oposa as my great mentor in this fight to protect the rights of our people and, of course, our environment.
Wonderful. Yeah, I mean, as Tony says, the law itself is land, air, and water, right? So it's the very foundation of our law is indeed the environment, and environmental law is so important. So let me turn to our next incredible panelists, Asia Y, who is a legal fellow at the Environmental Legal Assistance Center. And Asia, you're also a member of the Asia Pacific Youth Advisory Committee on Environmental and Climate Justice, which has been incredibly important in also supporting and informing the work of young people in the region. So Asia, I wanted to ask you the same question. What has inspired you to become a lawyer for the environment?
Thank you, Georgie. So for me, you know how the Philippines is an archipelago and there's so much diversity locally, like within our country. So when I was 19, I said I wanted to visit all the 81, well, now 82 provinces of the Philippines, just so that I can tell myself that I know something about my own country. And in the process of traveling, visiting pristine islands and lakes in the middle of nowhere during breaks or in between semesters, my part in protecting that, so that many other people can also still enjoy it or have that magical experience with nature. So for me, it's mostly because of traveling. That's why I got into this environmental law thing.
It's really interesting. I think it's a common theme that it's really engagement with nature and being that opportunity to get into nature and learn about how communities interact with nature that builds a lot of passion and really inspires a lot of environmental lawyers. It's fantastic. Thank you, Asia. And so let me turn to our third panelist today, Sophia Carald, who is a knowledge management specialist and youth coordinator at Parabucas. Of course, Parabucas is a women-led Asia-based international consultancy that focuses on laws and policies related to climate change, the environment, and sustainable development. So fantastic to have you with us, Sophia. What has inspired you to work in the environmental law field?
Thank you so much for inviting me here and representing Parabucas, of course. Aside from being close to nature, because I during my college I was really living at the foot of the mountain in Mount Makiling in Laguna, and when I graduated, I was looking for jobs here in Metro Manila, and that's when I found Parabucas. So my luntitas or my environmental lawyer aunties, so I called them, really inspired me to be in this field because I saw in them the potential of women in this kind of field that is always or is commonly dominated by men. And I saw how empowering it was being one of the few environmental lawyers here in the country. And for me, it's a very interesting field because not everyone or only a few people practice environmental law, and it's very inspiring every time I hear stories from them. So it's just being part of the group and belonging in this kind of community.
It's so interesting that you say, Sophia, that still there are not many women practicing in environmental law. And I mean, golly, you've been at the forefront of environmental law work in the Philippines and internationally for a number of years now. Why do you think that there are still so few women practicing environmental law? I mean, do you think that there are some existing or continuing barriers that women face in the legal field?
I just would like to say that there are still very few environmental lawyers in the country compared to the number of lawyers, like 60,000 lawyers. How many are environmental lawyers? But in the field of environmental law, I see a lot of women now becoming a strong part of the advocacy, and that's really a welcome development. In fact, not just in the field of environmental law, you see leaders from coastal communities who are women. So in the Philippines, I'd like to think there are more women advocates fighting for Mother Nature, and that has also strengthened us. We know each other, and in the Philippines, we have Jerthy, we have Lisa, all women and young environmental lawyers such as Asia and Sophia, and I'm very sure there will be more. Planting the seeds of compassion and love for the environment comes naturally for women, and I'm not surprised there are many. There are now a growing number of women in this field.
That's so exciting. And it's interesting that you say that it comes naturally, you know, fighting for the environment. And I wonder if that's also because, I mean, both Sophia and Asia, you mentioned living close to nature and seeing how people interact with nature. And it's interesting to see whether you felt a particular passion there to engage with environmental law, or has it been because you've had a lot of female mentors that have been inspiring you? So maybe Asia, I don't know if you want to answer that. Or Or maybe Asia is just disconnected for a second. So maybe Sophia, over to you.
Yeah, I think for me, law wasn't like the first choice. It was more of advocacy activism. That's the closer to how I was in college, because it's back then it was easier to mobilize people, to connect nature with people, because it was like it's like a given, especially living in Laguna. We're so close to nature, so it's easy to make it relatable. Issues about environmental degradation, climate change were easier to convey to people. But I think the legal aspect of how I got here is when after college, when I see how we how we needed systems change per se, because I mean advocacy is one thing, but also we have to complement it also with some legal strategies to make an overall impact in the community.
Yeah, thank you. And in moving to this sort of work in environmental law, particularly linked to advocacy, did you face any particular barriers? Do you think that there are any existing barriers, particularly that women face, for example?
The common experience for me is since I started young. I think I started around 19 years old, fresh out of college, new with the environmental activism space, and new with the legal aspect and policy aspect. There was a lot of kind of discrimination, saying that, oh, you were young, you still don't know what you're talking about, or okay, I'll hear whatever your demands are. For example, back in 2018, we did a lot of climate strikes following Greta Thunberg's climate strikes. But then when we were able to talk to government officials, it's always like us presenting our demands. And then I remember one time, like in a closed door meeting, the secretary or the commissioner said, "Don't tell us that it's your demands. Like demands are too strong to come from you as a youth." So they suggested that maybe make it as wishes. So it's more accommodating or milder when you come to talk to policymakers. And at that point, it's very disheartening. But then it made me realize that there's much work to do for me as an individual and with this space that I can grow. But that was the barrier before. And sometimes it's still there, but then I learn and we learn how to um, ride those challenges and persevere.
Yeah, so for you, it seems that the barriers have been more linked to perhaps assumptions about the capacity of youth rather than the number of women or men environmental lawyers in those positions. I wonder, Asia, whether you have experienced any particular barriers in the field of environmental law, and whether or not you think that those barriers have been linked to gender or have just been linked to other issues.
Okay. For me, well, you know how environmental lawyers work a lot with communities on the ground. So maybe I can just share one story. So in 2018, I was an intern with ELAC, the same organization that I am with now. And then we were helping a community update their ancestral domain sustainable development plan. So a part of it, we have to cover the uh, the cultural part. So there was a heated discussion on the Duai system or the polygamy system that time in their community. So of course the women wanted out, the younger generation wanted it out, but then the older uh, men didn't want it scrapped out of their culture. So and we were just facilitating the discussion. And then at the end of the discussion, in a very candid way, one of the older guys said that approached me and then in a very joking manner said, "Oh, ma'am, maybe when the time you get back here, you'll be one of the Duai implying that I may be like married there. And well, I was younger then, and I was very surprised at the comment because I wasn't expecting anything like that. So my knee-jerk reaction was, "Oh, sorry, you might be mistaken. I'm probably the one having the duai. Probably the one having two lovers at the same time." Basically, that's what I said. Okay, at this point in time, I know I should have responded in a more cool-headed way that time. But then, at that time, of course, parang I was taken by surprise. And well, a part of me realized that being a woman in the environmental law field, especially when you do field work, before they know that you're a lawyer, before they know that you're there for official business, they'll first see you as a woman, and that includes all the usual not problems, but lack of safe space feeling that other fields also experience when you're uh, a woman. So there's that part. And in relation to um, technology, it's still related to that in a sense that a lot of the people we work with are in far areas. So it's not as easy as it's not as easy for me to like have documents signed or have a meeting. I can't just go like very easily. So there are other things that needs to be considered. So I think part of it becomes inefficient that way because I have other things to consider. So there. So yeah, the communication part in technology
Yeah.
is
And
a
I mean that
limitation.
that can create a barrier not only for women in the field of environmental law, but for the communities we're trying to serve, because there is statistics, there is data that indicates that women have less access to the internet, have less access or understanding of how to use technology, which can then be a barrier in participation, which is one of the key values that we, of course, as environmental lawyers, trying to advocate for. So that's quite difficult. And I think that the story that you shared, Aisha, is probably something that others have similar experiences of as well, as being seen first and foremost not as a professional in your field of expertise, but how you present, rather than initially, what technical expertise you come with. I'm not sure, Gully, if you have had similar experiences. We've talked for many years about the glass ceiling in law, in the legal career, and that it can be very difficult for women to really smash through that glass ceiling. Certainly, has been the case in corporate law and criminal law and other fields. I don't know, Gully, whether you've had any experience of that glass ceiling in environmental law.
I don't know. I never felt it. Maybe because I'm an outlier. From the very beginning, I always thought of myself as a human being, not as a woman. So I really expect people to also treat me equally. I think I'm privileged, was brought up that way by my parents. And I also have strong women models. So I don't feel it at all. And I'm privileged to have had the experience of working with strong women on the ground. For example, in the fight to stop coal-powered plants in Cebu, I brought along our law students for them to be exposed to what's happening in communities. And the ones who met us were the mothers carrying their children. And I asked, "Where are your husbands?" And they said, they're working in the coal-fired power plants, and they chose to stay at home. So you can see if it concerns their health, their survival. You can really see the women in the front line fighting for the right of their children more than anything else. But I know that it is a reality in our country. There's gender discrimination. And I also know of, for example, women fisher folk who were not given, like, because they were fisher folks, but women, but they were not given boats, for example, or gears because this belonged to them. There's a lot that we still need to do to ensure that women are treated fairly in society. And I think one of the things that we have to do that is really create a platform for which they can speak out and accorded the respect that is due them as a woman, as a human being.
And the importance of strong mentors, I think, cannot be underestimated, because Sophia, you also mentioned that you called them your environmental law aunties, right? These strong mentors that really paved the way and showcase the power of women in this field of environmental law. I don't know if you want to share a bit more about that.
Yeah. So basically they're called my luntita. So it's like luntita, luntian, like the Tagalog translation is green and titas are aunties. So they're my green aunties in environmental advocacy. So they've always been apart from, so they are like sorry, they are like my advisors in like my personal life as an advocate, and then on the legal and more professional aspect as me being or studying towards becoming a lawyer. So they're very empowering because as in every time I encountered difficulties in leadership, like I've been switching roles from different organizations, trying to lead climate strikes, to trying to raise more awareness about climate change and different issues, to mobilizing like youth for policy development. They were always like telling me that because before I was like I should know everything, coming from the experience I told you earlier, that policymakers would often shun us down, like you still don't know what you're talking about because you're still young. So it kind of made me want to study a lot and like to learn everything all at once. But then they put me into perspective and told me that, Sophia, you're still young and you're in the stage in your life that you're supposed to learn, and you should not like stop yourself from continuously learning and admitting that you're still learning, because you can learn everything all at the same time or at this exact moment. I'm not supposed to know everything, but I should accept the fact that as an individual I'm still learning. So it's one of the learnings that I'm taking every time in this advocacy, in this legal field. But then, yeah, that's about them. And it's empowering to see how they also grew in this environmental space, because from their stories, they also started like as environmental law students, juggling their daily grind in law school, and then seeing them have their own firm, which is Para Bukas, and then building a network of women environmental advocates, lawyers. So there's hope, like for me as a law student and in an environmental advocate, that there's hope that what I'm doing right now, there's something I can look forward to in the future, like in the near future. It's not like a very far away future.
Yeah, and honestly, I don't think you ever stop learning, right? And we should never tell ourselves that our time for learning is finished. You know, this is constantly evolving and something that we can always expand our knowledge of the field and the way that we can achieve more and more and expand. But I mean, I completely agree with all of you that having strong female mentors has been also critical for me in understanding the possibilities of women in this field, and also having incredible male mentors as well that have lifted women up and have made space for women and have also advocated for the need to have more representation and a greater diversity of voices in the field. You mentioned, Sophia, juggling, and I think that this is a topic that we should delve into a little bit more, because there's always this debate about work-life balance, and honestly it's something that concerns everyone, men and women, but for some reason it keeps coming back to women. You know, how do you do it? How do you juggle? How do you achieve this work-life balance? And again, it comes back at maybe to those cultural assumptions that women are the ones who would be spending more time at home or be spending more time with family, and therefore there's more of a need to juggle and find that balance. So I think that, you know, let me come to you, Gali. You know, how have you, you know, supported women and female lawyers to balance competing demands of work and life, and how have you done it?
Yes, well, as I told you earlier, I've always been a fighter for equality. So taking care of kids, we have a cut-off time for my husband to be in charge and me until 12 because we were both working. So I didn't pamper him at all. Never the one to pamper. And going to for medical consultations, he's always there, and he should be thankful to me because the kids are close to him. In the Philippines, the male are pampered, and I'm not the one doing that. But really, work-life balance is so important. Especially if you're so passionate with the work that you do, sometimes you forget to have this time for yourself. And I'm still learning that, but it's for mental wellness and for recharging yourself. You really need time to be still or to be doing uh, whatever that you still want to do, because otherwise you'd lose yourself, and that's so sad. And that's one of the things I really tell our team and people who are close to me, the young lawyers, really find time to pamper yourself. That's so important because you matter, your health matters. But the pandemic has really been a real test for all of us. So what we did was bring in like wellness program for our team. So it's a work that needs to be done for, especially for those who forget that we need to be kind to ourselves, and that matters a lot. And I hope our young lawyers are listening as well.
Absolutely. I mean, for Asia, for you, I mean, is technology a tool here to help balance work and life?
Yeah, of course. Wait, can I just say my fiance is listening across the room right now. I think he's getting a sneak peek of the future just by listening to Ma'am Golly's sharing. Anyway, but yeah, I think technology is a very well, for me it has been game changing, because especially with how the pandemic shifted everyone to online meetings. All of a sudden there's so much social acceptability on online calls, online meetings. It's easy to make urgent meetings, unlike before. And even if, like right now, I chose to work in Palawan. It's a separate island from where I used to live in. So my family is far away from me. Everybody technically is far away from me. But then I can still catch up with them. I still am able to meet with my Saturday group. So yeah, every Saturdays I have this group where we do like meeting. It's not a meeting. It's like a prayer session, and then share about life. Try to process the different experience that we're having. So it's a trusted group of friends, and a lot of us are also young lawyers navigating our way into this like legal world. So there, I think technology has helped me bridge the gap between me and my loved ones, uh, since I chose to work there. Because, well, to my simple mind, the environment and the things that should be protected is in uh, Palawan. And even for the community members themselves, uh, right now, trainings can be done hybrid. So there's a facilitator physically, and then the resource persons can be online or even recorded. So all of a sudden, there's access to these amazing resource persons, and they also are able to interact with the community members, although online. So I think that helps also because there's more sharing and accessible environment because of technology, and it helps us also balance our work-life balance.
Yeah, I think this with the pandemic, this acknowledgement that people can still deliver and can still work efficiently remotely actually has a lot of potential for women, particularly to balance work and life. This idea that maybe we can have a phase following maternity leave where we just working remotely that would still give us access to family but engage back in the workplace at the same time, and lots more opportunities now that we're perhaps not having to be in the office 5 days a week, 6 days a week, however you happen to be working, but maybe on a certain number of days we can be working remotely, we can be having that flexibility engage, but still being just as efficient. And really committing to our professional goals as well. I don't know, Sophia, if you find that technology has helped you in a way as well to balance work and life?
I think yes, definitely. Because early days of the pandemic, like everyone's remote, so you have the time to actually do things that you love outside of work, or like you can do more of those things because you can finish work in like an hour or so, and then you're done for the day, and then you can do random things already. And then I think one of the perks of working remotely and with the digital technology now that it is more accepted, is that women can really work anywhere they want to. Like I have colleagues who's tried working in coffee shops near surf areas, near the beach. So it's really accessible to live your life while doing work. And it like the work is not anymore limiting you to see the wild world outside. And I guess for me as like a younger person, it made connecting to other people easier. Like I'm not limited to connecting working with Filipino youth here in the country, but it gave me opportunity to work with other youth across the globe. So in a sense, it made us feel more connected than we were before. However, I think there was like a negative effect on that because everyone's kind of expecting that I'm always on my phone, I'm always online, ready to answer, ready to work. So it kind of blurred that one. Though I know like sometimes I'm willing to do work beyond work hours, but sometimes it's really blurring the lines of when I should rest or when work is done. So, but then it's like Attorney Golly said that it's also recognizing that I'm a human, we're a human, and we're a resource that should not be overexploited.
Absolutely. And it goes both ways. I know for me, coming back, working in the digital world and being online all the time was fantastic because you got access to colleagues and spaces that you maybe didn't before. But then there was this assumption that we could then join all the meetings, that regardless of whether your colleagues were in New York or whether they're in Geneva or whether they were, you could join that meeting even if it was 10 p.m. or 5 a.m. Yes, in theory, it's possible.
It makes the time zone kind of tricky because not everyone understands how it goes. So like they're sending call
links at weird hours of the day, and then like they're expecting you to just hop in.
Yeah. So we have to set our own boundaries here, right?
That's the word. Boundaries.
Boundaries. Yeah. And we have to be also confident in being able to set those boundaries, because sometimes it can be difficult to set those. But the other thing that you said that I thought was very important is that because we know how to use technology and we know how to engage in a professional way over the internet, it gives us a lot of extra opportunities and potential. But one of the statistics that is being shown for this International Women's Day is that 37% of women do not use the internet. And that there are 259 million fewer women who have access to the internet than men. And so it is just as important and very important for us to extend those opportunities to women so that they are able to work remotely and be able to engage across all fields, not only in environmental law.
That's right,
Yeah.
Georgie. As you said, we have been provided opportunities to be able to reach out. And for example, what we did was really reach out to our coastal communities. And many were hesitant initially at first, and then they saw the benefits. And what we did was having this communications planning with the children, because the children are more adept in using technology, and for them to be able to also cascade their learnings to their parents, including their mothers. So that was really also an eye opener for us. And we also really believe in empowerment of our youth. So the youth are the ones who really help their parents in assisting them in the use of technology, because you have to be comfortable with it before you would even explore. So yeah, that's one of the possibilities that we can do to reach out to as many women, for them to be comfortable with the technology.
Fantastic. Well, which leads perfectly into my final question of what recommendations and practical advice or suggestions would you give to empower women in the field of environmental law? And indeed, one of them sort of reaching out to youth and young girls and women, I think is a really important one. But just very quickly, maybe just two things from everyone of what other sort of practical recommendations would you give to empower women in this field? So maybe over to you, Asia.
Maybe first would be to not be afraid to try new techie things, because I often hear this in my work environment. Some people are are afraid or hesitant to try Canva or to try artsy techie things online, because it's very user friendly these days. Parang it just takes willpower to use it. And then second would be to always be grounded in touch with the things that make you feel alive in this field. Because sometimes when we're so passionate about what we're doing, it's so easy to overwork ourselves and then get too focused. We forget that, like earlier said, we're also human beings and we need to be refreshed every now and then. So it's very important to know ourselves that way, what refreshes us, so that we can be in this field longer.
Wonderful. Sophia, over to you. What advice would you give?
Yeah, I think on a practical side, it's be, how do I say this? Learn the security aspects of dealing with digital technology. Because digital technology is relatively easier now, but the negative effects or how other people could jeopardize your security is also made easier. So especially for women, that's a bit, or that's scary for us. So I hope that we're safe when we're using this digital technology. Be careful with the informations that you share, and of course be with a group of friends, network that also supports you, guides you through the process.
Wonderful. Thank you. And Gully, your thoughts?
Yes. Yes. Share what you have, what you know, your resources. For example, there's this platform that women fisherfolk leaders can be together. So we're providing that platform because so many things can happen out of that. I'm a big believer in the power of women to effect change. So at every opportunity that we have, we really use that. In fact, on March 10, we're going to have that platform for them to be able to form an association by which they can be there. And the other is really, we have this Philippines has fantastic news for women to be part of decision making, and they should be engaged in that. And like for every village, local governments, there's a law that women should be a representative of the local legislative body, and that is not happening, but we should push hard for it. So that's one of my dreams for the women in the Philippines to really fully avail of the benefits that our laws have provided them, but which some are really scared to implement. I don't know why. They're scared of the power of women, perhaps.
Definitely should not be scared of the power of women, right? I think that only can lead to good things. So thank you very much to Gully, Asia, and Sophia for joining this episode. It's been fantastic to speak with all of you. And we need to continue this discussion and celebrate women in the field of environmental law, not only for International Women's Day, not only in March, but in every month and on every day. And so we're going to continue this discussion also in a second episode that is going to be broadcast or released on the 21st of March. But thank you very much for today. Thank you, Asia, Sophia, and Gully. It's been really lovely to talk with you.
Thanks so much.
Okay.
Bonjour.
Bonjour.
Hi, Nicole.
Hello.
Hello.
Aditi.
Hi. Welcome everyone to the reopen session. Is everything fine technically? Hopefully. Okay, Nicole say yes. So let's go. I will switch in French because we have like some traductors. So sorry for our English speakers, but you will be able
No, I
to
understand, but for you, it's better that I speak in French and not in English.
Donc,
But I don't see me, and my camera is open. I don't understand.
We will fix that, Madame. 1 minute.
Okay.
My colleague is fixing it, but yes, it would be.
It's not very important. If you hear me, it's the most important.
Yes, but it would be very nice to see you as well. And please feel free to speak in French. That's why we made sure to also invite translators so that the participants and the attendees can speak and carry it out in their language. So please, we invite you to speak French.
Okay, thank you. C'est à mon tour.
Je vais faire une courte introduction, si vous...
Très bien, ok, parfait, mais je vois toujours pas mon image. Hein. Mais c'est pas grave. Hein.
Peut-être le temps que j'introduise le sujet, peut-être que vous pouvez essayer de vous déconnecter, de vous reconnecter. Peut-être que c'est simplement un petit bug technique.
Mais je ne sais pas. Si vous voulez, je veux bien essayer, mais comme je suis là et j'ai peur que si je reviens, ça soit encore pire. Donc,
peut-être.
Je
Si
préfère.
je peux,
Oui.
Si je peux, c'est Yann, un autre intervenant. Je vois effectivement dans la liste des participants que votre caméra est connectée, tout comme celle d'Altinaï. Donc, je pense pas que le problème vienne effectivement de votre ordinateur. Je pense que c'est plus, ça vient de peut-être du côté organisateur. En tout cas, la caméra apparaît comme connectée.
Non, moi je suis connectée. Hein. Je peux pas faire mieux là.
Eh bien, on va commencer comme ça en espérant que Nicole puisse trouver une solution technique. Et sinon, comme vous l'avez très bien dit, l'important c'est qu'on puisse vous entendre, même si nous espérons pouvoir vous voir d'ici votre prise de parole. Donc, bienvenue à tous et à toutes à la session Europe de ce cycle de conférences qui a commencé depuis ce matin à l'heure française et qui dure tout le long de la journée. Mais qui est suivi à travers le monde entier sur différents fuseaux horaires et grâce à nos traducteurs. L'enjeu principal aujourd'hui, c'est de discuter ensemble des conséquences possibles d'un avis consultatif que rendra la Cour internationale de justice à la suite de la résolution du Vanuatu. Cette session Europe portera spécifiquement sur les actions en justice pour les générations futures dans la région et plus précisément nous discuterons de la jurisprudence européenne et la manière dont cet avis consultatif pourra être utilisé comme outil d'activisme et de contentieux en matière de climat. Pour cela, nous avons l'immense plaisir d'accueillir des personnes imminentes, comme Madame Corinne Lepage, ancienne ministre de l'Environnement, que malheureusement nous ne pouvons pas voir encore. Émilie Gaillard, qui est doctoresse en droit privé et pionnière en droit des générations futures. Merci beaucoup pour votre présence. Et Monsieur Yann Robiou-Dupont, scientifique climatique, dont les travaux sur la quantification des mesures prises par les pays en matière de climat sont utilisés dans le cadre des contentieux climatiques. Merci à tous les trois d'être présents avec nous aujourd'hui. Ma camarade Lolita et moi-même, Altinaï, nous serons responsables de la modération de cette session et resteront avec vous tout au long de cette session pour une durée d'1h30. Nous sommes toutes les deux étudiantes en master Génération Future et Transition juridique à Sciences Po Rennes, dirigée par Madame Gaillard, et membre de la campagne française de World Youth for Climate Justice. Tout au long de la séance, n'hésitez pas à poser vos questions via le chat pour les intervenants. Nous leur transmettrons lors des temps d'échange. Et si vous avez n'importe quel problème technique, n'hésitez pas à nous le transmettre aussi dans les chats. Je vais laisser la parole à ma camarade Lolita qui va faire un court débriefing sur le contexte de cet avis consultatif et nous laisserons ensuite la parole à Madame Lepage pour sa présentation.
Merci beaucoup, Aditi. Alors, on me dit que la solution pour la vidéo de Corinne serait que vous essayez de vous déconnecter puis de revenir.
J'ai vu, donc.
Ouais, à tout de suite. Du coup, un petit contexte rapide pour éventuellement les personnes qui n'auraient pas suivi toute la matinée. On a longuement parlé de l'avis consultatif, donc pour que tout le monde soit un petit peu sur la même longueur d'onde. Donc, il y a un peu plus d'une semaine, donc, on a eu une avancée historique pour la justice climatique et les générations futures, puisque le Vanuatu a publié la liste officielle des pays qui coportent sa résolution. Il y a plus de 104 pays qui coparrainent cette initiative historique qui vise à demander un avis consultatif à la Cour internationale de justice quant aux obligations et aux responsabilités des États envers les générations actuelles et futures face à l'urgence climatique. Donc, un avis consultatif, c'est un jugement qui est rendu à l'issue d'une procédure consultative, donc c'est différent d'une procédure contentieuse, et c'est là toute l'innovation. Donc, il ne s'agit pas pour la Cour de statuer sur un conflit, mais de répondre à des questions de droit qui lui sont soumises, et donc ce n'est pas contraignant. Mais même si ce n'est pas contraignant, ça possède une haute valeur juridique et une grande autorité morale, et donc ça pourrait devenir un instrument de diplomatie qui pourrait pacifier les relations entre les États sur ces questions. Donc, les avis consultatifs, ils contribuent aussi au développement du droit international, et donc par ce biais, ça pourrait renforcer les relations pacifiques des pays sur ces questions climatiques. Donc, l'adoption de la résolution du Vanuatu devait se faire par l'Assemblée générale des Nations unies. Finalement, au vu du nombre des pays qui coparrainent, 104, le vote ne sera plus décisif puisque ce sera adopté par consensus. Donc, c'est une grande victoire. Il y a d'autres initiatives similaires qui sont en cours, donc d'autres procédures d'avis consultatif. Il y en a une devant le tribunal international de la mer, qui est aussi à l'initiative du Vanuatu et de ses alliés, et une autre qui est en cours devant le tribunal interaméricain des droits de l'homme. Donc, on voit bien que ces nouvelles initiatives et outils juridiques, il est en plein essor. Donc, maintenant qu'on a eu ces belles victoires, il faut penser à la suite. Donc, comment on va se saisir de ce nouvel outil juridique, de ces avis consultatifs, au service des nouvelles affaires climatiques, par les mouvements militants pour la justice climatique, pour approfondir donc, les litiges qui sont en cours dans notre région en Europe. Donc, parce qu'en Europe, en ce moment, on voit que depuis des années se multiplient les actions en justice climatique. C'est devenu un nouvel outil militant, l'activisme en justice climatique. Et ça a été saisi par la société civile qui l'investit de plus en plus. Et on peut se demander donc, comment elles vont évoluer avec ces avis consultatifs qui vont peut-être permettre d'approfondir ces actions. Et donc, pour évoquer tout cela, dans un premier temps, on va voir ça avec Corinne, que Altinaï va rapidement présenter.
Bonjour Madame Lepage, je vais faire une très courte biographie de votre carrière très riche et est rempli d'expertise en la question. Donc, vous êtes avocate et politicienne française de renom et engagée pour la protection de l'environnement. Vous êtes titulaire d'un doctorat en droit et diplômée de Sciences Po Paris et vous avez prêté serment en 1975. En cours de ces 40 dernières années, vous êtes engagée de diverses manières en faveur de l'environnement. Notamment en 1978, lors du naufrage de l'Amoco Cadiz, vous avez défendu les victimes des marées noires avec le cabinet Hugues-Lepage et les communautés bretonnes. En gagnant votre procès, vous avez créé une première mondiale en droit de l'environnement qui a ouvert la voie à la protection renforcée des communautés victimes de pollution grave. Vous avez aussi participé à l'affaire Erika et Grande Sainte, qui sont d'autres succès remportés par le cabinet Hugues-Lepage et qui ont marqué le droit de l'environnement. Vous avez aussi des mandats locaux, puis vous devenez ministre de l'Environnement de 1995 à 1997. Et en tant que ministre, vous menez notamment à bien le projet de loi LOR concernant la pollution atmosphérique et l'utilisation rationnelle de l'énergie. Vous obtenez aussi le non-redémarrage de réacteurs nucléaires Superphénix et un moratoire sur les OGM. À la suite de votre carrière politique, vous êtes aussi vice-présidente de la Commission de la santé et de l'environnement du Parlement européen et vous fondez en 2014 le parti écologiste Rassemblement citoyen, le CAP 21, que vous présidez toujours aujourd'hui. De 1975 à 2011, vous êtes également à côté de toutes ces activités professionnelles enseignantes, et vous êtes l'auteur d'une trentaine d'ouvrages et de plusieurs centaines d'articles sur le droit de l'environnement et des essais politiques. De même, vous avez une vie active et une vie associative très active, notamment avec l'Association des Amis de la Déclaration universelle des droits de l'humanité, pour laquelle vous avez répondu à une commande du président de la République. Vous avez aussi créé et vous présidez depuis 2015 Women Engage for a Common Future, l'association Justice Pesticides et les mouvements des entrepreneurs de la nouvelle économie. Aujourd'hui, nous allons parler avec vous des institutions judiciaires européennes, des générations futures et tout ça dans la perspective de l'avis consultatif de la Cour internationale de justice. Encore une fois, merci beaucoup pour votre présence, Madame Corinne Lepage. Je vous laisse la parole.
Merci beaucoup pour ce rappel d'un parcours très long, parce que, comme vous l'avez rappelé, je vais bientôt avoir 50 ans de barreau quand même. Donc, un demi-siècle. Voilà, et qui a été effectivement très largement consacré aux questions environnementales dont il faut bien mesurer combien elles ont changé dans ce laps de temps. Aujourd'hui, les affaires environnementales, et vous en êtes un parfait exemple, c'est des affaires planétaires. Il y a 40 ans, c'était des affaires locales. Même si l'Amoco Cadiz concernait un grand nombre de collectivités, c'était jamais que le littoral breton français. Ce qui est quand même, à l'échelle de la planète, un petit morceau. Bon. Voilà. Donc, je pense que les actions que vous avez engagées sont vraiment extrêmement importantes parce que ces avis consultatifs sont extrêmement utiles dans les combats qui sont menés devant les enceintes judiciaires. Ce que je voudrais dire d'abord, c'est que la justice climatique que nous sommes tous en train de construire, chacun avec nos moyens, chacun avec nos traditions juridiques qui ne sont pas les mêmes, il faut la concevoir un peu comme un escalier. Imaginez un escalier dans lequel chaque décision rendue dans le monde serait une marche d'un escalier vers la reconnaissance planétaire de la justice climatique. Nous sommes en train de construire un droit international sur des bases qui n'ont strictement rien à voir avec le droit international comme on l'a conçu jusqu'à présent. Jusqu'à présent, vous aviez des conventions internationales et devant la Cour internationale de justice, les États allaient s'expliquer sur l'application ou la non-application de ces conventions. La particularité de la justice climatique, c'est en fait un droit national, ce sont des décisions nationales à portée internationale. C'est-à-dire que chaque décision rendue, et c'est la même chose pour les avis consultatifs, est un outil supplémentaire pour les contentieux qui soit sont en cours, soit démarrent. Et donc, il faut concevoir ça comme un tout. Et ça, je crois que c'est très important de le prendre en considération. Sur le sujet des générations futures, il y a une décision fondamentale en Europe, qui est la décision rendue par la Cour de Karlsruhe en 2021, pour laquelle Émilie Gaillard avait la première, je crois, organisé un séminaire hybride pour en discuter du contenu et de l'importance. C'est, à ma connaissance en Europe, la première décision qui reconnaît effectivement l'inconstitutionnalité d'une loi, qui était la loi climat allemande, au motif que, dans la mesure où cette loi n'avait pas intégré des mesures à prendre destinées à augmenter la capacité résiduelle de CO2 disponible pour les Allemands après 2030, cette loi portait atteinte aux droits et libertés fondamentales des gens qui vivraient en 2030. Que ce soit les gens d'aujourd'hui qui étaient les requérants, et qui auraient donc 10 ans de plus, ou que ce soit les générations futures, parce que il y avait dans les obligations mises à la charge des États une obligation de prévention qui, en l'espèce, n'avait pas été respectée. C'était un arrêt qui est vraiment tout à fait fondamental et probablement un des plus progressistes qui ait été rendu dans le monde à ce jour. Il se trouve que je fais cette année un cours sur la justice climatique à Sciences Po Paris, donc j'ai à peu près relu toutes les décisions, alors je ne vais pas dire toutes parce qu'il y en a probablement que j'ai passé à l'as, mais enfin un très 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 grand nombre de décisions rendues dans le monde. Je pense que c'est une des plus importantes, même si on trouve des décisions très importantes au Pakistan avec l'arrêt Legari, on trouve des décisions importantes au Brésil, on en trouve aux États-Unis, on en trouve dans beaucoup de pays du monde, mais celle-là, elle est au Nigeria, il y a un arrêt de la Cour suprême nigériane qui est très progressiste. Mais là, on est sur le sujet spécifique des générations futures, sur quelque chose d'extrêmement important. Je dirais que le contentieux climatique, aujourd'hui, il se heurte à deux difficultés majeures. Le premier, c'est celui de la recevabilité des actions qui sont lancées devant les tribunaux. Pourquoi ? C'est très simple à comprendre. Les tribunaux de tous les pays du monde proscrivent ce que l'on appelle l'action popularis, c'est-à-dire l'action menée par des gens qui n'ont pas un intérêt direct et un préjudice direct lésé. Alors, la jurisprudence peut être plus ou moins souple, mais le principe est le même dans pratiquement toutes les juridictions, et pour une raison très simple, c'est que si ce n'était pas le cas et si n'importe qui pouvait attaquer n'importe quoi, le système ne fonctionnerait plus. Il serait noyé. Voilà. Donc, le refus de l'action popularis est quelque chose de tout à fait essentiel. Et effectivement, les actions climatiques menées par les associations et par les individus se heurtent à cette difficulté pour des raisons différentes. Parce qu'ils ne peuvent pas, en fait, invoquer les mêmes bases. Je m'explique. Une association de défense de l'environnement est recevable dans beaucoup de pays du monde à agir. Mais à agir pourquoi ? À agir pour obtenir que des États respectent leurs obligations, que ce soit celles des accords de Paris ou que ce soit des obligations nationales. En revanche, une personne morale, c'est-à-dire une association, ne peut pas se prévaloir du droit à la vie et du droit à une vie familiale, une vie privée familiale correcte, tout simplement parce qu'elle n'est pas une personne physique. Donc son intégrité physique n'est pas en cause. Autrement dit, que ce soit sur la Convention interaméricaine des droits de l'homme, que ce soit sur la Convention européenne des droits de l'homme, vous trouvez des décisions qui ne marchent pas pour les associations. En revanche, ce qui peut marcher pour des associations, ce sont les règles d'ordre général. Donc, on a une difficulté. C'est plus facile pour les associations, mais elles ne peuvent pas attaquer la même chose et se fonder sur la même chose. Et dans la loi, la décision de Karlsruhe dont je parlais tout à l'heure, dans cette décision, la Cour constitutionnelle a admis la recevabilité des individus, rejeté le recours des associations. À l'inverse, dans une décision qui pour l'instant est frappée d'appel, mais qui est très intéressante, qui est une décision rendue en Belgique qui s'appelle Klimaatzaak, donc à la demande d'une association, la juridiction belge a admis les uns et les autres. Voilà. Donc, on a un problème de recevabilité. Et il est aujourd'hui tout à fait prégnant dans une affaire que je vais avoir l'honneur de défendre dans 15 jours devant la Cour européenne des droits de l'homme et qui est la première du genre. Nous avons deux affaires qui viennent le même jour. L'affaire dite des grands-mères suisses, des Signorinnen, et l'affaire d'Amiens Carême, qui toutes les deux posent avant tout un problème de recevabilité. En quoi des grands-mères suisses de plus de 75 ans auraient-elles un droit que le juge suisse lui a dénié, puisque la décision a été de rejet, à attaquer la Suisse pour avoir pas pris suffisamment de décisions positives et avoir ainsi attenté à leur droit à la vie et à une vie familiale normale? En quoi sont-elles plus concernées que des gens qui ont 20 ans et qui vont avoir leur vie mise en cause par les décisions qui ne sont pas prises aujourd'hui? Voilà. Donc, est-ce qu'il y a un droit lésé spécifique? Damien Carême, je dirais que c'est encore plus difficile. En quoi un citoyen qui vit dans une commune qui est menacée d'être complètement recouverte par les eaux, a-t-il un droit personnel lésé plus que tous les habitants de toutes les communes qui sont dans des situations comparables? Et donc, vous voyez que défendre l'intérêt lésé est très difficile. Ça se plaide, bien sûr, et j'espère bien le gagner, mais c'est très difficile. C'est très difficile parce que, effectivement, la jurisprudence est beaucoup plus restrictive que cela. Alors, il y a des décisions intéressantes, il y en a aux États-Unis, Klimaatzaak, dont je parlais tout à l'heure, qui disent que ce n'est pas parce que beaucoup de personnes souffrent d'un préjudice équivalent que le préjudice n'existe pas pour autant, que la personne n'est pas pour autant lésée. Et ça s'entend, ça se défend. Mais vous voyez bien qu'on flirte avec l'action populaire. Et donc, la question qui se pose derrière, c'est est-ce que, quand on est en face d'une action climatique qui en fait œuvre pour l'ensemble des collectivités, cette restriction au droit doit-elle demeurer? Voilà, c'est un premier sujet, mais il n'est pas petit. Il n'est pas petit parce qu'il y a beaucoup d'actions qui ont été jugées recevables dans le monde. La deuxième question qui se pose, c'est effectivement celle des bases légales. Quel est le droit que l'on peut revendiquer pour exiger d'un État qu'il agisse et qu'il soit dans une démarche de prévention de ses ressortissants? Et jusqu'où? Là, les bases légales peuvent varier, mais ce qui est très intéressant dans les avis consultatifs, dans les résolutions de l'ONU, la même chose, mais je pense aux avis qui ont été rendus par la Commission interaméricaine des droits de l'homme, où il y a des avis qui sont vraiment très intéressants. Les droits humains sont retenus comme étant une base. Question subsidiaire, c'est quoi les droits humains dans ce domaine? Autrement dit, est-ce que, et c'est la question qui va être posée à Strasbourg le 29 mars, est-ce qu'il y a parmi les droits humains le droit à un climat stable? Autrement dit, ce préalable à une vie, et pour le Vanuatu, à la vie tout court. Pour des zones moins périlleuses, à une vie décente, digne, qui est soumise à une exigence de climat stable. Est-ce que ce droit a comme préalable précisément ce droit à un climat stable? Est-ce que ce droit à un climat stable fait partie désormais des droits humains ou pas? Et dans le cas particulier qui vous occupe et qui est quand même très symptomatique, enfin très, comment dire, c'est pas, le mot symptomatique n'est pas juste, qui est très symbolique, c'est que dans cette dimension-là, ce n'est pas seulement la vie de personnes, la vie d'une communauté, mais c'est tout un ensemble culturel qui disparaît. C'est une langue, c'est des habitudes, c'est des modes de vie, c'est des traditions culturelles qui ne pourront plus vivre. Et donc, derrière cela, il y a effectivement la question posée du droit à pouvoir persévérer, non pas seulement dans son être, ou tout au moins dans son être collectif, c'est-à-dire dans ce qu'une collectivité représente en termes culturels, en termes linguistiques, en termes de tout ce que l'on peut imaginer. Ça, c'est quand même très intéressant parce que ça va beaucoup plus loin que les droits individuels. Et on retrouve un sujet qui, personnellement, m'est cher, qui est celui de la Déclaration universelle des droits et devoirs de l'humanité, à laquelle j'appelle tout un chacun à souscrire en allant sur notre site droitshumanité.fr, qui est en français et en anglais, vous trouverez facilement, parce que la déclaration à laquelle Émilie Gaillard a beaucoup contribué et nous aide aujourd'hui beaucoup, parce que ce texte, justement, transcende en quelque sorte l'individu par la reconnaissance de droits de l'humanité. Et c'est bien de ça dont il s'agit aujourd'hui. C'est de reconnaître que l'humanité a droit de persévérer dans son être, comme le vivant a le droit de persévérer dans son être, ce qui crée des obligations correspondantes. Et ce n'est pas seulement un droit individuel, c'est bien un droit collectif dont il s'agit. Et ce droit collectif est nécessaire pour assurer la pérennité des droits individuels. Et ça, c'est très bien expliqué dans l'arrêt de la Cour de Karlsruhe. La Cour de Karlsruhe, elle explique très bien qu'à partir de 2030, comme il y aura de moins en moins de possibilités d'utiliser le carbone, forcément, les libertés individuelles vont se restreindre. Forcément, le droit de propriété va se restreindre. Et donc, les droits et libertés fondamentales garantis par la Constitution allemande seront mis en péril. Et donc, vous voyez bien qu'on passe d'une idée de droit individuel à une idée de droit collectif, de devoirs individuels à une idée de devoirs collectifs. Et donc, je terminerai là-dessus parce que je ne veux pas être trop longue, et je pense que j'ai déjà été trop. La question qui est posée au Vanuatu, c'est, je dirais, le sas entre les deux. C'est-à-dire qu'on n'est pas tout à fait dans les droits de l'humanité parce que c'est un pays, mais on n'est plus du tout dans les droits individuels. Et reconnaître les droits du Vanuatu, pour moi, c'est la première marche vers une reconnaissance des droits de l'humanité. Et donc, je pense que c'est extrêmement important, à la fois sur un plan conceptuel et sur un plan politique. Voilà ce que je voulais vous dire en vous félicitant du travail que vous faites.
Merci beaucoup pour toutes ces informations. On aurait tellement d'axes pour vous relancer que ça en devient vertigineux. L'important aussi, c'est qu'on a un échange avec l'audience, donc j'ai vu qu'il y avait deux questions. Je me permets juste de vous relancer sur cette idée que on va quand même demander dans l'avis consultatif la responsabilité des États vis-à-vis du droit des générations futures. Est-ce que pour vous, c'est une grande première, c'est significatif, ou est-ce que ça a été auparavant déjà utilisé dans la rhétorique juridique? Est-ce que vous pensez que ça va apporter des bouleversements, ou est-ce que c'est juste une continuation d'affaires qui ont évoqué ce droit?
C'est une excellente question. D'abord, je n'ai pas la science universelle, donc je ne suis pas capable de vous affirmer clairement. Ça n'a jamais été jugé nulle part, j'en sais rien. Franchement, je ne sais pas. Je ne crois pas. Est-ce que c'est révolutionnaire? Oui. Est-ce que c'est totalement nouveau? Non. Pourquoi? Vous avez déjà de la jurisprudence de la Cour internationale de justice qui reconnaît la responsabilité d'un État pour des pollutions transfrontières. Un État qui va polluer le voisin, il est responsable. C'est la fondée du trail. Émilie connaît ça 42 fois mieux que moi. C'est un arrêt vieux, qui est, je dirais, 1929, un truc comme ça. Et il y a eu récemment une décision à propos d'une guerre. Je ne sais plus où c'est, parce que malheureusement, il y en a tant sur la planète que je ne sais plus, mais vous trouverez la décision qui condamne un pays qui, dans un cadre belliqueux, a pollué le voisin. Donc, si vous voulez l'idée qu'un pays est responsable des pollutions qu'il crée aux autres, ce n'est pas tout à fait nouveau. En revanche, ce qui est très nouveau, c'est de l'appliquer au climat. donc d'une espèce de pollution dont tout le monde est responsable, mais de manière différenciée. Voilà. Et donc ça, c'est tout à fait nouveau et je trouve que c'est vraiment extrêmement intéressant.
Oui, c'est très, très, très intéressant. On abordera d'ailleurs avec Yann plus tard cette question des différences de responsabilité en termes de pollution et ce que ça implique après comme conséquence. Donc, super, super intéressant. Je vois effectivement, comme Altinaï disait, qu'on a des petites questions dans la box à questions. Notamment, Émilie, vous vouliez répondre concernant un commentaire sur l'avis consultatif.
Vous pouvez laisser la parole à Corinne.
Non, vas-y, Émilie.
En fait, c'était une personne qui avait juste bonjour Corinne, ravie de te voir, merci d'être là. Non, une personne avait juste réagi en disant qu'elle n'était pas d'accord avec l'affirmation selon laquelle un avis consultatif est un jugement et qu'une décision de justice à la limite, mais il ne s'agit pas d'une formation de jugement de la CIJ. Oui, tout à fait, on est tout à fait d'accord. Des fois, quand on est à l'oral, les étudiants sont peut-être allés un peu vite, mais c'est vrai. Voilà, c'était pas une grande
Non, c'est vrai, un avis n'est pas un jugement, mais un avis peut avoir beaucoup d'incidence. Quand nous avons, avec Émilie, participé au tribunal Monsanto, alors qui était encore plus, je dirais, contestable, entre guillemets, parce que c'est un tribunal qu'on a inventé de toutes pièces, hein, soyons tout à fait clairs, eh bien, l'avis en droit rendu par le tribunal Monsanto, qui était quand même des magistrats, il ne faut pas rigoler, mais enfin, c'était une grande première, ça, de faire un truc pareil. C'est quelque chose qui a été très utile en droit, alors que ça n'avait une valeur juridique vraiment très minime à comparer avec l'avis juridique rendu par une autorité comme la Cour internationale de justice ou même des commissions des droits de l'homme diverses et variées qui ont eu à se prononcer et dont les avis sont régulièrement utilisés par toute une série de procédures.
Alors, on a une deuxième question sur notamment, est-ce que l'affaire Urgenda des Pays-Bas n'aurait pas eu une incidence plus importante que l'arrêt de la Cour constitutionnelle allemande en matière climatique, selon vous, Madame Lepage?
Oui et non, mais on ne parle pas de la même chose. Sur le plan climatique, il est clair que l'arrêt fondamental, c'est Urgenda. C'est lui qui a tout lancé. C'est lui qui a tout lancé. Avec, en fait, l'arrêt Urgenda, il y en a 3. Hein. Il y a un jugement, il y a un arrêt de cour d'appel et un arrêt de la Cour suprême des Pays-Bas, qui sont tous les 3 concordants sur la décision finale avec des nuances sur le fond. C'est ce qui a tout lancé. C'est indéniable. Mais l'arrêt Urgenda ne traite pas de la question des générations futures. Si j'ai souligné l'importance de Karlsruhe, c'est parce que c'est à ma connaissance le premier qui traite directement de la question des générations futures. Mais Urgenda est fondamental et tout le monde l'utilise, Urgenda. J'ai même vu, je vais vous faire rigoler, un jugement ou un arrêt, je ne sais plus, d'une cour australienne à propos d'une mine de charbon qui se réfère à Urgenda et à la Convention européenne des droits de l'homme. On est en Australie quand même. Hein. Donc l'applicabilité de la Convention européenne des droits de l'homme en Australie, moi je veux bien, mais enfin c'est un peu loin quand même. Vous voyez? Donc, et là on retrouve l'image que j'avais tout à l'heure des marches d'escalier. C'est-à-dire quand un truc intéressant est jugé quelque part, et vous savez que le Sabine Center recense toutes les décisions qui sont rendues dans le monde, eh bien c'est utilisé par les autres.
Alors, j'en profite tant qu'il n'y a pas d'autres questions parce que moi j'en ai plein à vous poser. Vous avez dit tout à l'heure que les décisions nationales étaient portées à l'international et que c'est comme ça aussi qu'on avançait dans cet escalier. Là, c'est un procédé totalement inverse avec l'avis consultatif. C'est quand même la plus haute cour au niveau international qui peut rendre un avis. Est-ce que vous pensez que les juges, par exemple européens au niveau régional ou même les juges au niveau national français le prendront en compte? Est-ce que ça s'est déjà vu? Dans quelle manière le dialogue des juges pourrait fonctionner par cet avis consultatif?
Alors, je vais vous dire, il y a le fait et le droit, à mes yeux. En droit, non. C'est un avis de la Cour internationale de justice, qui est un avis qui concerne le Vanuatu. Il peut y avoir des grands principes dedans, c'est très bien. Si ça rentre dans le cadre d'une question posée à un tribunal ou une cour française ou européenne, ça viendra dans le jeu. Sinon, non. Mais, il y a aujourd'hui une espèce de, comment dire, je dirais pas de concurrence, mais de course lancée entre les cours suprêmes du monde sur la question climatique. C'est-à-dire qu'il y a cette prise de conscience par la société civile de l'urgence et de la gravité de la situation et le constat partagé avec les juges qu'en fait, il ne se passe pas grand-chose. Et que donc, comme il faut bien que quelqu'un fasse quelque chose, c'est cette espèce d'alliance inédite et non, comment dire, non exprimée entre société civile et juges qui fait effectivement que les juges veulent avancer. Et les rencontres entre magistrats, les explications qui sont données par des cours qui rendent des décisions au Sabine Center. Moi, j'ai assisté à une conférence de presse donnée par le Conseil d'État quand a été rendue l'arrêt Grande-Sainte en 2020, qui était une grande innovation. J'en ai pas parlé parce que il y avait beaucoup de choses à dire. J'aurais pu parler aussi de l'affaire du siècle et de la responsabilité de l'État pour carence dans le climat, mais j'avais beaucoup d'autres choses à vous dire, donc je ne peux pas parler de tout. C'est la première fois de ma vie que je voyais le Conseil d'État aller faire une conférence par vidéo à l'université de Yale devant 350 juristes du monde entier pour expliquer ce qu'avait fait le Conseil d'État et s'en glorifier en disant on est vachement bon, en gros. Et donc il y a cette volonté d'être les juges, les cours suprêmes qui apportent quelque chose à la justice climatique dans le monde, qui s'affirme et qui s'affirme de plus en plus. Donc oui, de ce chef-là, quelque part, on ne peut pas faire moins bien que le précédent. Quand je dis le précédent, c'est la cour précédente. Et j'en reviens à mon histoire d'escalier.
Eh ben, merci beaucoup, Madame Lepage. Je crois que vous avez des impératifs.
Oui, j'avais dit à Émilie que j'étais prise à 2h15 parce que tout ça est venu avant-hier. Donc, j'avais un agenda à tenir. Mais en tout cas, merci, bravo. Et je suis tout à fait disponible si vous avez besoin d'un coup de main juridique pour cet avis consultatif. Moi, je suis tout à fait disponible. Il n'y a pas de problème. Et Émilie le sait. Voilà, merci.
Et on vous remercie
très belle
une
journée.
nouvelle fois pour votre présence et bonne journée à vous encore. Merci.
Au revoir.
Au revoir.
Alors merci beaucoup à Corinne Lepage pour cette intervention vraiment pertinente et vraiment passionnante. Maintenant, on va avoir une intervention de Madame Émilie Gaillard, ici présente. Donc, on va d'abord la présenter rapidement et après, on lui laissera la parole. Donc, Émilie Gaillard est maîtresse de conférences en droit privé à Sciences Po Rennes. Elle est co-directrice du pôle des risques à la MRSH et elle est aussi coordinatrice de la chaire Normandie pour la paix qui co-sponsorise cet événement. Donc, elle est une pionnière en droit des générations futures puisque dès 2008, elle publie une thèse intitulée Générations futures et droit privé vers un droit des générations futures, ouvrage qui a été primé par l'Académie des sciences morales et politiques. Donc, son travail est vraiment, permet l'émergence d'un nouveau paradigme juridique avec le droit des générations futures et elle travaille pour la reconnaissance de ce nouvel humanisme et aussi bien à travers l'espace que le temps, que entre les espèces et pour améliorer les conditions de vie de tout le monde. Donc, elle est aussi notre directrice de master à Sciences Po Rennes au campus des transitions et une formation qui est inédite en France et même dans le monde puisque c'est une des premières qui permet d'étudier spécifiquement ce droit des générations futures, qu'elle a été une des premières à formuler en France. Donc voilà, et elle a très récemment, elle publie beaucoup d'articles sur le transhumanisme en ce moment, et elle a aussi récemment co-dirigé un ouvrage avec David Foreman qui s'appelle Legal Actions for Future Generations. Et voilà. Je lui laisse la parole pour parler d'internormativité.
Oui, merci beaucoup Lolita, merci beaucoup Atinaï, je suis très très fière de vous. Je vous remercie beaucoup pour l'organisation de ce panel sur l'Europe. Je félicite aussi tout particulièrement Nicole Anne-Ponce qui a organisé avec tous ses autres collègues de l'Asie, du monde entier, toute la jeunesse, les différents co-sponsors de cet événement. Un événement plus qu'audacieux, il faut être jeune pour avoir l'audace d'organiser un panel de 12 heures d'affilée. Je regrette que Mireille Delmas-Martin ne soit pas là pour voir que si les jeunes sont capables de relever cette audace. Donc bravo, bravo d'organiser cela. Alors je voudrais, sans être dans des grands termes, j'avais réfléchi sur le terme d'internormativité il y a plusieurs années. Parce qu'en fait, on a le doyen Carbonnier en France, il faut savoir que c'est un grand professeur de droit qui a marqué le droit français tout particulièrement, qui avait complètement réformé la manière de penser la hiérarchie des normes en droit et il avait parlé de phénomène d'internormativité parce qu'il avait été audacieux pour un juriste français à dire qu'il y avait d'autres normes que le droit qui étaient appelées à régir la vie en société. Et puis, ce concept d'internormativité, je trouve, quand on l'applique au droit lui-même, il peut nous permettre de nommer précisément ce que Corinne vient de parler de marche d'escalier. Quand elle dit la Convention européenne des droits de l'homme invoquée en Australie, qu'est-ce que ça veut dire? Eh bien, ça veut dire que justement, il y a des phénomènes d'internormativité. On peut dire autrement que ce sont des phénomènes de fécondation multiple, d'inspiration. On est au-delà en fait de l'effectivité, on est au-delà de l'approche classique, traditionnelle du droit, assez fixiste, assez calqué sur le paradigme de l'État-nation, assez axé sur le principe de la hiérarchie des normes telle qu'elle a été imaginée par Kelsen. En fait, toutes les questions dont on va parler, que ce soit le climat, mais avant, hier, c'était le nucléaire, et de nouveau aujourd'hui, les risques existentiels auxquels nous faisons face, ce sont des risques qui sont à la fois menés à l'encontre des êtres humains, mais bien au-delà de l'intégrité de la planète, ici et maintenant, à travers les espèces, à travers le temps long, le temps écologique, y compris le temps de la planète. Donc, comme l'a dit très bien Corinne Lepage, elle a dit de son époque, les problèmes commençaient à être transfrontières, mais c'était quand même localisé. Et c'est là l'un des changements de paradigme majeurs, c'est que nous faisons face à des risques existentiels, nous avons besoin de transformer l'ensemble des sciences, et c'est déjà là, puisque le paradigme écologique s'inscrit dans toutes les sciences, observé dans les sciences dures, dans les sciences humaines. Lorsqu'un nouveau paradigme est présent dans l'ensemble des sciences et transforme la manière dont une société et les scientifiques voient les sciences, c'est la marque d'une révolution scientifique. Alors, il y a plusieurs récits actuellement à l'œuvre. Il n'y a pas que le récit de l'humanisme de l'avenir et environnementaliste qui plaide plutôt, et je me rallie à cet humanisme-là, à quelque chose de plus humble dans notre empreinte écologique. Il y a aussi d'autres récits qui visent à toujours modifier l'intégrité de la planète, comme c'est le cas avec les propositions de géo-ingénierie. Mais n'allons pas trop vite. Continuons sur l'internormativité. Lorsqu'on discutait avec Nicole en préalable à ce séminaire, elle disait « mais comment on va pouvoir intégrer dans nos ordres juridiques internes les solutions ou ces avis consultatifs qui vont être donnés un peu partout? Comment on va nommer cela ?» Et donc, je lui ai dit justement dans la chaire, c'est cette ligne 1.4 de recherche sur l'internormativité. On va pouvoir donner à voir des mouvements d'inspiration plus ou moins explicites. Et puis, il y a des mouvements d'inspiration et d'internormativité, je peux vous le donner pour participer et travailler avec eux, c'est un grand honneur. Il faut savoir que les juges de Cour suprême du monde entier se sont réunis dans le Global Judicial Institute, l'Institut global judiciaire, et les juges font partie donc d'un réseau, ont créé un réseau Internet où ils se partagent leurs décisions, et l'objectif est clair, c'est d'élever non seulement leur formation au droit de l'environnement, mais d'investir complètement ce champ du droit de l'environnement. Cela relève C'est une des sous-branches de la Commission de droit de l'environnement de l'Union internationale pour la conservation de la nature. Donc, il y a ces rencontres en présentiel entre ces juges des cours suprêmes qui vont savoir qu'est-ce qui se passe en Inde, qu'est-ce qui se passe en Amérique latine, qu'est-ce qui se passe en Europe, qu'est-ce qui se passe en Afrique. Et puis, cette internormativité, elle est accélérée à l'ère justement de l'ère numérique, puisque l'accès aux informations sont immédiates. Et cette internormativité, à mon avis, elle va être d'autant plus enrichissante pour accélérer ce grand processus de transformation qui est celle que j'appelle de mes voeux depuis aussi ma thèse, qui est l'entrée dans l'ère du droit transgénérationnel. Donc, avant moi, il y avait Edith Brunweiss, qui est la grande pionnière de l'équité intergénérationnelle, parce que dans les années 80, on sentait bien qu'on faisait des choses qui n'étaient pas normales. Donc, il y avait un problème d'équité entre les générations. La transformation que nous accompagnons aujourd'hui et qui est au cœur de Louvre Legal Actions for Future Generations, c'est de passer le pas d'après, qui est de dire il y a des droits fondamentaux transgénérationnels, il y a des devoirs fondamentaux à l'égard des générations futures, et c'est ça ce qu'apporte l'arrêt de Karlsruhe qui a été cité par Corinne Lepage, qui est effectivement l'un des premières cours constitutionnelles à l'affirmer. En Inde, il y a beaucoup de jurisprudence aussi qui reconnaît une approche transgénérationnelle des droits de l'homme. Donc ça, je le partagerai prochainement avec vous. Donc sur la généalogie des droits de l'homme, qu'est-ce qu'on pourrait dire? Eh bien qu'en fait, par rapport aussi, pour faire le lien avec Corinne Lepage, on va arriver maintenant à un stade où se pose plus que jamais la question de reconnaître les droits à l'humanité aux générations futures, mais en lien d'interdépendance avec son environnement, avec les autres espèces. Ça n'a pas de sens encore en XXIe siècle de penser relever le défi du risque climatique et même le droit de manière complètement séparée de la nature. Des fois, on a des moments de partage avec les étudiants et on se dit quand même, un jour viendra où on se dira mais quel manque, quelle arrogance l'être humain, l'humanité aura fait preuve que de croire et que d'agir comme si elle était seule sur cette planète, alors qu'il y a des millions d'espèces vivantes et que nous sommes tous interreliés. Un exemple simple, une bouffée sur 2 d'oxygène, merci aux océans, et la deuxième bouffée vient des forêts, avec toute la vie qu'il y a à l'intérieur. Donc on peut dire qu'il y a un momentum. Le momentum, c'est un peu cette... Alors, je ne sais pas si on peut parler de course de vitesse entre les cours. En tout cas, on voit bien que chacune veut et est investie, en fait, par la société civile, mais chaque juridiction est en train d'apporter sa petite pierre à un édifice absolument monumental. Et la question de l'internormativité va se poser avec une grande acuité, notamment au niveau européen. Jusqu'alors, au niveau européen, et donc on a plusieurs affaires actuellement pendantes devant la Cour européenne des droits de l'homme, dont celle Grande-Sainte, dont l'affaire Duarte. Et en fait, il va se poser la question de savoir comment on va arbitrer les règles qui vont être délivrées dans des décisions contentieuses et comment on va donner des ordres de priorité aux avis consultatifs. À mon sens, les avis consultatifs, c'est comme le droit international de l'environnement. Ça peut paraître originellement faible parce que plus ou moins de soft law, mais ça va être la plus grande force au final, surtout avec l'effet du passage du temps et le ralliement des nations et des sociétés civiles autour d'une vision fondamentale qui est la pérennité de la vie sur Terre. Ces avis consultatifs vont certainement se nourrir et se citer les uns les autres. On ne peut plus vivre dans un univers juridique où les uns et les autres vivent de manière séparée. Et c'était précisément le message de Mireille Delmas-Marty. Elle disait que le grand défi de notre siècle, c'était de passer des États solitaires à un paradigme d'État solidaire. Eh bien, je crois que cette vague mondiale des avis consultatifs est peut-être la mise en œuvre pour la première fois de l'apparition de ce paradigme d'État solidaire, où chacun, à divers niveaux de réalité, vont questionner leur juridiction suprême sur la question d'un risque existentiel, en l'espèce, le climat. Alors, je voudrais rendre hommage au juge Veera Mantri. au juge Viramantri qui nous a quittés et qui était juge à la Cour internationale de justice, car je pense que quelque part, il veille sur cette jeunesse qui porte cette campagne internationale. Le juge Viramantri avait écrit une opinion dissidente à une décision de justice sur les essais nucléaires, lorsqu'en 1973, la France avait repris ses essais nucléaires. Je vous passe les détails sur la procédure, ça a été classé. Mais pour lui, déjà en 1973, et il a répété en 1995, la Cour internationale de justice est la cour qui est la plus légitime à reconnaître les droits des générations futures. Elle dit la chose suivante. Alors, je cite le juge Viramantri, il dit que la Cour internationale de justice doit transformer en obligation juridique l'obligation morale de garder la planète au profit des générations futures. Il a beaucoup de belles phrases. Je vous invite à lire ce qu'il dit. Il dit, si un État doit protéger sa population, il a forcément le devoir de protéger aussi les générations futures. Je vous rappelle qu'un État de droit, et surtout un État de droit environnemental, doit assurer que vous tous, vous puissiez bénéficier de la pleine jouissance de vos droits et libertés fondamentales. Il y a également donc la question des droits des générations futures. Elle a été soulevée plusieurs fois par M. Viramantri devant la Cour internationale de justice. Je ne peux pas tout lire, mais pour lui, il a répété en 1994, la Cour internationale de justice en tant qu'organe judiciaire principal des Nations unies est habilitée plus que tout autre tribunal à dire et à appliquer le droit international avec l'autorité qui est la sienne. Elle doit, dans sa jurisprudence, reconnaître dûment les droits des générations futures. Et donc, je pense que le juge Viramantri, quelque part, sera certainement à veiller et à regarder la suite de cette affaire. Et au final, quand vous regardez la marche de l'histoire, elle a une certaine logique. On ne peut pas reconnaître les droits des générations futures avant ceux de l'humanité, sachant que les droits des générations futures sont forcément pas anthropocentriques. Ils sont forcément en lien d'interdépendance avec la nature. On ne peut pas reconnaître les droits de l'humanité avant de reconnaître les droits de l'homme et de la seconde génération, de la première génération. Donc, tout se fait dans un bon ordre. Est-ce que je suis dans les temps, Lolita?
Vous l'êtes. Parfait.
Une dernière chose que j'aurais voulu ajouter, c'est de dire toujours dans l'idée et en écho à ce que disait Corinne, la dynamique, elle est lancée en fait. Et ce que je vous disais, c'est que ces avis consultatifs vont forcément se renforcer les uns les autres. Là où il y aura un problème d'internormativité, c'est s'il y a vraiment une contradiction frontale. Ça, c'est un risque. C'est effectivement un risque lorsqu'on saisit beaucoup de juridictions. Mais le dialogue des juges, ou en tout cas cette observation mutuelle des juges, dans un contexte quand même où l'ONU a adopté, que ce soit à Genève ou à New York, des résolutions qui reconnaissent le droit à un environnement sain, durable, font que la grande marche de l'histoire de ce droit de l'Anthropocène, à mon avis, elle est clairement visible, elle est clairement lancée. Sinon, l'effet cliquet, ce serait le principe de non-régression qui a tant été si bien formulé par le professeur Michel Prieur. Donc, à voir quelles sont les affaires à suivre. Il y a effectivement un risque, à force de trop saisir, peut-être ce serait affaiblir la puissance de ce mouvement. Et d'un autre côté, je pense que par la voie de l'avis consultatif, tout va se fédérer et créer des synergies par-delà la diversité des cultures juridiques. Dernier message, on raisonne encore beaucoup à travers nos paradigmes d'État-nation, à travers nos représentations juridiques traditionnelles. Je tiens à faire le porte-voix des peuples autochtones qui demandent à être davantage associés, qui le sont davantage, de plus en plus. Mais qui de mieux que les peuples autochtones qui préservent plus de 80% de la biodiversité majeure dans le monde pour aussi apporter leur analyse, que ce soit dans des amicus curiae, que ce soit dans le cadre de ces procédures. Je voudrais conclure en me faisant porte-voix de cet appel. Je vous remercie pour votre attention.
Merci beaucoup, Madame Gaillard, pour cette présentation qui nous amène à penser le droit de manière beaucoup plus complexe que celle dont ordinairement on a le réflexe de le penser. Je pense que l'intervention de Madame Lepage nous a amené dans des questions très techniques de contentieux et la vôtre nous permet de prendre un peu plus de recul sur la révolution qui est en cours et cette idée que le droit doit aussi évoluer dans sa doctrine et dans la façon de se penser lui-même. Et pour cela, vous êtes une des pionnières pour remettre un peu tout cela en dynamique constamment. Avec le droit de la nature, mais le droit des générations futures. Merci beaucoup d'être présente aujourd'hui avec nous parce qu'on sait que, que vous avez pris sur votre temps libre et on vous remercie beaucoup. On va vous libérer et je vais laisser tout de suite la parole à Lolita pour notre troisième intervenant. Et je vous souhaite une bonne après-midi, Madame Gaillard.
Toutes mes félicitations, je suis très, 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 très fière de vous. Merci d'être vous. Au revoir.
Au revoir.
Merci beaucoup. Donc, encore un grand merci à Émilie pour cette présentation qui était vraiment très, très passionnante. Maintenant, on va passer à notre troisième intervenant, le docteur Yann Robiou-Dupont. Donc, je vais encore une fois faire une présentation rapide avant de lui laisser la place. Le docteur Yann Robiou-Dupont, il est chercheur. Il travaille sur la quantification de l'ambition des pays et la justice des États en termes de réduction des gaz à effet de serre. Donc, il a été conseiller scientifique pour plusieurs actions en justice, notamment auprès de la CEDH ou dans le cadre de l'affaire Urgenda. Donc, comme je l'ai dit, son travail académique s'intéresse à cette quantification de la justice et donc à mesurer cette ambition internationale des États, notamment au regard des accords de Paris. Donc, concrètement, il calcule combien doit faire chaque État, étant donné sa richesse, sa responsabilité historique, ses capacités financières. Donc, ces travaux ont été publiés dans Nature Climate Change, Nature Communications, et sont aussi utilisés par le Royaume-Uni pour définir ses objectifs net zéro et ses objectifs 2030. Ces travaux sont aussi utilisés dans l'action en cours devant la CEDH au nom des enfants portugais. Et ces travaux ont également servi en partenariat avec les pays vulnérables du CVF, dont fait partie le Vanuatu, pour présenter à la COP27, qui a eu lieu il n'y a pas si longtemps. Et ces travaux ont permis de montrer l'insuffisance des ambitions de beaucoup d'États du G20. Donc, des travaux qui vont nous permettre d'aborder ces responsabilités communes, mais différenciées des États par rapport à l'urgence climatique et donc, voilà, la mise en pratique qui pourrait aboutir grâce à l'avis consultatif. Donc, je laisse la place à notre expert. Je crois savoir que vous avez un PowerPoint. Est-ce que vous êtes en capacité de partager votre écran ou dois-je le faire?
Non, ça devrait marcher. Bonjour et merci beaucoup. Ça devrait marcher. Est-ce que vous arrivez à le voir?
Oui, ça fonctionne. On voit votre PowerPoint.
Ça fonctionne, sauf que je ne peux pas changer de slide. Je ne sais pas pourquoi je ne peux pas changer de slide. Je vais essayer avec le PDF. Ok, on va faire ça avec le PDF, du coup. Alors, merci beaucoup. Effectivement, je ne sais pas quelle audience il y a et si c'est surtout des juristes, mais c'est vrai que petit à petit, j'ai commencé à avoir l'habitude de travailler aussi avec des juristes. Donc, désolé pour les francophones, les slides sont en anglais, mais je vais traduire au fur et à mesure. Moi, mon travail s'inscrit dans une chaîne de preuves scientifiques qu'on essaye d'apporter notamment pour informer les actions de justice, mais de manière générale, les actions aussi législatives de la société civile et les preneurs de décision. Mais donc, il y a plusieurs chaînes d'attribution en fait entre ce que les sociétés humaines font comme activité et les remèdes qu'elles peuvent apporter au regard des différents besoins de préservation, soit de la nature, soit de leur propre culture ou des individus, comme ça a été mentionné avant. Donc, il y a déjà un premier besoin qui est d'attribuer les impacts qu'on peut voir au changement climatique. Donc, ça peut être la montée du niveau de la mer, ça peut être des événements extrêmes. Après, une seconde étape, c'est d'attribuer le changement climatique aux activités humaines. Une troisième, c'est d'attribuer la responsabilité à un acteur en particulier. Donc, ça peut être un État, ça peut être une entreprise ou des groupes d'individus, et d'attribuer leur responsabilité dans leur contribution au changement climatique et donc en suivant la chaîne d'attribution aux impacts que l'on peut chercher à éviter ou à compenser. Et la dernière étape, c'est celle sur laquelle je travaille, c'est d'attribuer la responsabilité de remédier à la situation et en particulier, moi, dans mon travail, de réduire les émissions. Donc, la question, c'est combien chaque pays doit réduire ses émissions de gaz à effet de serre, par exemple. Donc, peut-être pour se relier de manière plus directe à l'action qui a été lancée par le Vanuatu et soutenue par vous. Donc, dans la résolution de la Cour européenne de justice, c'est particulièrement la question de la responsabilisation, des obligations des États sous le système légal international d'assurer la protection du système climatique, entre autres. Et donc, pour répondre à cette question, il y a tout un corpus de littérature scientifique dont je fais partie, mais je suis évidemment pas le seul à travailler là-dessus. Et ce qui est peut-être intéressant de votre point de vue de voir, c'est qu'une grande partie de ces travaux scientifiques ont été faits pour s'appliquer à l'accord de Paris, ou en tout cas sont cadrés par l'accord de Paris. Alors en particulier sur ma partie du travail, on va partir des objectifs de réduction de gaz à effet de serre qui sont présents dans l'accord de Paris, notamment au travers d'un objectif de limitation du réchauffement climatique, de limiter le réchauffement climatique à 1,5 degré, et bien dans ça de 2 degrés, d'arriver à des émissions nulles dans la deuxième moitié du siècle. Il faut savoir que l'entièreté de l'accord de Paris, dont les objectifs des émissions, mais pas seulement, tombent sous le besoin de refléter l'équité et le principe de responsabilités communes et différenciées et de capacités respectives à la lumière des différentes circonstances nationales des différents pays. Donc c'est un corpus d'études scientifiques qui est encadré par la volonté d'informer sur la mise en œuvre de l'accord de Paris. Après ça, ce qui est important aussi de voir, c'est que là, sur le travail que je fais, dont je vais présenter les résultats, on va travailler sur les objectifs climatiques que les États ont présentés, donc en particulier ici, les objectifs de réduction de gaz à effet de serre à 2030. Alors, ce ne sont pas les seuls objectifs climatiques qui existent, pas non plus de la part des États, mais ici, on va se focaliser là-dessus, mais évidemment, ce genre de travaux peut être appliqué d'une manière plus large. Donc, les États sont engagés à réduire des émissions ou à limiter l'augmentation de leurs émissions de gaz à effet de serre pour certains, au travers d'engagements pour 2030. Et dans ces engagements, ils doivent indiquer en quoi leurs engagements sont justes et ambitieux. Et ces deux termes sont accolés, notamment dans la requête des Nations Unies aux États, et ça montre que effectivement, en fait, l'équité, la justice au sens de l'équité, est la métrique de l'ambition. Donc, d'un point de vue de justice internationale, au sens des négociations, on va avoir des métriques qui vont être là partiellement pour refléter le point de vue des États, et qui peuvent être négociées de manière internationale. Et donc, il peut y avoir plusieurs vues. Et comme on est à des négociations entre États souverains, il peut y avoir plusieurs vues qui ne sont pas forcément les mêmes sur l'interprétation, par exemple, de l'article 2 de l'accord de Paris. Pour les cours de justice, ça va être un peu différent. La question, c'est pas comment rendre le monde plus juste, au sens plus équitable. La question, c'est vraiment celle de la légalité, comment s'assurer que tel ou tel acteur ou telle action est cohérente avec le cadre légal. Mais il se trouve que vu que la seule métrique de l'ambition, donc de la suffisance d'une action, par exemple, de réduction de gaz à effet de serre, est l'équité, on va retomber sur ces métriques d'équité qui conseillent donc à la fois les négociations internationales sur comment rendre le monde plus équitable, mais qui sont des métriques qui servent au progrès de négociation, et aussi celles qui sont donc les mêmes métriques qui vont informer sur la suffisance des objectifs. Ça, c'est un graphique qui provient du dernier rapport Emissions Gap Report des Nations Unies et qui montre que les politiques actuelles nous emmènent vers un réchauffement climatique de 2,8 degrés. Si on arrivait à atteindre collectivement les engagements actuels à 2030, on arriverait plutôt sur une trajectoire de 2,4 degrés, qui est donc insuffisante, mais qui est meilleure que les politiques actuelles. Donc ça montre qu'à l'échelle mondiale, les États ont tendance à ne pas respecter collectivement leurs engagements. Et on voit la courbe verte tout en bas qui serait là où on devrait être pour s'aligner avec un réchauffement climatique à 1,5 degré. Donc, on voit l'importance du fossé qui sépare les engagements actuels de la trajectoire qui nous mènerait vers une limitation du réchauffement climatique à 1,5 degré. Donc, on voit qu'il y a des engagements qui sont très insuffisants, et encore plus pour les politiques actuelles, et qui, tels qu'ils sont projetés, nous amèneraient vers un réchauffement climatique qui serait très dangereux, et pas que en plus pour les générations futures, mais surtout pour les générations futures, et qui, aussi d'un point de vue légal, évidemment, menace la réalisation de l'accord de Paris. Peut-être pour donner une rapide perspective, et Lolita, n'hésite pas à me dire si je prends trop de temps, voilà ce qui avait servi de base scientifique pour la décision d'Urgenda, c'est un tableau qui provient du 4e rapport du GIEC de 2007 et qui montre combien les pays de l'annexe 1, donc les pays développés dont font partie les Pays-Bas, doivent réduire leurs émissions de gaz à effet de serre, alors pour 2020 à l'époque, pour limiter le réchauffement climatique en dessous de 2 degrés. À l'époque, c'était le tableau. Et donc, c'était basé sur tout un tas d'études sur justement l'équité, ce corpus de sciences dont je parle, qui montre quelle est la contribution adéquate des pays selon leurs circonstances nationales. Et donc, le juge de l'affaire Urgenda avait décidé que les Pays-Bas devaient au moins être dans ce range-là, donc au moins être alignés avec 25% de réduction de gaz à effet de serre pour pouvoir considérer qu'ils faisaient leur part de la réduction, au moins selon un point de vue, de la réduction de gaz à effet de serre cohérente avec les objectifs internationaux, et donc ne menaçaient pas, ou en tout cas ne menaçaient pas de manière absolue la réalisation de cet objectif commun. Alors, 25%, c'était vraiment le minimum possible et ça ne fonctionnerait pas si chacun faisait le minimum possible, mais au moins ça pouvait être interprété comme que selon une perspective, avec 25%, ça pouvait être vu comme une contribution suffisante. Alors, pourquoi je dis une perspective? C'est parce que, comme je disais, il peut y en avoir plusieurs. Alors, on peut imaginer des métriques basées sur la responsabilité historique, sur la capacité financière, d'autres visant purement du égal par personne, ce qui n'est pas aligné avec l'article 2 de l'accord de Paris qui met en avant surtout la responsabilité historique et la capacité financière. Mais donc, nous, dans notre article et au travers d'études scientifiques, on a essayé de quantifier les différentes trajectoires que les pays pourraient avoir s'ils s'en tenaient à tel ou tel principe d'équité. On a fait un site web qui présente en fait l'ensemble de ces résultats. C'est indiqué en haut, Paris Equity Check. Et on voit là, par exemple, que pour l'Union européenne, l'ancien objectif, mais même le nouveau, est très insuffisant comparé à n'importe laquelle de ces visions de l'équité. Donc ça, c'était un papier qu'on a fait en 2017, mais comme on voit, ça pose malgré tout le problème que toutes ces études marchent si l'ensemble du monde choisit une vision d'équité et s'y tient. Mais si chacun prend la vision qui l'arrange, ça ne marche pas et c'est une partie du problème de ce qu'on a aux négociations internationales avec des positions de différents pays qui soutiennent différents points de vue de ce que serait juste et suffisant. Donc ça n'est pas résolu du point de vue des négociations, mais nous, dans un nouvel article, on a essayé de montrer qu'est-ce qui se passerait si on arrivait à combiner ces métriques, si chaque pays pouvait un peu prendre la métrique qui l'arrange, comme ça se passe aux Nations Unies, et comment on pourrait juger de l'ambition des États, quand même, malgré tout, dans cette situation-là. Et donc là, on voit le résultat de l'évaluation en termes de réchauffement climatique de l'ambition des engagements des différents pays. Alors, c'était la première série d'engagements. Là, on voit que c'est très rouge, beaucoup d'engagements très insuffisants. Et si on regarde les nouveaux engagements, on voit que ça s'est un peu éclairci, mais ça reste très insuffisant, tout comme on l'avait vu sur les trajectoires mondiales quelques slides auparavant. On voit aussi que les Vanuatu et beaucoup de pays du Sud ont des évaluations vertes, donc étant donné leurs conditions nationales, il ne serait pas juste de leur demander davantage. Par contre, il y a beaucoup de pays qui pourraient faire davantage. Donc voilà, après aussi sur le site ou même dans les documents légaux soumis par les pays, on peut voir comment les pays se justifient de la suffisance de leurs engagements. Alors souvent, c'est répondu de manière peu réplicable par exemple l'Union européenne qui dit simplement que vu que le monde doit arriver à zéro émission nulle dans la seconde moitié du XXIe siècle et que l'Union européenne prévoit d'y arriver d'ici 2050, c'est suffisant, sans décrire en quoi c'est suffisant ou réplicable pour l'ensemble des pays. Donc voilà, donc ce genre d'étude est utilisé dans les rapports du GIEC, dans les rapports de l'ONU, parfois par des gouvernements, beaucoup aussi entre les gouvernements lors des négociations internationales, mais aussi, et le GIEC l'a mis en avant dans son dernier rapport, le 6e rapport, que c'est vraiment ces études de ce que sont des parts justes de la part des États qui peuvent permettre de juger de l'ambition dans le cadre d'une action collective. Donc, pour voir combien chacun doit faire pour arriver à un objectif commun, il faut prendre en compte ces questions de justice et d'équité. Donc voilà, donc dans les développements à voir pour ce genre de littérature, il faudra aussi, et ça va venir, on travaille là-dessus, lier les questions de réduction de gaz à effet de serre à celles d'adaptation et de perte et préjudice. Enrichir notamment aussi la modélisation de l'équité, je vais en parler très très brièvement dans une slide, et aussi évaluer ce que serait une contribution économique, donc en termes d'aide climat internationale qui elles aussi sont très insuffisantes. Et aussi après le rôle des acteurs sous-nationaux et des acteurs tels que les entreprises. Donc sur les questions de finances internationales, nous, on va aussi travailler dessus pour vraiment voir pays par pays. Mais il y a déjà un papier qui est sorti là cette année dans Science qui montre que la finance qui est fournie par les pays d'Amérique du Nord et d'Europe sont très insuffisants comparés à ce qui serait juste. Et évidemment, ça menace la mise en œuvre des mesures de réduction de gaz à effet de serre dans les autres pays qui ont besoin de cette finance, qui en plus serait juste. Donc, ça menace la réalisation aussi de l'accord de Paris. Et enfin, je vais finir par cette slide qui est une slide issue du rapport que j'ai fait, notamment pour les pays du CVF, donc Climate Vulnerable Forum, qui est un groupe de 58 pays dont fait partie le Vanuatu, et qui a été soumis à la COP27, mais qu'on va soumettre aussi à comité de lecture, qui présente non pas simplement quelle trajectoire ou combien il faudrait qu'on réduise les émissions en partant d'aujourd'hui, par exemple en Europe pour faire une part juste, mais vraiment qui regarde quelles seraient les émissions, des niveaux d'émissions équitables aujourd'hui. Et on se rend compte qu'en fait, les émissions actuelles sont tellement injustes, on voit ici par exemple au milieu pour les pays du G7, qu'il faudrait, pour être juste, que leurs émissions actuelles soient vraiment une fraction, là c'est presque un 6e, un 7e de leurs émissions actuelles. Et de manière correspondante, par exemple, les pays du CVF, eux, si on appliquait une justice climatique, pourraient émettre bien plus que ce qu'ils émettent à l'heure actuelle. Et donc, ça veut dire que les pays du G7 doivent financer la réduction de gaz à effet de serre, notamment dans d'autres pays. Donc, évidemment, mettre en œuvre beaucoup de réductions d'émissions au sein de leur territoire, mais aussi aider les autres pays et financer. Et, une partie, c'est de la compensation, il y aura aussi de l'adaptation, mais aussi financer la transition climatique pour que les autres pays puissent réduire les émissions, même encore davantage que ce qui serait juste de leur demander s'ils le finançaient seuls. Et donc, cette finance internationale est vraiment aussi l'un des outils clés pour permettre la mise en œuvre de l'accord de Paris. Donc, merci, et n'hésitez pas si vous avez des questions.
Merci beaucoup, Dr Rovieux-Dupont, pour cette présentation. Ça nous paraissait particulièrement pertinent pour cette session Europe d'avoir un point de vue scientifique sur la question pour voir comment ça allait être saisi pour la suite des contentieux climatiques et notamment aussi un point de vue scientifique sur les différentes responsabilités, notamment les responsabilités européennes qui sont les plus importantes par rapport aux conséquences climatiques que le monde entier rencontre aujourd'hui, mais certains pays beaucoup plus que d'autres. Je ne sais pas si parmi l'audience, certaines personnes ont des questions. N'hésitez pas à mettre des questions dans le chat ou à prendre la parole, tout simplement. Sinon, moi, j'en ai quelques-unes. Je vous laisse écrire dans le chat si vous avez des questions. Pour ma part, je me demandais, du coup, vous parlez de vos travaux qui ont été utilisés et écoutés, présentés à la COP27. Et du coup, quel est votre point de vue scientifique sur un petit peu le seul résultat positif de la COP27 qui a été d'aller un petit peu plus loin sur ces responsabilités communes mais différenciées des pays?
Alors oui, je pense que c'est une avancée majeure et pas seulement pour des questions de perte et préjudice. Je pense que c'est une question aussi sine qua non pour beaucoup de pays et qui ne peuvent pas se permettre de ne rien obtenir sur ces questions-là. Et donc, quand bien même ce sont les pays qui souvent sont les plus menacés par le réchauffement climatique, on ne peut pas, je comprends tout à fait que ces pays ne puissent pas se contenter de faire leur maximum sur la réduction de gaz à effet de serre et satisfaire notamment les demandes des pays du Nord sur ces questions-là, sans s'assurer qu'ils puissent obtenir quelque chose sur les questions de perte et préjudice. Et ce sont les premières victimes du réchauffement climatique. Mais je comprends tout à fait ce conditionnement de la participation aux réductions de gaz à effet de serre, ou en tout cas de fournir davantage d'efforts sur ces questions-là, au fait qu'il y ait une certaine réparation qui puisse être faite. Donc, je pense que c'est un progrès qui va en permettre d'autres. C'est évidemment trop lent. Je pense que l'effet des marches qui était mentionné avant par Corinne Montage était tout à fait juste. La question, c'est aussi une question de vitesse. Donc, c'est un progrès. Et puis, il va effectivement aussi être important pour nous, scientifiques, de lier les questions d'équité en termes de réduction de gaz à effet de serre à celle d'adaptation et de préjudice. Elles ne sont pas formellement liées sous l'accord de Paris. Les manquements en termes de réduction de gaz à effet de serre ne sont pas liés à des questions de perte et préjudice, mais ça n'empêche pas qu'ils puissent être quantifiés par des scientifiques. Ça n'empêche pas qu'ils puissent faire l'objet de négociations futures. Ça n'empêche pas qu'ils puissent être utilisés par des cours de justice. Donc, on va travailler à essayer de fournir ces quantifications et éventuellement aussi voir et donner des métriques aussi pour reconnaître la participation, s'il y en a, quand il y en a, à ces fonds de perte et préjudice sur les questions d'adaptation et d'indiquer un peu aussi ce que seraient des participations juste soit au vu de la participation au réchauffement climatique actuel qui donne des impacts qu'on observe à l'heure actuelle, soit basé sur des capacités financières. Et après, bon, le message un peu de cette présentation, c'est de dire que des preuves scientifiques, des travaux scientifiques existent, mais évidemment, il ne faut pas oublier que tout ça, c'est du quantitatif, donc ça quantifie que ce qui est quantifiable, et qu'on peut avoir des modèles sur la perte et préjudice en termes d'impact économique. Si on détruit toute l'infrastructure d'une ville, ça a un certain coût. Si un pays est perdu, si un pays entier ou des îles entières doivent se délocaliser sur d'autres terres, ça, c'est pas des coûts qui peuvent être estimés. Et c'est aussi ça l'importance du droit aux générations futures, c'est d'aller au-delà du quantifiable et de la réparation.
Je suis tout à fait d'accord.
Beaucoup.
Ah, vas-y, Aditi.
C'était pour relancer sur une question du chat qu'on a eue. Alors, on sort un peu du cadre de l'Europe, mais c'est aussi tout l'intérêt de cette conférence, c'est de pouvoir aussi croiser les perceptions et les régions suivant nos intervenants. Elle est en anglais, mais je vais essayer de la traduire en français pour pour les personnes qui nous suivent en français. Est-ce que la Chine est perçue comme un pays qui doit donner de l'aide ou plutôt en recevoir concernant sa croissance? Est-ce qu'elle devrait faire plus pour réduire ses émissions?
Alors, il y a deux questions en une. Ce que montrent nos travaux, c'est que oui, la Chine, comme beaucoup d'autres pays, devrait en faire plus pour réduire ses émissions. Donc, clairement, et c'est ce qu'on a mis en avant dans nos études, mais aussi ce que des études chinoises ont mis en avant, notamment des études provenant de l'Université du pétrole en Chine, c'est que l'engagement de la Chine est très insuffisant. Après ça, au contraire de l'Europe qui est mal partie pour tenir ses engagements, qui va devoir faire beaucoup d'efforts simplement pour les tenir, la Chine risque de surperformer entre guillemets comparé à ses engagements, ou alors on peut aussi le voir en se disant que l'engagement de la Chine était très insuffisant comparé à ses capacités de réduction de gaz à effet de serre. Donc, l'évaluation scientifique montre que l'engagement est très insuffisant. A priori, la Chine va pouvoir avoir des émissions plus basses que cet engagement, donc meilleures. Mais a priori, ça resterait très insuffisant aussi. Donc, la Chine fait partie des pays qui doivent grandement améliorer leur trajectoire pour pouvoir se conformer avec un niveau de réduction qui sera en adéquation avec l'accord de Paris. Là, je commentais sur l'engagement à 2030. L'engagement d'émissions nulles, ou en tout cas de neutralité carbone pour 2060 pour la Chine, est lui beaucoup plus ambitieux. Alors après, c'est aussi une question de comment et comment la Chine va pouvoir le tenir, mais alors, cet engagement, par contre, lui est beaucoup plus ambitieux. Après, sur l'autre partie de la question, c'est une question qui est pas tranchée, mais il y a très peu d'études sur le sujet, donc j'invite Caroline Alcorso à aller voir l'étude que je montre à l'heure actuelle. C'est la dernière étude que je connais sur la question de l'évaluation de la finance. Elle est que régionale. Nos résultats préliminaires tendraient à montrer que la Chine devrait fournir plutôt de la finance qu'en recevoir, étant donné c'est une composante de deux choses en fait. C'est une composante de ce qui serait équitable de la part de la Chine à fournir en termes d'efforts. Et après, la deuxième composante, c'est quelle partie de cet effort doit être domestique et donc quelle partie doit être internationale. Et cette question de quelle partie doit être domestique, c'est pas lié à l'équité. L'équité, c'est quel effort doit fournir la Chine au total. C'est lié au coût relatif de réduction de gaz à effet de serre dans les différents pays. Et par exemple, dans des pays du Nord, les industries sont déjà très efficaces, donc c'est très cher de réduire davantage comparé à dans des pays du Sud. Et c'est pour ça que des pays du Nord vont devoir fournir de la finance parce que ce sera moins cher et donc plus efficace d'une manière globale de financer de la réduction de gaz à effet de serre dans d'autres pays, au moins pour avoir un rattrapage aussi en termes d'efficacité d'émissions sur les différentes technologies. Donc c'est un peu une composante des deux, mais pour la Chine, les travaux tentent à montrer que la Chine doit plutôt fournir de l'aide en plus de ce qu'elle doit faire en tant que contribution sur son sol, vraiment en termes de réduction de gaz à effet de serre.
Merci beaucoup pour cette réponse. Je ne sais pas si jamais il y a une dernière question de la part du chat ou de l'audience. Je regarde. Sinon, on va conclure là-dessus, je pense. En tout cas, merci beaucoup. Oui.
Non, mais désolée, je suis tatinée. Non, je me posais sincèrement la question de comment vous êtes reçu dans les contentieux climatiques, quelle écoute vous trouvez de la part des juges. Est-ce que vous pensez qu'il y a encore des biais entre le juridique et le scientifique, des voies d'amélioration est-ce que vous arrivez à parler un peu le même langage bon, visiblement, vu votre présentation, vous avez l'habitude, mais est-ce que, alors à l'échelle internationale, avec le GIEC, peut-être les institutions internationales ont plus d'habitude, mais au niveau régional ou même national, quelles difficultés vous avez été confrontés, même dans votre expérience, quelle amélioration vous avez pu voir au cours des années sur la superposition de ces deux sciences?
Alors oui, merci pour ces questions. Alors, quand j'écris, quand je participe à la rédaction de rapports scientifiques pour informer les cours, c'est aussi fait avec des juristes. Et donc, c'est vraiment un dialogue sur pas seulement montrer la littérature telle que je la montrerai à des collègues scientifiques, mais aussi d'essayer de trouver le langage, de voir comment c'est utile ou pas pour les questions de normes. Et la quantification qu'on fait et la façon dont on en discute entre scientifiques est une chose, celle dont on la présente lors de négociations internationales en est une autre parce qu'elle est relative à des discussions entre pays souverains. Après la discussion avec la société civile sur ce qui est juste, on a encore une autre. Et enfin, la discussion avec les juges ou les acteurs d'action en justice en est une autre. L'exemple, c'était vraiment d'essayer d'informer comment les États collectivement arriveraient à un monde plus juste dans la perspective d'une acceptabilité, donc pas forcément pour arriver à ce qui est le plus juste, mais en tout cas pour arriver à ce qui est acceptable, ce qui implique un certain degré d'équité entre les pays. C'est un peu comme ça qu'on phrase la discussion pour les Nations Unies, alors que, encore une fois, pour les questions d'action en justice, ça va être vraiment la question de l'applicabilité à des normes juridiques en place. Donc, le même résultat ou la même étude peut être présentée différemment, et ça ne veut pas dire que c'est de la manipulation, c'est vraiment de la discussion et de présenter la pertinence des différents travaux pour les cours, et donc ça, c'est issu d'un dialogue entre les scientifiques et les juristes.
Merci beaucoup pour cette réponse qui montre toute l'intérêt de croiser aussi un peu les domaines entre eux, parce qu'un juge ne peut être scientifique, mais un scientifique a aussi besoin de pouvoir parler avec des juges pour comprendre leurs besoins et leurs attentes par rapport à vos résultats et vos études, qui sont très intéressantes et nécessaires pour établir la responsabilité et l'équité à l'échelle internationale, notamment vis-à-vis du changement climatique. C'était une perspective très intéressante à avoir pour clôturer cette session européenne. Je pense qu'on a bien fait le tour avec une première présentation plutôt technique sur le droit, puis de Madame Colin Lepage, puis une intervention un peu plus générale sur les enjeux juridiques de la doctrine et le droit des générations futures, et de nouveau un peu plus technique et scientifique avec votre dernière intervention. Je pense qu'on peut conclure, Lolita. Je ne sais pas ce que tu en penses, mais alors, normalement, si Nicole est parmi nous, on est une demi-heure de pause. Hi, Nicole. Do we have 30 minutes of break, right?
That's right. So after this session, we'll have 30 minutes break and then we'll proceed with the session for Africa.
Ok. Donc, pour les Français, 30 minutes de pause après une session sur l'Afrique. Encore merci, Dr Yann Robiou, d'être venu avec nous et de nous avoir présenté vos travaux. À Émilie Gaillard et à Corinne Lepage d'avoir été présentes aussi parmi nous. À Nicole et à toute son équipe pour l'organisation de cette merveilleuse journée. Et avec Lolita, nous allons, nous déconnecter et laisser la suite.
Merci à vous, Marla.
Thank you so much, Lolita Alti. You did an amazing job. Congratulations. Enjoy the rest of your day. Have a good rest. You deserve it.
Hello. Thank you.
Okay. I think I am in.
Yes.
Can you see me? Can you hear me?
Yes, I can hear you, Abel. And greetings, everyone. We will take a few minutes.
I can't hear you, Kulekani. I can't hear you, Kulekani. Kulekani, I can't hear you.
Will we have to kick out Odd and the other interpreters if we bring in the interpreter for Africa?
No, I don't think so. No. Will they be leaving?
If Kulekane is speaking to us, but we cannot hear him. Kule, we cannot hear you.
Yes, I also cannot hear him. Probably I think something muted.
Because he's not mute.
No, Kulikani. Maybe you can try increasing your volume or log in and log out. Hello, everyone. Welcome for the session for Africa. We're just waiting for Kolikani to get back in because he has some issues with his mic. No, Kulikani. Sorry, we still can't hear you. You're using another device? Sorry, we can't hear you. Hi, Kulikani. Can you try? Oh, no. No, we can't hear you. Hi everyone, apologies. We have technical issues with our session moderator, Kulikani. His mic is not working, but we're working on that and we're asking him to log in and log out. But if not, and if it doesn't work out, then we'll just have to proceed. And I will do my best to moderate the session instead. But I would really would like to ask for your patience to hopefully fix this first and have Kulikani join us in a few minutes. Thank you. Kulikani.
Hi, colleagues.
We can hear you now.
Awesome,
Thank you
awesome.
so much. That works. So we can finally start our session for Africa, and I leave it to the competent, capable hands of Kulikani.
Thank you so much, Nicole, and thanks for coming in to assist. And we have taken so much time to sort out this issue. Colleagues, greetings from me. It is the afternoon here in South Africa, and I think in the whole of Africa. And as we are using the Central African time, good afternoon. My name is Kulekani Magwaza. I'm based in South Africa as the coordinator of the WYCJ Africa Front. And I also work with the youth NGOs here in South Africa and in the continent. So I've been listening to the other sessions since this morning from the South Asia and the rest of the colleagues who have done a lot of work in terms of facilitation and a very good discussion in terms of the climate change and the laws and human rights. So in this session, we will also have a very unique topic for ourselves here. And we have, fortunately, all of our speakers here, unfortunately or unfortunately, we don't know something there. All of our speakers are the youth, are in the youth category, and they are experts in their own field of studies, and also in their discipline in terms of, activism within the climate justice space. But before I welcome and introduce the speakers, I would like to send an apology on behalf of Mr. Ahmed Fathi from Cairo, Egypt. He sent me a message saying that he is having difficulties to join us. So he was one of our speakers here. He said that he's unable to join because of connectivity problems, but also because of the location where he is at currently, as he was hoping that he was going to join us. And so welcome everyone from anywhere in the world where you are, and welcome to our Africa session. The topic for today is climate change and human rights in the context of non-economic losses and damages. And obviously, we have specific questions for our speakers. We have one question for each speaker, but after that question, we will be interested to also hear their perspectives in terms of their domestic or national laws on environment or climate change. And we will do that so that we can hear their thought, as we want to have a very good law in terms of achieving climate justice. So let us dive into our program, which I would like to share. Let me check, am I able to share the screen? No? Yes. As you can see on my screen, the program is very short. I've just done the welcoming, and then I will just introduce our speakers, and then after that I will introduce the theme, what the theme means and what's the aim of the theme and so on. And then after that I will just invite the speakers to give us the talks, and we do the questions and answers and ways forward and closure. So this is our program here. Right. So our first speaker will be, so I'm just doing the introduction now. After introducing you guys, I will just invite you to put on your mics and say hi and tell us where you are right now. You might be, you might not be where we think you are. So we have, the first speaker will be Helvi from Namibia. Helvi is the regional coordinator for the Youth Network, CAADP, and she is a Namibian farmer and entrepreneur who holds a bachelor degree in agriculture and is currently pursuing her master's degree in academic leadership and management at University of Zambia. So the club that she is coordinating has 200 members who are proactively dynamic in their communities, most being small-scale farmers that produce for their households and populate in their vicinities, while some being qualified as agriculturalists. So Helvi, may I invite you to put on your mic and maybe say hi to our attendees here, and you can just tell us where you are connecting us from.
All right. Good morning, good afternoon, good evening, everybody. Thank you so much, Kule, for the invitation. To be part of this discussion, to engage with everyone, and to indulge on a very pertinent topic such as this one, and to really speak of the context of the desertification or the expansion of the desert, of the Namibian desert, and the issues of climate change and how this has affected Namibia as a whole over the recent years. So myself, I am speaking from Namibia, in fact, in the northern part of the country, where also when I do my presentation or my talk, I will also speak a little bit about the climate challenges we are facing, especially in the northern part of the country where I am currently based. So again, thank you very much, and I think it is a very good discussion, and I look forward to engaging everyone and all the participants. Thank you, Kole.
Thank you very much for that. And we have Abel, who is a Mozambican environmental and climate justice activist, and is also from the negotiator under the UNFCCC. We all know what UNFCCC is. Abel is the executive director of the Youth Vision and country lead of the African Youth Commission. Abel also coordinated the civil society platform on climate change and involved in different environmental and climate justice programs. Before I invite you, Abel, to put on your mic and tell us where you are connecting us from and how are you today, I want to say, these bios for me, because I know both of you, they feel like they have limited you because you are much more than what is written here. So yeah, Abel, you can just let us know where you are connecting us from.
Hello guys, accept our greetings from Maputo City. Maputo City is capital of Mozambique. I like to be sure. Can you hear me? Can you hear me?
Yes, I can hear you. Yes.
Yes, we can.
Yes, accept our greeting from Maputo City. Maputo City, capital of Mozambique. I'm here right now, is where I'm based at managing all programs from this headquarters. So I think from now I'll start. Thank you.
Thank you. Thank you so much for that. Okay, so before I go on, I forgot to inform all the participants that we have an interpretation. So at the bottom of our screen, you will see something like the map of the world, or the map. Then if you click there, you can choose the language of your choice. Unfortunately, we have English and French. And apologies to Brother Abel. We had this discussion before we got in here that we only have English and French and not Portuguese and other languages as we would wish to. So apologies for that. Okay, colleagues, let us just dive into our topic today. And let me introduce you to this topic. And it's I said at the beginning that it is a very unique topic simply because we know that the topic of loss and damage on its own has just been accelerated from COP27 of the UNFCCC a few months ago in Egypt. It was accelerated, but only on the basis that there will be a special, I would say in my own language, a special program for financing this topic. And before I talk about our topic today, we all know that the issue of human rights and loss and damage has been the topic since the climate talks started years ago. And human rights, obviously, it is something that should be considered in all the streams. It's a cross-cutting issue. And it's the same as loss and damage. Although we are dealing within the UNFCCC processes, we're dealing with mainly with the issues of mitigation and adaptation. But now recently we are happy that loss and damage is now there as something that could be on its own and that could be implemented as a standing item. And one thing that has not really, in our impression, most of us here in Africa, that has not really been considered as very important was the implications of the non-economic losses, which I will explain a bit. And so the implications that are always at the topic, because there are so many evidences thereof, are issues when there is a shrinking economy, or for instance, when there is a cyclone that just destroys the infrastructure of one country, and you could see maybe the GDP of a country going down because of that, and so on and so on. So those are the things that are always at the discussion, because there are measures of, there are tools to measure those impacts, and also there are evidences of that. But when it comes to, for instance, and that is my first point, when it comes to the unquantifiable climate change impact, such as the negligence in respect of the cultural loss, heritage, and religious rights, and the losses or the changes which are forced by climate change impact. And I'll give you just an example. When climate change, for instance, strike, if there is a flooding, and I'm not going to go too much because I want our speakers to also have a chance to speak, and maybe I can just come after. But if you look at, for instance, at issues of access to water, access to healthy water for human consumption, which is a human right, you would find that we would not have access to it, and that is an implication that is caused by climate change. But also it can be tried. We can lay a criminal complaint, for instance, in some domestic court. And one of the examples I can make was in April 2022, last year, when the flooding happened in South Africa, killing more than 430 people. A group of NGOs went to court and laid a criminal complaint against the government on the negligence that they said, you should have done something to prevent this, right? And so, and then the case obviously could not go on because the evidences are not quantifiable, right? And so it goes on to even talking about our religious rights, and we cannot practice anything else as we used to practice within our practice, in as much as the religious rights are concerned. And then also there is an example on omission in respect of climate legal frameworks, and this is very simple, especially for people that understand law. So if you are committing to do something, or you have signed, you have demonstrated your commitment within the law or within a particular legal framework that you will do something, and you will take an action as you are required. But at the end of the day, we realize that you did not do something, and then that can be you can be prosecuted under the laws, right? And so many times within, let me just say, within the climate talks, we miss this talk to say that if we are not taking action as a matter of urgency, we're losing everything else that we can identify with, especially Indigenous people, right? But not only Indigenous people, people that still believe in identity as something that relates to the heritages and some religious rights. And so, yeah. And then the last thing that I can make an example, just to also amplify this topic, is the significance in impacts that are not immediately noticeable, right? And so there is within our laws, and again, I'm just speaking from my perspective, from knowing the domestic laws here in South Africa, there's something that is called complicity, whatever. And it can also be tried in the court of law. So these are the laws where one has done something that leads to something that is a crime, or that can complicate our laws, right? So if someone, for instance, encourages, or someone is empowering, or is doing something that would cause someone to die, or someone to be limited in terms of their constitutional right, then that can also be tried in the court of law. But again, because of the lack of the tools to gather all these things to form evidences, then it makes things very hard for us to actually make sure that we hold the people responsible and accountable in terms of climate change and human rights. So I was just explaining the topic, what it means, and what is in the topic, and then before we give to our speakers, and I'm sure our speakers will then give us a much more focused context or content. Yeah, so that is it from me, and yeah. Let me then introduce our first speaker, which is Helvi. Helvi will be, maybe I can just pose a question to you, and yeah, while I'm just doing, I'm actually just looking for my documents here. Hello. Okay, just a moment. Sorry, I have a French version here with me, so I'm afraid to try and read French because I might embarrass myself. Okay, now I have the right one. Helvi, yeah. So Helvi, I will just have one question or one topic for you, and then you can come in and let us know your perspectives. So this is from your lived experiences on effect of expanding the desert in Namibia, as you indicated earlier when you introduced yourselves. So in which ways does climate change, as it is impacting Namibia, affect the cultural norms, traditional beliefs, and other non-economic losses, factors in Namibia? So I don't know, maybe you might also want to make some examples, and also bring in some perspectives from your national laws. So you have the floor.
Okay. Again, thank you very much, Kule. As I said before, I am very much happy and excited to really be discussing on issues such as this one. Most of the time we hear a lot about the nexus of climate change and agriculture. We hear a lot about climate adaptation and mitigation measures, but little is being spoken really with regards to how climate change is affecting indigenous people in obviously the different countries. So my presentation will be a bit on climate, the nexus of climate change and how it's affecting the agricultural side in Namibia, because also I think it's one of the things you haven't mentioned when you introduced was that I founded an organization. It's called Women in Agriculture Namibia. So I work closely with women farmers in the country, and also really bringing in how it's affecting their farming life, and then also looking at indigenous women farmers, or the marginalized group of the really rural women farmers. Okay, so really, I think we all know that the desertification of Namibia is one of the most visible effects of climate change in our country. You know, we have been experiencing prolonged drought and increasing temperatures, and floods, and these are really causing our land to dry out and become very barren, which is affecting both the environment and of course the human populations. So speaking towards the topic, to say how are our cultural norms in Namibia and traditional beliefs being affected by the expanding desert in our country. So number one is the desertification of the region. You know, it has led to a loss of fertile land, first of all, and water resources, you know, which obviously had a profound impact on the lives and the livelihoods of our people in the country. And then number two, it's affecting our cultural norms and traditional beliefs through the changes in ways people obtain food. So now many people in Namibia have traditionally relied on subsistence agriculture and pastoralism to feed themselves as well as their family. But now, due to this climate changes, these are activities, you know, they are becoming increasingly difficult to sustain, and so it has put a very huge shift, or it has led to a shift towards more market-oriented forms of food production and consumption. So we have now a lot of Namibians, and even in the rural areas, who instead of producing their own food and you know, growing their own food and eating directly from their arable lands, they are now buying food products from the shops, which most of them are exported, you know, into the country. I want to give an example of one of the indigenous groups in Namibia, or a tribe in Namibia. They are called the Overhimba people. The Overhimba people, they live in the northern part of the country, where I am also based right now, for example. So these Himba people, they have a traditional way of life that is closely tied to the land. They rely on their livestock for food and obviously for income, and they use land for grazing and farming. Okay, so but now, because of the dry and barren land, it makes it challenging to grow crops and find sufficient grazing land for their livestock. As a result, many of these Himba people are forced to leave their ancestral lands and move to urban areas in search of work and better living conditions. Just before I joined the meeting now, I went to, we call them malls, a supermarket around here. And this is one of the really things I've seen I think they just started moving to the urban areas in sometime last year. Sometime last year, that's when these Himba people, but all those years, even before and after independence, they have remained in their ancestral lands, they have remained in their rural areas, and they were just feeding off from their cattle, grazing their lands, rearing their animals there. And unfortunately now, because of climate change, arable land is no longer there. Water, rainfall is no longer there. They are forced to come and sit in front of the supermarkets with their young ones, either begging for money or for food. But the one thing I like about them is they are now, they are very creative with their hands. So what they are doing there is they are now selling these wooden sticks for cooking porridge. You would call it ugali in some other African countries. That is the one they are selling. But the one thing that concerns me is, imagine someone for over 50 years back has been selling a cattle or a cow for that is worth, we can say maybe $2,000. They've been selling that, and that is a huge amount of money. But because of climate change now, this person is selling a wooden spoon that is worth $US. That is a downgrade. In my opinion, that is a downgrade for our people because of climate change and because of the expansion of the Namibian desert, which we call the Namib Desert. So really, this is just really one of the examples that I wanted to speak of, because even when we look at these people, we say they are suffering, but back then they were not suffering. They could sell a cow that is worth $2,000, $3,000, but now they are selling something that is worth $1 because their cattle, they cannot rear the cattle anymore. They cannot grow their crops anymore. And honestly, these are really some of the devastating results that are coming up from climate change. And then also another example is these Himba people. I wish I had a picture that I could maybe present or show you, but we have two groups in Namibia. Number one, the one is the Himba, and the other one are the San people. These are people who are respected, or groups that are respected in our country because they have managed to sustain their olden way of life. And we have a lot of tourist attractions who really just want to engage in this and you see these people, but you will see now, because where there isn't that, when they move to the urban areas, so even their dress code over the years, it's going to change. They have a very nice dress code, so it just covers, for the women, it doesn't even cover this part. Almost half of the face, is not covered, but this is what we are saying is special about these people. But because now of climate change and they're moving to the urban areas, they are going to start being uncomfortable, and they will now start shifting into the dress code of the European countries and the Western countries, which is not supposed to be the point. We are now losing. So at the end of the day, as a country, we have lost our roots, where we have come from, and now adapting the beliefs and the traditional norms and the costumes of the European and the Western countries. So climate change, it goes beyond. It just goes beyond the finance. It goes the way of farming. It really also touches in it. It's affecting a lot of African countries. We are forgetting where we come from. We are forgetting our roots. These Himba people also believe in ancestor worship and practice form as ancestor for veneration, for example. But however, because of the increasing loss of the ancestral land and the migration of younger generation to the urban areas, there is a risk of losing these traditional belief systems. The younger generations are becoming less connected to their ancestral lands, and they are less likely to continue these traditional practices for their ancestors. So again, our spiritual norms, our traditional norms, we are losing them and moving towards the European ways of living. because of climate change. So this is really one of the issues that I've really picked up, because when you invited me to speak on this and I saw in my own country we are experiencing this, I said, but this topic that Kulakani is inviting me to speak about, I think it's very important and it's very pertinent. But nonetheless, moving on to another form, or how Namibia, or how we are being affected by the expansion of the desert rather. It has also had an impact on our traditional beliefs and the practices surrounding water. And I'm sure this is not only in Namibia, but also could be in other African countries, that where water, it has been known as a precious resource. For example, some communities have traditionally believed that water has spiritual properties, and have developed rituals and ceremonies around its use. However, now, as water becomes increasingly scarce in the country, especially in Namibia, these beliefs and practices may need to evolve and to reflect into really the new realities, and that the new cultural norms and practices will emerge to reflect changing realities of the desert. So that is the context of how the expansion of our desert is affecting us, and how it's affecting our costumes and our traditional beliefs. But it also has other several significant effects, which could be, for example, number one, like I said, loss of productive land. It's also affecting us with regards to soil erosion. We can also speak on biodiversity loss. We are looking at water scarcity, human displacement, and very much so increased poverty. As an example I've given before of the Obahimba people, someone used to earn an income of $2,000, but because of this now they're earning an income of $1 because of climate change. So it's bringing poverty and hunger to our people. So because in the interest of time, I think I was only allocated 10 minutes only. So what I'm saying overall, the expanding desert in Namibia, it has a significant environmental, social, and economic impacts, and addressing these issues is really essential for promoting sustainable development, and of course improving the well-being of the affected communities. Namibia is experiencing the effects of climate change. Like I said, including the droughts. We recently just had the floods. Now, as we speak, I'm in the northern part of the country, but I am now an unemployed farmer because my plot of vegetable is underwater, and unfortunately, I cannot do anything until it dries up a little bit. So really, that was the context of how the expanding desert has really changed our traditional norms and our agricultural way of farming. Thank you, Kule. Thank you very much.
Thank you so much, Helvi. And what you've just shared with us is really I think it's a touching stories, because they speak about what is happening with our people, but not us being apart from them, because we are also experiencing those. And then just before I go on, I'd like to highlight maybe two things that you talked about. One of them is migration, climate migration, when people are looking for better lives, but they are migrating from one city or from one country to another, just looking for good jobs and looking for better lives. And not because we cannot do anything for our own where we are, but because we are unable, we do not have access to fertile land, for instance, as you are saying. We do not have access to fertile land because the droughts that we are having are just deepening, they're just expanding. The desert that we are having, they're just expanding, you know. And then you also talked about the issue which relates to water and our spiritual life here in Africa. As someone that has a background in theology, I know what it means to just not have water when you need to practice some of your beliefs. You know, a day before yesterday, I was in Johannesburg. We attended a meeting with the Presidential Climate Commission here in South Africa, and we invited faith leaders. And one of the commissioners, we had a discussion with him. He said that imagine if there is no water, for instance, church leaders or pastors would not be able to baptize anyone. And you know, these are the things that are not so significant if you bring them to the international talks, because again, there's no quantifiable evidences that can say we're losing our identity, and by us losing our identity, it means that we don't have access to life, basically, because that's what life means for us, right? So I just needed to indicate that before I invite Abel from Mozambique. Abel, I hope you can still share with us some of your experiences and some of the experiences lived by the Mozambicans there, especially, looking at what happened in the past few years and what is happening. You are at a region where that is very prone to different cyclones. I think almost every year there's a season of cyclone that is hitting Madagascar and Mozambique because of that region. Maybe you might want to share us some of the implications that you have there where you live. So yeah, you have the floor.
Thank you, Kulekani. It's really nice to be here with you, to share with you how Mozambique has been suffering by cyclones and floods these last years. Allow and accept my apologies because my English is so bad. So I request you to make some effort to really understand the intention of my words. So firstly, I would say that climate change is really a big challenge in the world. It's also a big challenge in Africa and in Mozambique, my country. And Mozambique is one of most vulnerable countries in the world. There is geographical location. So we are already in front of the ocean, in the ocean. So everything, all floods, all cyclones, all winds, it comes and affect us first, then go to the hinterland. So the last few years, we have seen much work of the spy for Mozambican in general, because the loss and damages caused by natural phenomena like cyclone, floods, in some cases by droughts, have negatively and significantly affected the lives of population, especially young people, children, women, not ignoring the other species that are part of our ecosystems. And this ecosystem that have been giving this contribute to ensure that food security in our communities are ready. So we say that loss and damage is affecting and is violent human rights, with greater emphasis in children and young people, and also in women and other disability people. If we look in our last 4 years, we will see that we had more than 500 schools destroyed. We had more than 100 hospitals destroyed. And what happened when we destroy school because of cyclones, because of ice, means that this school will be closed. So if the school is closed, or if the school is a resettlement center for communities that our houses are affected by, it means that we will be viewing, we are bringing some prohibition. It means that students must not study. Why? Because the school is not available for lessons, but it's only available because, okay, part of schools are not working because they are affected by floods. The schools that are nice or are not affected are working like becoming a resettlement centers for people coming from affected areas. So it means that all of us, or all of young people, are affected by these issues. The same happens with hospitals. Some hospitals looking for this, like I said, we had more than 100 hospitals that are closed because they are affected by cyclones. So it means that even if we try to understand, we got people who need a frequent assistance in their communities. They must go to hospital every week to have some medicine. We got chronic ills. We got the sexual and reproductive health for young people, especially for girls, that they need assistance. That so we are being with this issue, we cannot do nothing. And if we cannot assist these young people, if we don't assist these girls, if we don't assist these chronic years by another medicals, what happens with them? So it means that the right of health and medical care is also being violated by cyclones. So if we count looking for statistics, that means that in this last cyclone, we have affected more than 12 million people in Mozambique. In this last 12 million people was affected. So if 12 million people was affected, it means that accounting also, we had more than 1,500 people was killed, counting from Idai, from Gineo, we had Idai, we got Gineo, we had Kenneth, now we got Fred, you see. And Fred is also coming again today. Today, Fred is affecting Mozambique in Zambezia, Nampula, and also Cabo Delgado. Is hitting Mozambique right now. I'm talking with you. So it means that we must take serious this issue. We already had more than, like I said, more than 1,500 people killed. We had a lot of places, a lot of homes, a lot of houses, a lot of vehicles, a lot of business, a lot of bridges, a lot of roads, a lot of different actions that make people living, that was destroyed by floods, was destroyed by cyclone. So we have, one of issues that is very, very, very terrible. We also had cemeteries destroyed. You must imagine what is destruction of some cemeteries, that a woman burns and newly buried bodies, people dragged and in water and scattered around houses. Sometimes we must go and collect it to put it in different public places. Is not something good. And how is our psychological health for young people, for children, for a lot of people who had the opportunity to see this kind of thing, how it affecting that woman rights are also affected by different ways. It means that the right of good health is affected. The right of education is affected. The right of also food is also affected, because people stay long time out of their homes, other people on the trees waiting for some helicopter or waiting for something to come and assist taking to the security place. So we got a lot of rights that are also violated by cyclone. So we have been fighting with our government. Why? Because we understand that we got people, we got subject of rights, but we also had subject of obligation. All citizens or all people must be defended by government. So it means that we have been working at different levels, that our African government, our Mozambican government at different levels must ensure, must defend the human rights of the people, firstly, because must understand and prioritize the political commitment and also concrete actions that you can make sure that how are they giving contribution to climate justice in the governance plan. But to be possible, all of this action, we must ensure that the government is really, really having now skills to know that climate justice is really understand that loss and damage must be is destroying the future of our investment, is wasting all taxes, all investment that people in our individual effort are doing to bring a better life, and every year is destroyed by cyclones, destroyed by floods. So all community, international community must understand. And also all population must also be engaged to fight for full enjoy of their rights to live in a health and environment, but first as the first people. This is one of, we have been fighting to bring you all medias, journalists, local communities, authorities to understand, because some areas that people are affected are places that are already identified that this is not a secure place to build a house. Please just move. So we must ensure that all young people who are still looking for lands to build their house must find a good and safe place to make a good life, to ensure that in case of floods, in case of cyclone, will not be more affected. Because now all of us, there is no poor, there is no rich, there is no political, there is no, all of us, we are affected. Who is in Mozambique, who is in Malawi, even Mr. President, even all of us were being affected by different ways, but all of us were being affected. So it means that must be commitment of all of us to work and defend the human rights first, and secondly, and ensure that our governments, our governance plan, in our organization, in our individual actions, me as a citizen, what am I doing to contribute to impact and defend the human rights? What am I doing to reduce the impact of loss and damage? Where will I choose the place to build my house? What kind of house will I build that will not be affected in this kind of actions is what we're doing with young people to understand, to make them understand that what kind of life they must choose for their future. Thank you.
Thank you. Well, thank you so much, Abel. I think those are very significant sentiments because, you know, yeah, it just talks about what is currently happening, what is currently being experienced, and what should be happening in terms of women's rights and so on. But one thing that has just stick on me very, very hard was when you talked about the cyclone that is happening right now as we speak. And to me, I am, you know, I'm just reminded by one of the things that I used to say when I talk about the climate change impact. For instance, if there's something very devastating coming in the country or in a certain community, I used to say, imagine having to wait for something that will possibly take your life. You know, science tells us that we will experience so much of these things, but imagine being told that tomorrow or a few days from now, cyclone will be in your area and it will destroy your properties. It will possibly kill, you know, some of your people. Imagine basically just waiting for, you know, I'm sorry if this sounds very sensitive, but imagine just waiting for your death, basically, you know, because we don't know if we will survive. And then if you survive now, and then you would be told that next year it's coming, you know, so you just have to wait for it, you know. But these are lived experiences, and these are lived limitations to our right to life, to our right to healthy and protected environment. So thank you very much for that. Let me see if I would have questions, and I think we have way less than we've taken a lot of our time. I think we have 10 minutes or less, very less. My colleagues will assist me. Do we have any questions from the participants before we move on? Maybe I can just take 5 seconds to be quiet a bit. You are welcome to type a question in the chat. And awesome, thanks, Nicole. So you're welcome, anyone welcome to type a question in the chat, and you can just type it in. There's a section, there's a thing that says Q&A. Yes, you can write a question there. All right. Can I just continue with this discussion a bit? And now I know that our speakers are you know, are also activists, especially in the civil society space. There's something very common with the countries that have coasts. You know, South Africa, Mozambique, if you go this side, but if you go that side, you have Namibia. And it's very unfortunate that we don't have anyone else from, especially maybe from the north or from central. We couldn't get them as speakers, and Ahmed has connectivity challenges. So there's something very interesting that is happening with our coast. A few years ago, some experts they said that we have a big oil in our oceans, and currently they are pursuit for some companies to do oil drilling or the offshore seismics so that they can get this oil. And I'm mentioning that because I know that there are lawsuits in South Africa. There's about 2 lawsuits that have taken place to push back against that. And I know that in Namibia, something like that happened. Not sure which year, but a few years ago. I'm not sure if Helvi, you are aware of that. And in Mozambique, definitely there. But in Mozambique, obviously there are complex issues. There are political and geopolitical issues, especially with the capital issues. But the matters are about people wanting to continue with the gas and oil in Africa, and that is in the lawsuit. And we know what oil does. That's fossil fuels. It just continues to cause global warming in our environment, and then continues to cause all these devastations. So my question then is, maybe you might want to respond to this question and also do some kind of a closing marks. What do you think we can do as civil society organizations just to push back against what is not necessary? And I'm saying that deliberately because of the debate. Helvi knows about this African debate about just transition and so on, and obviously you, Abel. What can civil society do in order for us to put pressure on pushing back against what is not necessary, and especially against fossil fuel in Africa? And then through the legal court, obviously, when there is a lawsuit, what do you think we can do? I mean, maybe one of the things that we can do is just to voice out ourselves in different ways. But yeah, you can let us know what you think. But then now I'm asking in the context of looking into just making sure that we do have some content in terms of making sure that in the global context, which applies to our domestic context, we have a very good framework for protecting our human right. I'm not sure if that question was very clear, but I can give each of you one, but not more than 2 minutes. You can just give us your quick thought, because obviously you were not you were prepared for this topic. It's just that I'm only bringing it now. Let me start by Abel, and now I need to end with Helvi. Abel, what do you think?
Thank you for this question. I think from now I will not give my position. Why? Because at local level, we are doing a lot of discussions. In the world, we got the polluters who polluted, who developed their countries before. They explored a lot of gas. They did a lot of, they explored a lot of natural and mineral resources in different countries and polluted the world. And today we are suffering by the impact. And now, last year, Mozambique discovered that got some reserves of gas and get some opportunity to explore it, to strengthen the economy, to develop the communities, etc. So what we have been discussing is, will be difficult to say no exploration, yes, in Mozambique, because the decision is already taken by the government. But we also understand that civil society got opinion, and his voice must be and is listened by actors, different stakeholders. Is ensure that all technologies we are using, or all technologies that must be used, must reduce a lot the level of pollution of the ocean, must reduce the maximum the level of pollution of the global level. So we've been working with our government to ensure that the pollution must be reduced. Even if you analyze in our national communication on NDCs we did last year, Mozambique is one of the countries that got a very reduced level of pollution in the world. So we've been working with our government that we must advocate for what we are doing. We cannot advocate on something and do another thing. Thank you.
Thank you. Yeah, I think that's very true, and I'm happy because you're bringing another perspective from how we think about our government, yeah, which has obviously different interests. So thank you very much for that, Abel. Helvi.
Kule, thank you. You know, and as you said, I think this is the oil topic is most of the time a very I don't know, you have to talk, but like especially in Namibia, there's a lot of conflict of interest going on, and you know, with regards to Namibia, there has been recent oil discoveries. So as we speak, Namibia has been, you know, receiving a lot of visitors, obviously not from the African continent, because of these esteemed oil discovery in some part of our country. You know, there has been talks around it, looking at both the environmental impacts and, you know, what some of the CSOs have been doing, the civil societies have been doing. You know, there's quite a lot of discussions happening, and right now I think the amount of oil that has been discovered in Namibia would be about, I think they said around 6.5 billion barrels of oil equivalent to the, you know, recoverable reserves. So you see, it's the topic is really still new, and we have been getting a lot of attention, and now this is where us as civil societies, especially in the country, need to start or have been doing a lot of advocacy work, you know, before the situation goes out of hand. Because just imagine if they have now discovered oil in the country, in the upcoming years, what would have Namibia turned into, and all the considering the environmental impacts and all of this. So of advocacy work, also doing a lot of monitoring. So a lot of SEOs have been monitoring the activities of the oil companies that are operating in Namibia. What have they been up to? Are they, you know, are they complying with the local laws and regulations, and of course the international standard for environmental and obviously social responsibilities. I know of certain organizations that have also been doing research and analysis with regards to this so-called oil that has been discovered in our country, and I think the CSOs at this point, we can only stand in with doing a lot of also community engagements, especially the communities around that area where the oil has been discovered, because now also this could affect them, that maybe they might be deported or removed from the area and go stay somewhere else, you know, all of these issues. So a lot of community engagements and capacity and engagements with these communities, you know, really, I think they need to be done. But it's a very hot topic. I will tell you, it's a very hot topic currently in Namibia, and really the attention we have been receiving We have seen them, they've been coming to visit our country, you know, just sneaking up to check and all of this. But we'll continue. We'll see how far, because we still haven't gotten the exact results. Sometimes it just could be people speaking sometimes, but they have been doing their assessments and all of this. But once we have a really clear outcome, I think we'll be in a better position, as well as us as CEOs, CSOs, to really come and maybe try to be involved in the whole matter.
Thank you so much.
Thank you, Kule.
Yes, thank you so much for that perspective. Yeah, it's very interesting. You know, I fully understand how complex the issue is, and I'm trying to think of it, you know, within this context of human rights and the climate change laws, you know, legal framework. I think this topic or this perspective that you're giving us has something to do with the result of the talks under UNFCCC, you know, the carbon trade and the non-market and market approaches, those ones, those technical things that are being discussed there, and many others, you know, when it comes to practical, to the really lived lives. That is how you know, we have to work around those, and then we get to the issues of environmental dignity and so on. Yeah, but thank you so much for that. And thank you so much, colleagues. Let me do the last two items, which will be in 2 minutes or one. So first of all, this is just for me to say that from now, there will be another session. So another session will be for, I'm sorry, I don't have the program with me, but there's going to be another session because this is a 12-hour interdialogue, interregional dialogue. So I'm very happy, and me and my colleagues were definitely happy that we also had the chance from Africa to moderate this session, but also to have a space where we can engage with everybody in the same platform. And second of all, and now this is about Africa, and next week we'll have another meeting, but it will be with our campaigners here, which we will communicate. If you are interested, or if there are law students that are interested, just reach out to me. I'll give you more details. You join us, we have more conversation. And then there is a draft resolution in the United Nations that will be considered before the end of this month on taking the issue of climate change to the International Court of Justice. We can also share that information. You can also go to this website, which I will share in the chat. And then yeah, so you will learn more information about that. And so this is just information sharing for those who might want to exit here, but please do not exit. There's more conversations that will be happening here that are more interesting. And yeah, stay in touch. And the closure for me is to appreciate our speakers. First of all, Helvi and Abel, thank you so much for joining us in this webinar and for agreeing to be our guest speakers. And we hope that we will be in touch in the future, from now on and in the future. And we're hoping that the World Youth for Climate Justice will still be connected with you and other stakeholders also. I want to appreciate Ahmed Fathi in his absence. He was one of our invited speakers, but could not join because of connectivity problems. And we appreciate his willing to also be part of us here. And appreciation to Professor Bond and Professor Lumumba, Bond from South Africa and Lumumba from Kenya, that I am in touch with, and I'm happy that we have the people of such calibers that have responded to some of our messages asking for support. Thanks to the participants, thanks to the team, the technical team, and once again I apologize that we started later than we wanted to because of my issues with my mic. So thank you to everyone, and yeah, I am saying for me from this session, cheers, and we will see you in the next session. Yeah, I think one of the colleagues here should give me a directive. Should we exit or the next session is starting now? What's the
Okay, so much. Have a great weekend.
Thank you, and you too. Enjoy the weekend. Thanks.
Thank you so much, everyone. Thank you, Kolikani. So again, we will have a 30-minute break, and then we will be back for the North America session, which will start in about 30 minutes. So if you want to stay logged in for that, you're welcome to do so. Thank you again for the wonderful session, Abel, Helvi, and for the amazing facilitation, Kolikani, as usual.
Okay.
Thank you. Arigato.
Obrigado.
Mambo.
Merci beaucoup.
Yibongile.
Ah, siyabumbela.
In the Philippines, a longtime environmental champion, Professor Jerthy Mayo Anda, has been working tirelessly for decades to defend the people and environment of Palawan. In 1990, Jerthy founded the Environmental Legal Assistance Center, now one of the Philippines' most active NGOs that helps communities uphold their constitutional rights to a healthy environment. ELAC and Jerthy work together with civil society groups to educate Indigenous people and local communities to protect their sources of food, water, and livelihoods. ELAC's strategic grassroots approach was critical to their campaign to stop the planned division of Palawan into 3 smaller provinces, which could open doors for the easier passage of unsustainable, exploitative projects. Undaunted by political pressure and powerful interests, Jerthy worked with the Save Palawan movement along with church and civic leaders to mobilize students, lawyers, researchers, and community leaders to campaign for One Palawan. Together, they motivated tens of thousands of voters to keep Palawan as one. In 2021, record numbers of Palawan's people let their voices be heard and voted to keep Palawan unified as a single province. This is just one of the stories of the many environmental law champions across Asia who are fighting and winning battles for people and the environment. These champions are making positive changes that will echo for generations. Join us in this movement as we work to develop and support the environmental law champions of tomorrow. Environmental law and human rights are closely intertwined. Often, fighting for one leads to fighting for the other. Such was the case for Surachai and Supapon from N-Law in Thailand. Surachai and Supapon were working for a human rights law firm when they were assigned an interesting case. Several dozen community activists had been protesting against the coal power plant. Many of them were charged by the police for trespassing and disorderly conduct. Some were facing years of jail time. As a result, they formed N-Law in 2001, one of Thailand's first organizations dedicated to empowering marginalized communities, protecting their environmental rights through litigation and advocacy. In 2003, N-Law took on the case of Clitty Creek, which would become a landmark environmental case. Since the 1960s, N-Law has been working to protect the environmental rights of Palawan. They have worked with the Save Palawan movement along with church and civic leaders to campaign for One Palawan. Together, they motivated tens of thousands of voters to keep Palawan as one. In 2021, record numbers of Palawan's people let their voices be heard and voted to keep Palawan unified as a single province. This is just one of the stories of the many environmental law champions across Asia who are fighting and winning battles for people and the environment. Toxic runoff from a local mining operation was polluting the creek, leading to rising cases of lead poisoning among the residents. With no funds for legal assistance, the villagers were powerless against the continuing industrial pollution. With support from NLaw, the Lawyers Council of Thailand, and other legal rights groups, the villagers filed and won 3 cases, including a landmark win at the Supreme Court. The rulings included compensation for more than 150 affected villagers and a restoration of the creek. The Clitty Creek case also set a precedent for court-ordered cleanups of industrial and mining toxic waste sites. This is just one of the stories of the many environmental law champions across Asia who are fighting and winning battles for people and the environment. These champions are making positive changes that will echo for generations. Join us in this movement as we work to develop and support the environmental law champions of tomorrow. In Bangladesh, Professor Nazrul Islam has been working for more than 2 decades to help create a new generation of environmental law champions. Since 1999, he has promoted the study and teaching of environmental law. At the time, this was an elective subject in law schools and classes were poorly attended. For over 20 years, Professor Nazrul used every opportunity to promote environmental law, writing newspaper articles, giving televised talks, publishing research, and giving training courses. His efforts inspired other educators, and together, they raised the awareness of environmental law all over the country. Today, environmental law is mandatory in many law schools, with classes often filled to capacity. These classes nurture new champions like Sayeda Rizwana Hassan. Rizwana joined the Bangladesh Environmental Lawyers Association, or BELA, in the early 1990s as a fresh graduate. She rose through the ranks and now leads BELA and its 60 environmental defenders who have filed and won several landmark cases. Among the most noteworthy cases was against Bangladesh's notorious ship-breaking industry. Ship-breaking companies purchase decommissioned ships and use unskilled workers, some of them children, to break up and scavenge the ships by hand. This causes severe contamination of shores and waters and lead to deaths, injuries, and diseases for the impoverished laborers. Rizwana and her team filed petitions and cases to stop shipbreaking, bringing it to the Supreme Court. What began with temporary injunctions became the first case in Bangladesh that fined polluters. In 2009, Rizwana and her BELA team won a judgment that temporarily closed 37 shipbreaking yards. Their cases led to new, more stringent regulations for the entire industry. BELA's legal victories continue to grow with each success and have gone so far as to help pass an amendment that enshrines environmental protection in Bangladesh's constitution. This is just one of the stories of the many environmental law champions across Asia who are fighting and winning battles for people and the environment. These champions are making positive changes that will echo for generations. Join us in this movement as we work to develop and support the environmental law champions of tomorrow. In Bangladesh, Professor Nazrul Islam has been working for more than 2 decades to help create a new generation of environmental law champions. Since 1999, he has promoted the study and teaching of environmental law. At the time, this was an elective subject in law schools and classes were poorly attended. For over 20 years, Professor Nazrul used every opportunity to promote environmental law, writing newspaper articles, giving televised talks, publishing research, and giving training courses. His efforts inspired other educators, and together, they raised the awareness of environmental law all over the country. Today, environmental law is mandatory in many law schools, with classes often filled to capacity. These classes nurture new champions like Sayeda Rizwana Hassan. Rizwana joined the Bangladesh Environmental Lawyers Association, or BELA, in the early 1990s as a fresh graduate. She rose through the ranks and now leads BELA and its 60 environmental defenders who have filed and won several landmark cases. Among the most noteworthy cases was against Bangladesh's notorious ship-breaking industry. Ship-breaking companies purchase decommissioned ships and use unskilled workers, some of them children, to break up and scavenge the ships by hand. This causes severe contamination of shores and waters and lead to deaths, injuries, and diseases for the impoverished laborers. Rizwana and her team filed petitions and cases to stop shipbreaking, bringing it to the Supreme Court. What began with temporary injunctions became the first case in Bangladesh that fined polluters. In 2009, Rizwana and her BELA team won a judgment that temporarily closed 37 shipbreaking yards. Their cases led to new, more stringent regulations for the entire industry. BELA's legal victories continue to grow with each success and have gone so far as to help pass an amendment that enshrines environmental protection in Bangladesh's constitution. This is just one of the stories of the many environmental law champions across Asia who are fighting and winning battles for people and the environment. These champions are making positive changes that will echo for generations. Join us in this movement as we work to develop and In the Philippines, a longtime environmental champion, Professor Jerthy Mayo Anda, has been working tirelessly for decades to defend the people and environment of Palawan. In 1990, Jerthy founded the Environmental Legal Assistance Center, now one of the Philippines' most active NGOs that helps communities uphold their constitutional rights to a healthy environment. Elak and Jerthy work together with civil society groups to educate Indigenous people and local communities to protect their sources of food, water, and livelihoods. ELAC's strategic grassroots approach was critical to their campaign to stop the planned division of Palawan into 3 smaller provinces, which could open doors for the easier passage of unsustainable, exploitative projects. Undaunted by political pressure and powerful interests, Jerthy worked with the Save Palawan movement along with church and civic leaders to mobilize students, lawyers, researchers, and community leaders to campaign for One Palawan. Together, they motivated tens of thousands of voters to keep Palawan as one. In 2021, record numbers of Palawan's people let their voices be heard and voted to keep Palawan unified as a single province. This is just one of the stories of the many environmental law champions across Asia who are fighting and winning battles for people and the environment. These champions are making positive changes that will echo for generations. Join us in this movement as we work to develop and support the environmental law champions of tomorrow. Environmental law and human rights are closely intertwined. Often, fighting for one leads to fighting for the other. Such was the case for Surachai and Supapon from N-Law in Thailand. Surachai and Supapon were working for a human rights law firm when they were assigned an interesting case. several dozen community activists had been protesting against the coal power plant. Many of them were charged by the police for trespassing and disorderly conduct. Some were facing years of jail time. As a result, they formed NLAW in 2001, one of Thailand's first organizations dedicated to empowering marginalized communities, protecting their environmental rights through litigation and advocacy. In 2003, NLAW took on the case of Clitty Creek, which would become a landmark environmental case. Since the 1960s, toxic runoff from a local mining operation was polluting the creek, leading to rising cases of lead poisoning among the residents. With no funds for legal assistance, the villagers were powerless against the continuing industrial pollution. With support from NLAW, the Lawyers Council of Thailand, and other legal rights groups, the villagers filed and won 3 cases, including a landmark win at the Supreme Court. The rulings included compensation for more than 150 affected villagers and a restoration of the creek. The Clitty Creek case also set a precedent for court-ordered cleanups of industrial and mining toxic waste sites. This is just one of the stories of the many environmental law champions across Asia who are fighting and winning battles for people and the environment. These champions are making positive changes that will echo for generations. Join us in this movement as we work to develop and support the environmental law champions of tomorrow.
Hi, everyone. Thank you so much for joining our webinar. We will begin momentarily.
Good morning, good afternoon, good evening, wherever you're joining from. We are here on behalf of the Fast Action for Climate to ensure intergenerational justice, or FACE. Here with the World's Youth for Climate Justice and the Normandy Chair for Peace to give a little bit of background on an upcoming advisory opinion request before the International Court of Justice, and just to talk a little bit about how youth can be more involved in the AO process and how advisory opinions can advance intergenerational justice for the climate. So I will turn it over to Trina then to give a little bit of background on the webinar and on our organization.
Thanks, Erica. Hi, everyone. Just for a quick background, this webinar is part of the 12-hour global dialogue on the Power Advisory Opinion. This webinar is hosted by Faith Intergenerational Justice, which is an initiative focusing on the intersection of climate and environmental justice as it relates to fast action or near-term climate mitigation strategies to preserve the planet for future generations. So we encourage youth-led, inclusive, and intersectional discussions on climate change mitigation, resilience, and adaptation. And the focus of this panel will discuss and explore the power of advisory opinions in the context of the climate emergency. And we want to empower young people with the scientific and policy knowledge base to inform further climate action. So I'll bring it back to Erica now, who can go over the run of show.
So as Trina mentioned, first we're going to go through the scientific background on the need for speed in climate mitigation. Then we'll give a short background on the current advisory opinion requests before international tribunals. And then we'll have a panel discussion for panelists to give their insight on the process, on advisory opinions generally, and on how they can relate to youth movements. And then we'll have an interactive panel discussion and some Q&A. If you have questions, please pop them into the chat and we will be sure to get to them at the end of the session. I will pass it back to Trina then, who will speak on fast mitigation strategies under the climate emergency.
Sounds good. All right. Hi, everyone. My name is Trina. My pronouns are she, they. I am a founding co-chair of FACE Intergenerational Justice. And I'm also a research associate at the Institute for Governance and Sustainable Development, as well as a JD candidate at the Vermont Law and Graduate School, where I'm on the board of the Environmental Law Society and a member of the Environmental Justice Law Society. So I'm going to provide a little bit of background on the need for speed in meeting the climate emergency and a little bit more of the background on the science. So climate change is a threat multiplier that threatens all forms of justice. The impacts of warming affect the most vulnerable frontline communities first and worst, but these communities contributed the least to global warming, as we all know. Therefore, all climate solutions have to be centered in climate justice, and it starts with a demand for representation for the most affected people in areas and decision-making spaces, including youth, as well as fast-acting policies, supporting investments, and other solutions like advisory opinions that can immediately address the needs of frontline and historically marginalized communities. We're quickly running out of time to slow warming to avoid accelerating feedback loops and triggering climate tipping points. Passing 1.5 degrees Celsius of warming, which could happen by 2030, raises the risk of crossing at least 6 different climate tipping points, which would lead to irreversible changes in our climate system. Each year, climate activists call for urgent action, but the honesty gap between commitments and action continues to grow. Leaders make promises, but binding commitments to real climate solutions continue to be delayed. Current policies in place are projected to result in about 2.8 degrees Celsius of warming by the end of the century, which would be catastrophic. And even at 1.2 degrees of warming that we see in 2021 and 2022, weather extremes are becoming more frequent and more severe. The time is running short as we're facing 2 climate crises, one with immediate near-term risks and the other where the risks are delayed but more drastic. The good news is we know what needs to be done. If we can win what we call the sprint to cut short-lived superpollutants like methane In this decade, we can avoid up to 0.6 degrees Celsius of warming by 2050, reduce projected warming in our critical Arctic by 2/3, and the rate of global warming by half. This is the only way to slow warming in the near term, buying us time to decarbonize, adapt, and build resilience to climate change. Superpollutants include methane, tropospheric ozone like smog, black carbon soot, and hydrofluorocarbons that are used primarily as refrigerants. And they all have a stronger warming power than carbon dioxide, but only stay in the atmosphere for an average of days to years. Since superpollutants can also be air pollutants, focusing on these superpollutants have a near-term benefit on human health. And this means reducing them has both an immediate impact on the rate of warming and on local health, which becomes a key climate justice strategy. So these climate solutions must include both a longer-term climate stabilization by reaching 2050 net zero carbon dioxide targets and focus on reducing near-term risks that would trigger a domino effect of irreversible tipping points. So this is what we call the longer marathon to 2050 and the shorter sprint to 2030 through SLCP. And these strategies are complementary, not exchangeable. We have to be able to do both. According to the IPCC, keeping the planet livable requires both of these solutions as well. For small island nations, cutting superpollutants to slow the rate of sea level rise is a survival strategy. Frontline communities need climate solutions today. Young people know that the window for climate action is quickly closing. And this initiative for an advisory opinion on climate change in the International Court of Justice was revitalized by 27 Pacific Islands law students who built upon Palau's 2011 ICJAO campaign to focus on human rights and climate change. These law students formed the Pacific Island Students Fighting Climate Change. And today, the campaign has grown beyond the Pacific, united under the World Youth for Climate Justice. This campaign, led by youth, empowered other young people to demand climate action in the highest court. So with rising calls to act quickly to avoid hitting the 1.5 Celsius guardrail, lawyers and advocates are becoming more creative in using the law to enforce strong and fast climate action centered in environmental and human rights. While the legal system may be seen as a slow-moving solution to the fast-moving problem of a rapidly warming planet, it is possible to achieve climate justice in parallel with fast mitigation strategies to reduce warming as quickly as possible. The courts are not a monolith. They can listen and adapt. And legal strategies, along with activism and advocacy, has the power to implement strong climate action to keep our planet and people safe. So now I'll pass on the mic to Erica, who can speak further on current advisory opinions that are before international courts and tribunals.
Hello, I am Erica Gerstenberger. My pronouns are she, her, and I am in the United States. I am an attorney licensed in New York State, and currently I'm working as a legal fellow for the Institute of Governance and Sustainable Development in Washington, D.C., supporting a global climate litigation portfolio. And first, before we dive into the specific pending requests, I was going to give a quick overview of advisory opinions generally, particularly for the non-legal audience. These are generally non-binding analyses by a court or another tribunal that interpret questions of law not specific to litigating parties. So what they are not judgments to bind specific parties that are on an active dispute before the court or tribunal that's issuing the advisory opinions. They are thus advisory. So they allow a court or a tribunal then to opine on very broadly applicable questions of law, which is a strong benefit of this particular tool. Even though they're non-binding, these are very valuable opinions because they can guide other courts and tribunals. They can be used as tools for diplomacy for states with peacekeeping mechanism. And they also, to some degree, forecast how the court or tribunal itself would rule if it were faced with contentious litigation on the same topic. In the international context, parties request advisory opinions to interpret treaties and other multi and bilateral agreements between states, or also to provide guidance for states to interpret how and whether their own domestic laws comply with these kinds of agreements. And increasingly, currently, we are seeing advisory opinions being used to strengthen climate action in the courts by seeking to get guidance on states' obligations pertaining to climate change, as Trina mentioned, particularly with the intersection of human rights and intergenerational rights. And so then a little bit of background on pending advisory opinion requests in international tribunals. We'll start with the ICJ, the International Court of Justice. This is the reason we're all here to talk about the subject. There is a campaign currently before the International Court of Justice, which is the principal judicial organ of the United Nations. The request was submitted by the Republic of Vanuatu in November of this past year, joined by several other states, urging the United Nations General Assembly to seek an advisory opinion on climate change and intergenerational human rights. The General Assembly is going to be voting on whether or not to proceed with the advisory opinion request on March 29th, just in 2.5 weeks. And we will give some more information later on in the webinar about how to engage in that process and how to urge your states to join on as co-sponsors if they have not already. Another pending request is before the Inter-American Court of Human Rights, which is the principal organ overseeing the Americas and Latin America. And the request was submitted in January of this year. It was co-submitted by the presidents of Chile and Colombia, which is the first time that sitting presidents have ever issued a joint request before this tribunal. And that, in my opinion, makes it a very, very big, very precedent-setting historic moment just in and of itself. The request is asking, again, for clarification on states' duties under human rights law on whether and how the states must protect present and future generations from the effects of climate change. And then finally, there is also a request currently pending before the International Tribunal for the Law of the Sea, which is responsible for interpreting questions of law related to maritime and shipping and ocean bodies, water bodies under the UNCLOS, which is the United Nations Convention for the Law of the Sea. This request was submitted in December of this past year by the Commission of Small Island States on Climate Change, and it is asking for an advisory opinion from the court on states' responsibilities regarding climate change's effect on coastal communities and the marine environment. And so to dive a little bit further into advisory opinions, we will next hear from Professor Nicholas A. Robinson. Professor Robinson has extensive experience in international environmental law. I apologize. I'm being told then that we will be switching the order. So on Professor Robinson, rather, we will be hearing from Nimija Nagareddy. And Himija is the proud daughter of South Indian immigrants, currently serving as a health equity research fellow at the Agency for Toxic Substances and Disease Registry at the Center for Disease Control in the United States. She is an elected select board member for her town of Acton, Massachusetts. And as one of the youngest elected representatives in her state, she is very dedicated to building youth civic representation in her community and country. Himija recently graduated with a Master of Science in Environmental Epidemiology with a concentration in infectious disease epidemiology from the Harvard T.H. Chan School of Public Health. She is a passionate member of the UNA USA for the last 6 years, founding the first collegiate UNA chapter in Connecticut at the University of Connecticut and going on to serve 2 terms as the Northeast representative on the UNA USA National Council. In her role as youth observer at the UN this year, she strives to uplift voices and actions of young people across our country in a global policy dialogue on international issues of paramount importance. We are very excited to hear from you, Hamija, on how youth can advocate for advisory opinions, and I will turn it over to you.
Thank you. Thank you so much for having me and for the invitation to speak about why youth advocacy with advisory opinions is so paramount. And I apologize if any background noise comes in, but hopefully it is okay. So I wanted to start with a general question. We already kind of heard an overview of what are advisory opinions. And for those who don't know, similar to myself, when I first heard about them, advisory opinions are provided by the courts, such as the International Court of Justice, as we've heard, in response to a legal question. An advisory opinion from the International Court of Justice, for example, is sent to the UN General Assembly, UN Security Council, and UN specialized agencies. Advisory opinions are opinions that are advisory. In other words, unlike court judgments, they're not officially binding. But they do have meaning and they do have significance. Court advisory opinions do carry authority and recognition and can be highly persuasive in determining the obligations of states and other entities. So why do advisory opinions matter in the climate justice movement, specifically the youth climate justice movement? Advisory opinions on addressing climate change as a human right can contribute to global progress on climate justice and intergenerational equity. It helps us take a rights-based approach in addressing the climate crisis at all levels, from the local to the international, when dealing with mitigation, adaptation, loss and damages, a lot of things that for many young people who even went to COP27 heard a lot about, and spearheading implementation efforts with the Paris Agreement and the passing of future international climate policy. So we can see that this type of rights-based approach provides a sustainable way of getting everyone on the same page when it comes to climate action. Advisory opinions can also allow us to legally endorse the available science and scientific consensus on climate change, especially in this era of mis and disinformation, especially when it comes to climate education and science. This allows us to establish a basis and a recognition, a legal recognition of the climate science and get, again, everyone on the same page with that to then create evidence-driven implementation efforts. It also, advisory opinions also allow us to transition towards a sustainable economic model and can provide a meaningful way for civil society and the will of the people, such as you and I, especially young people, to hold their governments accountable for protecting their citizens, something that allows us to protect our human rights. And so again, this rights-based approach is really key. Advisory opinions at the international level, and I want to underscore, even at the local level, provide an incredible pathway for young people like us to legally justify and tangibly mobilize area-wide and, importantly, multi-sectoral resources. And you don't have to have a fancy degree for going forth with passing advisory opinions or supporting the passing of advisory opinions. Right now, advisory opinions are an underutilized tool for creating change among youth activists. And we're hoping to change that with this event. So for all of us young activists on the call, for all who are allies of young people who may not be young, I know that it's not unusual for you to feel the responsibility to step up to the mantle and lead the climate education, policy, and implementation efforts that we need for a more sustainable world. So my ask for you today is to dig a little bit more into advisory opinions. Use and share the resources and the knowledge that we're providing today to seriously consider acting. Actively build support for current advisory opinion requests around climate action and climate crisis recognition, and encourage those around you to do the same. Really provide that educational support and resources and reach out to us, people at Faith, people on this call, all the incredible partners that have come together to put forth this event, because you're not alone in this work. And we do want to hear about and support your efforts in your local communities and your national and international avenues of advocacy, because we all know how powerful youth-led advocacy efforts are with creating that radical global change we need today. Thank you.
Thank you so much for that, Himaja. That was outstanding. And I'm so glad that you were able to join this webinar and speak on such important things and empowering young people to be able to act and, in front of the climate emergency. So now I'm going to introduce Romina Piccolotti, who is a renowned environmental and human rights expert and activist. Romina is the president of the Center for Human Rights and Environment, which she founded in 1999 to promote human rights and environmental protection. And through CHRE, or SEDA in the Spanish acronym, she established Latin America's first human rights and environmental legal clinic to defend underprivileged and marginalized communities from environmental degradation. Previously, she served as Argentina's environment secretary, where she deepened environmental controls for hundreds of companies, helped shape and create stronger environmental regulatory frameworks, led Argentina to pass the critical forestry law, and ushered in the world's first ever glacier protection law. At IGC, she's also a senior policy analyst, where she works to reduce short-lived climate pollutants and strengthen the Montreal Protocol. So now I'll pass it off to Romina to talk about climate justice in international courts and tribunals. Thank you, Romina.
Yes, thank you, Trina, and thank you, the organizers, FACE, and the Normandy, the members of the Peace Chair for organizing this seminar, which is extremely important at this moment. So enough has been said about the different kind of advisory opinions. I would like to do a deep dive on the advisory opinion that was requested by Chile and Colombia to the Inter-American Court of Human Rights. The Inter-American Court of Human Rights is different from the International Court of Justice because victims of human rights violations do have a standing before the court. In the contrary, the International Court of Justice is only among states. So from my perspective, and specifically for this seminar, to give a voice of the people on climate is very, very important. So I'm very glad this advisory opinion was submitted before the American Court of Human Rights. More than 25 countries of the Americas have accepted the jurisdiction of the Inter-American Court of Human Rights. And since 1982, the court has issued around 29 advisory opinions. Advisory opinions in the Inter-American system issued by the court do have clear legal effects, as the court is the highest body that interprets the American Convention of Human Rights. So compliance with the advisory opinions that cannot be separated from the duty of states to comply with the provisions of the American Convention of Human Rights that they have signed and or ratified. One of the principal ways in which a state must guarantee compliance is what is called in law the control of conventionality, or the obligation of states to adopt positive measures to guarantee the rights under the American Convention, including through law reform, policies, NDCs, any kind of administrative norms. They must do it, adopt it in a way that is compatible with the American Convention of Human Rights. And the Inter-American Court has explicitly held that the control of conventionality must include advisory opinion interpretation. This is why I'm saying that advisory opinions do have very strong legal effects in the context of the Inter-American human rights system and the context of national laws of states in the Americas. This is why you will find in the jurisprudence of many countries, including Costa Rica, Colombia, Mexico, Ecuador, Argentina, etc., that courts explicitly held that advisory opinions are binding and authoritative interpretation of the American Convention. Numerous high-level courts of countries of the Americas have also said that advisory opinions have even highest rank that the Constitution, because these countries have included the Constitution, the American Convention, as part of supranational law. So a very clear example of that, for example, is the advisory opinion 24/17 regarding the right of LGBTQ individuals. Since this advisory opinion, states across the Americas have begun processes to ensure that their civil registries ensure an access to identity documents in line with individuals' gender identity. This is in reaction and to comply with the advisory opinion that the court held on this issue. So going back to climate, as was said here, it was a historic moment where two presidents got together and decide that the court need to give advice to states on how they should tackle, how they can comply with their obligations under the American Convention of Human Rights in the context of the climate emergency. And this is the opening, I think, for the youth movement. What this means? I mean, it means that the court will launch a process that will go through all 2023, beginning with public notification of what will be the questions that the court will be advising on. And we can expect that these questions will include issues that are very important for the youth movement, including how to remain under 1.5, and how climate justice can be done, including actions that will help the world to remain under 1.5. So under this context, after the Inter-American Court will notify publicly about the questions, they will open a window for experts, communities, vulnerable groups, victims to submit their opinions, their submissions, their observations to the court on their area of expertise. And that's the opening for the youth movement. From my perspective, an advisory opinion does not clearly tell the states that to comply with their obligations under the American Convention, they should include fast mitigation strategies is the only way that the court can really guide the states on the concepts of climate emergency. Because as what I said at the beginning, here in this call, the only way to remain under 1.5 is by substantially cutting short-life climate pollutants and increasing action on other fast mitigation strategies like stopping deforestation and increasing energy efficiency. So if you are serious about the climate emergency, and if you want to tackle the climate emergency in a way that respects human rights obligation and includes climate justice, every NDC, every action that you do on climate, every law that you adopt at the national level must be aligned with remaining under 1.5, and therefore must be aligned with increasing action on fast mitigation strategies. So I will stop there and will answer any questions concerning this matter. Thank you.
Perfect. Thank you so much, Romina. We will now head to the panel discussion. And so I will ask all the panelists to turn on their cameras again. The panelists will include Romina, Himaja, Erica, and Nicole Pons from the World Youth for Climate Justice. Just as a quick background, the advisory opinion resolution that is before the International Court of Justice currently has 105 member states that have co-sponsored the resolution. So I'm about to share the screen right here. You can see the countries that have co-sponsored the resolution, and co-sponsorship is still open. So if you don't see your country flag here, you can call on your government to vote yes on the ICJAO resolution. We'll also be sharing a toolkit and some other information after this webinar that can provide some more information on the science and the policy actions that we can all take, especially youth. For now, I will ask the audience if they could help us out by filling out a word cloud. So Erica will fill in the chat with the link. But for now, I'm going to share my screen. And the question that we ask for the audience is, what are a few words that come to mind when you think of intergenerational climate justice? We want to engage the audience and ask them to be able to inform what are the priorities that we can ask for in an advisory opinion and any other legal or policy-oriented climate action. So I'm about to share my screen right now. Perfect. So if you go to the link, you can fill in a couple of words that can that you are thinking of. You can also go to menti.com and use the code that appears on the screen right there. And so we'll give it a few minutes for the screen to populate. And I also invite the panelists to fill this out as well. All right, this is fantastic. Thank you everyone for filling this out. I'm going to keep this kind of open so the panelists can all see some of the priorities or concepts that come to mind when we're talking about intergenerational climate justice. And I'll ask a couple of questions now to the panelists. How can we incorporate some of these priorities into advisory opinions and other legal mechanisms? So I'll leave the floor open right now.
All right. May I come in, Trina?
Of course.
So I see the center fast action, and I could not agree more. I mean, you cannot have climate justice without fast action, because it's the only thing that will. And fast, when we meet, what is fast action? Fast action is to significantly reduce methane emissions, to significantly reduce black carbon emissions, to increase energy efficiency, to accelerate the implementation of Kigali, which is basically phasing down HFCs for refrigerant, tapping the refrigerators in the cars, and replace it for a kind of friendly refrigerant, and obviously increase energy efficiency. So these are the fast action. Fast action is not necessary to accelerate the energy transition. Because if you only accelerate the energy transition, you will end up with more warming that we have today, and that's climate injustice. So while you accelerate the energy transition, you must cut short-lived chemical pollutants and include other farm mitigation strategy to be able to deliver climate justice. And how do you do that in the context of the advisory opinion? First, please contact Trina. She can be the link between us on. We're advising right now submissions to the advisory opinion on the Inter-American Court of Human Rights. So if you are willing and you want to submit your views to the court, please contact Trina and we'll help you to do so. So I hope this will be helpful for the next steps.
Wonderful. Thank you, Romina. And I did just share both the emails for my personal, but also the Faith Intergenerational Justice email. And we'll provide some more information through FACE because this is one of the big aspects of the work that we're doing. Before I go to the next question, I just wanted to see if Himaja, Erica, or Nicole has anything else they wanted to say. All right. Oh, Nicole.
Oh, none on my end. I think that was on point, and I actually wrote down fast action, so I agree very much.
Yes, fast action is very important. I think that's part of the science base that we have to inform ourselves to, and making the climate science a lot more accessible and understandable to people of all ages as well. And I think that's one of the really important things to inform policy recommendations and actions that young people can do. So I'm going to bring this to Erica, Himaja, and Nicole. But I want to ask, why are advisory opinions so important for young climate advocates?
I can chime in first. I think that advisory opinions provide a really incredible way for young people to enter the legal climate justice space, to provide actual input on a level on how we should be approaching holding ourselves accountable, whether we're talking at the local level, state level, or as a globe. How do we keep ourselves accountable to moving towards a more climate just future? And young people have been leading this change. So much of the advocacy that we see in the climate space, honestly, so much of the action that we've seen in this past decade on climate action has primarily been spearheaded by young people. It's been absolutely incredible to see how we've continued to lead a global movement, one that isn't losing momentum, but gaining momentum on creating the fast action that we need. And advisory opinions provide another really substantial avenue for young people to do so. But you're right, there is an educational threshold, or it seems like there's an educational threshold. Many young people don't know what advisory opinions are. I didn't know what advisory opinions are. And it took that education on my end and the resources that FACE was able to provide me for me to learn more about it and to see the potential of contributing to it, of throwing my hat and putting forth my opinion. And so I think that it's a really powerful tool for young people, but it's absolutely critical that we continue to talk about this. The other thing is young people truly are some of the greatest climate educators that we've seen in the world when it comes to talking about the science, when it comes to implementing the action. And so this really does almost feel like a natural fit in the youth climate justice movement, which makes it really exciting. I think that this is another incredible avenue for us to continue to create that change that we need. And also, I want to make reference to what Romina said before about intersectionality and making sure that with the efforts that we're doing, we're really prioritizing the voices that tend to be marginalized and left out of climate advocacy spaces, legal spaces. This is a way for us as youth activists to make substantial steps towards creating a more inclusive advocacy movement, a legal advocacy movement that's pro addressing the climate crisis.
I'll hop on that question also. So I think that, to start, advisory opinions are incredibly important for the youth climate movement because of the need for fast action. Like Trina was saying, if we do not act now in the sprint toward 2030, then our chances of crashing through the 1.5 guardrail are astronomical. And so then to bring it back to what Himija said, one of the important aspects of the youth climate movement is how good youth are at communicating, spreading the word. And so advisory opinions are a fantastic way just to stimulate the conversation, spread a little bit more the science and the message of the urgent need to act on climate. And also, I think the reason why this particular legal instrument is useful for the youth movement is the nature of advisory opinions as general, broadly applicable questions of law. So rather than an opinion or a judgment that's strictly about party A or party B, an advisory opinion is about you and about me and about everybody that opinion touches. So it makes it a much more, personal connection to the movement for youth who are wanting to get involved in these kinds of campaigns.
Well, brilliant insights from Imogen and Erica. Just to add a bit to that, even just this 12-hour regional dialogue, to quote one of the panelists earlier, only the youth has the audacity to organize something like this. And we're all young people, youth groups organizing this in a different regions. So that alone brought us all together. And it just, emphasizing that there's not one solution, and the advisory opinion is not one solution, one instrument that will wish away all the problems of the climate emergency, but we have to parallel that with efforts like what Romina and Imogen saying with fast action and keeping it at 1.5. And we need to reinforce this discussion, especially leading up to the AO, and hopefully when we get the vote at the United Nations and then we go to the ICJ, that these conversations and these issues are included as well and are part of the discussion, and hopefully will be addressed as well. And and I think just also the fact that an advisory opinion was framed, this advisory opinion on climate change and human rights was framed by the Vanuatu government, who's the leader of this, who's the main sponsor of this resolution, as a youth advisory opinion. I don't think something like this has been as inclusive to the youth. I mean, an instrument of international law. Correct me if I'm wrong, but it's just incredible to me that even the states are recognizing it as a youth advisory opinion, mainly led and campaigned for by youth. So it's a very empowering story, and something that not only youth from all backgrounds can contribute, not just those with legal background, because Imaja, I'm a lawyer now. I started as a law student. I didn't even know what an advisory opinion was. So that's why we had these discussions with Trina when we were planning all this, that we wanted to be as accessible as possible and to ground it and to contextualize it, like what will it do and what does it mean, and not just and go beyond the technicalities of it. And that's also why we're doing that, and we're seeing more and more people getting involved, getting educated, being more aware. And yeah, that's also very inspiring as a youth advocate myself.
Thank you so much for all of that. Romina, I just see that you unmuted. Did you want to say something as well?
Right. I want to point out there are two specific questions also that I think are relevant for in the Inter-American Human Rights Court advisory opinion request. One has to do with the differentiate obligations of the states to protect children. So as one of the most vulnerable groups under the context of the climate emergency, I think that's a very good opening for the youth movement as well. You know, you can make a submission on 1.5, 60 pinpoints if you don't include fast mitigation strategy and increase funding and policies and actions behind fast mitigation strategy. Then you can do a submission specifically on the vulnerability of children, the context of climate emergency, and what does it mean for climate justice. And again, reiterate the fast mitigation strategy. And then there is another question that has to do with judicial remedy. And I think that's a very important question. First, because environmental defenders, climate defenders are being killed, are being harassed around the world. And it seems that the judiciary system is built not to protect the freedom of expression and from the youth movement at this moment. So I think it's very important that the court, including this advisory opinion, when they answer this question of the states, what does it mean to provide a judicial remedy in the context of the climate emergency? And it must be fast, a fast judicial remedy first. And second, it must allow the protection of the freedom of expression, which include, in my view, civil disobedience too. So I think that's another specific question that is very close to what the youth movement is doing and the protests on the streets, etc. How to protect that, how to ensure that the law protect that rather than suppress that, and the judiciary as a key implementer of the law.
Thank you, Romina. And thank you everyone else as well. And this kind of makes me think of another question when we are discussing, remedies or what kind of actions that we can demand for, or what young people actually need. Who will be drafting this? Who can write, these opinions, these policies, anything like that? Is there the space for young people to be able to comment? And if so, are those comments even incorporated? How do we avoid the tokenization of youth just as, oh, great job, young people are advocating for this, and kind of keeping it at that? We need to actually, be empowered. And so how can young people go about doing this in the very intimidating legal institutions and policy institutions that often just tokenizes young people, and there is not an actual space for young people to wield more influence and power in those decision-making spaces? This is an open question. I'm sorry, it's a big question, but.
I mean, just to jump on it very quickly, there needs to be more seats at the table for youth in decision-making capacities on the kinds of organizations and institutions that are making these decisions. Like Himija, we need more of you. We need more participation. And I also just wanted to underscore what Romina was saying about judicial remedies, and perhaps, Trina, then remedies can be incorporating direct action to include youth more meaningfully. But these opinions, these advisory opinions, are going to be very beneficial, because not only are we asking for more definition on what the duty of states is, what do they actually have to do, it'll also, indicate when has that duty been breached, when has the law been broken, and then further, the remedies part, what do you have to do about it once the law has been broken? And I think that that's just a fantastic opportunity now with these conversations to try to be thinking about how we can better integrate youth into each one of those steps.
I totally second you, Erica. I think that it's so important that we continue to encourage more young people in this space, especially informal delegations, formal delegations to UN conferences, in negotiation spaces, formal delegates to, our missions, our UN missions around the world. And I think that we're making steps towards that, but there's so much more that we can do, exactly like you said. And I think that that has so much value because, I mean, we even just saw the list of countries that have signed on to this AO, and there were so many that were missing, including the US, I believe. And so one of the things that we can continue to do is make sure we have young people in these spaces, as you said, Erica, these seats at the decision-making tables. And the responsibility, oftentimes falls on youth activists to try to push for those seats. And I would challenge people on this call who are youth allies and may not be young people themselves, but care about youth engagement and care about hearing from the young people who are on the front lines of this climate crisis to really make sure their voices, their perspectives are incorporated because they have actual power in these spaces.
Just to quickly add to that too as well, I just like to share one story testimonial from a friend, a colleague here in France. I think what we are able to do is because we are encouraging youth and young people to converse and reach out to their governments. We're empowering them as well. So what happened was that they reached out to their ambassador, French ambassador, and then the French ambassador was so surprised that young people, 20, 21, knew exactly what they were talking about. And they were kind of being quizzed because this ambassador, this diplomat, wasn't really sure if they knew what they were talking about. But then because of these, because of how these groups that we have, the FACE, for example, with your awareness and education program, and World Youth for Climate Justice providing toolkits and providing this material. So we're empowering and educating these young people, and that also emboldens them to reach out to their diplomats, and just this encouragement in general to talk to their government, and that this is their right and they can do this. And we've had many experiences like this and stories like this. And yeah, I think that's also one way to make sure that youth have meaningful participation, that they are not afraid to converse with their leaders, which is very important and encouraging. And also one thing that we're working on for the World Youth for Climate Justice is our Youth Climate Justice book. It's like a green book. It was inspired by the Yale brief. So many students from different universities are contributing and writing to that. And we're planning to submit it to the proceedings and show this. And I'm not sure if that's possible, but I don't know, with the ICJ proceedings later on with the yeah, maybe we can submit that, or whoever's willing to listen and read this, that this was put together by young people from different universities from all over the world. So, I think that's one example of meaningful participation.
Nicole, I would like to read that. If you can please send that to me, and see if from that we can convert it in a submission to be inside the Inter-American process. I think would be very interesting. I would like to read it first. So please send that to me.
Yes,
great effort. Thank you. Very, very good effort. And yes, I do believe that the youth movement needs to be at the table, and we're doing everything that we can to get you guys at the table. We should have done that a long time ago. And what I mean at the table is at the decision-making table, because you can be part of a delegation, but not be at the decision-making table, you see? So you need to be very specific on your ask. I think that will also bring more transparency to the process and more accountability to the process, which is essential. I mean, there are many things that happen during these negotiations that I always think, if you, if these things come out in a transparent way, and you are held accountable in your own country of what you're saying here in this negotiation table, then you will be behaving in a different manner, you see? So today there's no accountability at all during the negotiations. And I think this is a very, very important point, and that the youth through the social media, etc., can really help on that.
Wonderful. Thank you all. Oh, Nicole, did you want to say anything else?
I just wanted to say that thank you, Romina, and we would love to share that from the World Youth for Climate Justice.
Wonderful.
Great. And I really hope you make a submission in addition to this green book that you have put together, that you make a specific submission on climate justice and the climate emergency and fast mitigation and tipping points. I think this is essential. And the advisory opinion is also a good tool to educate judges, to educate lawyers, to educate communities that are beyond these scientific discussions. And we should use that, amplify that. We're going to organize 2 regional workshops, one in maybe Amazonia and the other in Colombia. We'll let you know about that. And after the submission process is closed by the court, there will be a hearing where different experts will have their date in court, if you wish, but they will be speaking to the court. And I think it's very important to promote that and push the court to be progressive, which I'm sure it will be. The women at the court, women are always progressive. And then on the ICJ process, anything that we can do to help, we're willing to. Any information maybe from this process that can help the other process could be useful. You will need to keep a lot of pressure on the ICJ. I have litigated in the ICJ myself to make sure that they come out with a good advice for opinion and a progressive one.
Perfect. Thank you so much. I am cognizant that we have a little bit of time left, and so I want to be sure to incorporate some of the Q&A. So if you haven't filled out the Q&A, feel free to fill it out below, or just send me a direct note and I can ask the questions to the panelists. But the first question that I see is, how do other human rights conventions interact with ICJAO, and how are future generations considered? So I'll leave this open as well.
Sorry, Trina, can you repeat the question? I couldn't hear it very well.
No worries. The question was, how do other human rights conventions interact with the ICJAO, and how are future generations considered?
Right. I can tell you how other treaties interact with Inter-American Convention, the American Convention and the American Court first. And for example, both courts, Inter-American Court and the European Court, they look at each other a lot. So you will see, for example, on different jurisprudence from both courts, that they are reflecting also on what the other court is doing. We hope that this experience that we're going to have at the Inter-American Court of Human Rights will also influence what the European Court of Human Rights can do and what the African Court of Human Rights can do. And actually, a specific seminar will be held among the 3 courts, where the advisory opinion capacity on climate will be addressed by the judges themselves. This is a closed seminar only for the judges of the courts. So hopefully this will inform each other. Now, the ICJ will not will not address the human rights obligations under this regional treaty at all. It's a very different setting. So I'm not sure how this will develop in the future when the ICJ advisory opinion moves forward.
To build off of that response, the jurisdiction of each tribunal is different and specific to those tribunals, but like she mentioned, they communicate with each other and they look to each other, and they, it's one of the great facets of an advisory opinion is because it's a guidance document from that tribunal. Other tribunals can look to it and see how it would apply to the laws within their respective jurisdictions. And so also wanted to add and emphasize something that Romina said, that in addition to the youth needing access to information on fast mitigation science and how they can get involved in the climate emergency, oftentimes legislators, litigators, judges, people who are professionals in the legal space might not have direct interaction with climate law or international climate law regularly, and might not have a lot of the background on the need for speed and the action that we need to take mainly on short-lived climate pollutants in the near term to curb warming in the near term so we can address the climate emergency in time. So events like this and events that, closed events like Romina was describing, or delegations, any way that we can be spreading this information, we need to do so.
Thank you,
I
Erica.
would also like to share a timeline with you guys. I think it's important. So our expectation is that the advisory opinion will be issued by the court maybe the first quarter of 2024. I say that because, there's a journey through the advisory opinion, and then it's the day after of the advisory opinion. And so you can begin preparing yourself, what will you do with this advisory opinion? What kind of actions will you take? How will you move forward after, the day after?
Yeah, I'll just say also to Erica's earlier point about the education, not even just for young people, but everyone that is working within the climate sphere, parallel to the climate sphere. A lot of the science is very technical, and not everybody reads the IPCC report that is released, every couple of years. However, when we're centering climate justice, the need for speed is already inherent, as we see with youth climate advocates from the Pacific, from small island states as well. And we see that many climate activists are already advocating for policy solutions that do align with the fast mitigation strategy, as we described, with the 1.5 degrees Celsius and shore-lived climate pollutants. However, it's not called SLCP mitigation. It might be instead called climate justice or clean air or food security, which focuses on establishing clean air for people and food security for people, but it also reduces emissions of black carbon and methane, which is part of the SLCP strategy. And so being able to link this science background with the policy recommendations, especially for young people, but all people that are working on climate, it's so important to link these ideas together and bring it in the legal field as well too. So then we can define and have, better understood parameters for more efficient or better climate solutions that focus on climate justice. So if anyone has anything else to add, I can leave a little bit of space. And if not, there are a couple more questions that came into the Q&A, so I can go straight to that. All right, so the next one is from Caitlin Frederick. What are high priority areas for youth, not necessarily studying law, but interested in climate change, for uplifting this important initiative in our countries that have yet to support this? And I'll send this in the chat as well.
I can jump into that because I love this question. It's something that we've actually been working a lot on just this year through my term as Youth Observer and even in past Youth Observer efforts. So to summarize, over the past 4 months, I embarked on a nationwide listening tour, going in person and virtually across the country to speak with young people and really gather feedback and information on what youth priorities were. And completely unsurprisingly, I don't think anyone would be surprised by the fact that climate change was the number one thing that was mentioned in every single discussion that we had, in every single forum that we held. It was a huge priority for young people, and they made it known. And it was really powerful hearing the statements, the personal anecdotes of young people having faced environmental and climate injustices here in the US. Young people reading up about the science and being the main educators of their communities, especially if their communities were a little bit resistant to making meaningful climate education changes, using the science to govern policy, things like that. I would say the top things, and I can actually put the link in the chat for you all to see, but some of the key findings were young people were especially worried about climate and environmental injustice. So how the climate crisis disproportionately affects people of color, people who live on the coast, people who are of low income, people who are of the LGBTQ plus community. There's so many different groups that climate change disproportionately affect when it comes to, and you can list all the other 16 SDGs, health and well-being, quality education, and the list goes on. So that was the key thing that came out of the listening tour. Other things that came out include seeing stronger US commitments to addressing the climate crisis from an economic standpoint, from a policy standpoint, and even at the state and local levels, making sure that there were substantial improvements to actually moving forward with the climate future. More than happy to put that in the chat. Those were just a few things that were highlighted. But the other thing that we wanted to do, especially when talking about the climate crisis, was highlight more Indigenous voices. Indigenous people are at the forefront of facing huge losses due to the climate crisis, and oftentimes have been at the forefront of championing the actions that we need to be taking towards conservation, towards energy efficiency. So it was really inspiring hearing from our Indigenous community as well on that. So I'll put that in the chat so that you can all take a look if you're interested.
If I could add a high priority action item, I think a lack of knowledge and a feeling of imminent doom has led to a lot of paralysis by people who otherwise would be keen to participate in the climate action movement towards solving the climate emergency. So I would say also hop on social media, spread the word as make the science and make the message accessible, that there is hope, that there are pathways to be able to reduce warming in the near term. We know how to do it. We have the science, we have the available tools. There's no reason not to be doing it right now. So hop on social media, tell your friends, and get the conversation going.
Yeah, those are great points. And just to add to that as well, I think, I think that the thing with climate change, that's why it's so difficult to address, is that it doesn't come in one shape. It's all shapes and sizes, and it affects so many facets of things. And also, it's not some apocalyptic thing like don't look up, like an asteroid going to destroy the world in a day or two. It's something gradual that affects all of us, but it's difficult to see and visualize. So I think one way to a high priority action as well would be to amplify the voices of vulnerable communities who are affected by this, hugely affected by this, but we don't see that often by the effects of climate change, because again, it comes in all shapes and sizes. So one of the ways to do that is to storytelling and evidence collection and showing how it affects communities and vulnerable communities. So it doesn't stop at all to those who have legal backgrounds. We have to engage people and youth who are working on the ground and in their communities and empower them as well.
Thank you so much, Nicole, and everyone as well. That was extremely inspiring. And before we hop off, this reminds me of one of my favorite Venn diagrams of all time, which I shall share on the screen now. But this is from All We Can Say, and about climate action that we can take part in and how we can figure out what we can do when things seem so overwhelming. So the Venn diagram intersects what brings us joy, what is the work that needs doing, and what are you good at? And combining these three elements into concrete action for the climate based on your level of ability, your knowledge, your experience, your lived experience and everything is critical for us to combine our efforts and create a growing movement, such as with the ICJAO resolution movement that we see has grown to be so big. And I also want to say the joy element is also really important too, especially when you're fighting climate anxiety, because I think being joyful is one of the most radical things we can be, especially in the face of just such scary uncertainty. And the thing is, the solutions are out there, that we can do the solutions. We just have to act now. Hope is not lost. And we see this with all the young people that know this and are working on this today. And I think it's very important. So I can leave this Venn diagram open for everybody. And I want to thank everyone for joining this webinar, and thank you so much to Nicole and to everyone at the World's Youth for Climate Justice, the Normandy Chair for Peace, with Ariel that helped organize this conference that was so helpful and so important in discussing the power advisory opinions and other things that young people and all people can do to achieve climate justice in the near term and the long term. So with that, I say thank you so much, everybody.
Thank you so much.
Thank
Excellent.
you.
Gina, thank you.
Excellent. Thank you. Thank you, Rose.
Thank you.
So we can leave this here, and the next session will be at 7:30 for Latin America. So if you want to stay in and feel free, we'll show some videos. Paulo here from the Asian Research Institute for Environmental Law will share some videos. And if you want some links to that, feel free to message down in our chat box so Paulo can share it with you as well. Thank you once again, everyone. See you for the Latin America session.
In Bangladesh, Professor Nazrul Islam has been working for more than 2 decades to help create a new generation of environmental law champions. Since 1999, he has promoted the study and teaching of environmental law. At the time, this was an elective subject in law schools and classes were poorly attended. For over 20 years, Professor Nazrul used every opportunity to promote environmental law, writing newspaper articles, giving televised talks, publishing research, and giving training courses. His efforts inspired other educators, and together, they raised the awareness of environmental law all over the country. Today, environmental law is mandatory in many law schools, with classes often filled to capacity. These classes nurture new champions like Sayeda Rizwana Hassan. Rizwana joined the Bangladesh and Environmental Lawyers Association, or BELA, in the early 1990s as a fresh graduate. She rose through the ranks and now leads BELA and its 60 environmental defenders who have filed and won several landmark cases. Among the most noteworthy cases was against Bangladesh's notorious ship-breaking industry. Ship-breaking companies purchase decommissioned ships and use unskilled workers, some of them children, to break up and scavenge the ships by hand. This causes severe contamination of shores and waters and lead to deaths, injuries, and diseases for the impoverished laborers. Rizwana and her team filed petitions and cases to stop shipbreaking, bringing it to the Supreme Court. What began with temporary injunctions became the first case in Bangladesh that fined polluters. In 2009, Rizwana and her BELA team won a judgment that temporarily closed 37 shipbreaking yards. Their cases led to new, more stringent regulations for the entire industry. BELA's legal victories continue to grow with each success and have gone so far as to help pass an amendment that enshrines environmental protection in Bangladesh's constitution. This is just one of the stories of the many environmental law champions across Asia who are fighting and winning battles for people and the environment. These champions are making positive changes that will echo for generations. Join us in this movement as we work to develop and support the environmental law champions of tomorrow. Environmental law and human rights are closely intertwined. Often, fighting for one leads to fighting for the other. Such was the case for Surachai and Supapon from N Law in Thailand. Surachai and Supapon were working for a human rights law firm when they were assigned an interesting case. Several dozen community activists had been protesting against the coal power plant. Many of them were charged by the police for trespassing and disorderly conduct. Some were facing years of jail time. As a result, they formed N-Law in 2001, one of Thailand's first organizations dedicated to empowering marginalized communities, protecting their environmental rights through litigation and advocacy. In 2003, N-Law took on the case of Clitty Creek, which would become a landmark environmental case. Since the 1960s, toxic runoff from a local mining operation was polluting the creek, leading to rising cases of lead poisoning among the residents. With no funds for legal assistance, the villagers were powerless against the continuing industrial pollution. With support from N-Law, the Lawyers Council of Thailand, and other legal rights groups, the villagers filed and won 3 cases, including a landmark win at the Supreme Court. The rulings included compensation for more than 150 affected villagers and a restoration of the creek. The Clitty Creek case also set a precedent for court-ordered cleanups of industrial and mining toxic waste sites. This is just one of the stories of the many environmental law champions across Asia who are fighting and winning battles for people and the environment. These champions are making positive changes that will echo for generations. Join us in this movement as we work to develop and support the environmental law champions of tomorrow. In the Philippines, a longtime environmental champion, Professor Jerty Mayo Anda, has been working tirelessly for decades to defend the people and environment of Palawan. In 1990, Jerty founded the Environmental Legal Assistance Center, now one of the Philippines' most active NGOs that helps communities uphold their constitutional rights to a healthy environment. Elak and Jerty work together with civil society groups to educate Indigenous people and local communities to protect their sources of food, water, and livelihoods. ELAC's strategic grassroots approach was critical to their campaign to stop the planned division of Palawan into 3 smaller provinces, which could open doors for the easier passage of unsustainable, exploitative projects. Undaunted by political pressure and powerful interests, Jerty worked with the Save Palawan movement along with church and civic leaders to mobilize students, lawyers, researchers, and community leaders to campaign for One Palawan. Together, they motivated tens of thousands of voters to keep Palawan as one. In 2021, record numbers of Palawan's people let their voices be heard and voted to keep Palawan unified as a single province. This is just one of the stories of the many environmental law champions across Asia who are fighting and winning battles for people and the environment. These champions are making positive changes that will echo for generations. Join us in this movement as we work to develop and support the environmental law champions of tomorrow. In the Philippines, a longtime environmental champion, Professor Jerthy Mayo Anda, has been working tirelessly for decades to defend the people and environment of Palawan. In 1990, Jerthy founded the Environmental Legal Assistance Center, now one of the Philippines' most active NGOs that helps communities uphold their constitutional rights to a healthy environment. Elak and Jerthy work together with civil society groups to educate Indigenous people and local communities to protect their sources of food, water, and livelihoods. ELAC's strategic grassroots approach was critical to their campaign to stop the planned division of Palawan into 3 smaller provinces, which could open doors for the easier passage of unsustainable, exploitative projects. Undaunted by political pressure and powerful interests, Jerthy worked with the Save Palawan movement along with church and civic leaders to mobilize students, lawyers, researchers, and community leaders to campaign for One Palawan. Together, they motivated tens of thousands of voters to keep Palawan as one. In 2021, record numbers of Palawan's people let their voices be heard and voted to keep Palawan unified as a single province. This is just one of the stories of the many environmental law champions across Asia who are fighting and winning battles for people and the environment. These champions are making positive changes that will echo for generations. Join us in this movement as we work to develop and support the environmental law champions of tomorrow.
Listo, muy buenas tardes a todas y todos. Mi nombre es José Daniel Rodríguez y junto con mi colega Elisa Granzotto, que está acá conmigo también, coordinamos el Frente para América Latina de World Youth for Climate Justice. Es un gusto para mí darles a todas y a todos la bienvenida a este panel sobre opiniones consultivas y justicia climática en las Américas. El propósito de este panel es explorar la interacción entre las dos solicitudes de opiniones consultivas que están ahorita en curso, una ya ante la Corte Interamericana de Derechos Humanos presentada por Chile y Colombia, y otra que será votada el 29 de marzo para solicitar a la Corte Internacional de Justicia una opinión consultiva sobre las obligaciones internacionales de los estados frente al cambio climático. El día de hoy me acompaña Marco Yáñez, él será el moderador del panel. Es un joven abogado chileno quien fungió como joven negociador de Chile en la COP26 y también fue coordinador del pabellón de Chile en la COP27. Y contamos también con un panel de lujo de expertas y expertos destacados en el derecho internacional de los derechos humanos y derecho internacional ambiental, a quien también tengo el gusto de presentarles. Nos acompaña Viviana Krisisevich, quien es directora ejecutiva del Centro por la Justicia y el Derecho Internacional, CEGIL, quien tiene una experiencia extensiva en litigio ante el Sistema Interamericano de Derechos Humanos. Y bueno, CEGIL también ha estado detrás de la solicitud de opinión consultiva ante la Corte Interamericana de Derechos Humanos. Entonces, muchísimas gracias, Viviana, por acompañarnos. También contamos con la presencia de Patricia Tarre Moser. Ella es experta internacional y consultora independiente en el derecho internacional de los derechos humanos. También trabajó por los últimos 10 años como abogada ante la Corte Interamericana de Derechos Humanos, donde tuvo también la oportunidad de contribuir a la jurisprudencia de la Corte en materia de medio ambiente y derechos humanos, y actualmente tiene una plataforma de educación en línea en materia de derechos humanos. Bienvenida, Patricia. Nos acompaña también el día de hoy el profesor Mario Peña Chacón, es consultor internacional en Derecho Ambiental y Derecho Internacional Ambiental de la Unión Internacional para la Conservación de la Naturaleza y varios organismos de las Naciones Unidas, como el Programa de Naciones Unidas para el Medio Ambiente y para el Desarrollo. También coordina la maestría en Derecho Ambiental de la Universidad de Costa Rica. Bienvenido, profesor. Y también nos acompaña el día de hoy Jorge Calderón Gamboa. Él es experto independiente de las Naciones Unidas sobre el programa Harmony with Nature y también trabajó por 12 años ante la Corte Interamericana de Derechos Humanos, donde contribuyó significativamente al cambio jurisprudencial de la Corte en el reconocimiento de los derechos económicos, sociales, culturales y ambientales. El panel del día de hoy funcionará de la siguiente forma. Bienvenido, Jorge. Marco hará una pregunta a cada una de las personas panelistas. La persona panelista quien está dirigida a la pregunta tendrá 10 minutos para contestarla y luego el resto de las y los panelistas tendrán 2 minutos adicionales para reaccionar o brindar, digamos, complementar la respuesta que ya ha sido dada a la pregunta. Al final tendremos un espacio para 2 preguntas del público. Entonces, sin más, le paso la palabra a Marco para iniciar con la conversación. Muchísimas gracias.
Muchas gracias, José. Gracias por esa bienvenida y por esas palabras. Y por supuesto, darle la bienvenida a los y las panelistas que tenemos acá. Y sin más, comencemos con las preguntas que tenemos preparadas para ustedes. La primera pregunta va dirigida al profesor Mario Peña. Me gustaría saber cuáles considera que son los principales retos para la protección de los derechos humanos frente a la crisis climática en las Américas. Profesor, gracias.
Muy buenas tardes, Marco, y muchas gracias también a Marco y a José Daniel y a los organizadores de este evento. Estoy muy contento de compartir con un panel de lujo como el que estamos hoy. Ok, la pregunta es como la pregunta del $1.000.000, ¿verdad, Marco? ¿Cuáles son los retos? Bueno, son muchísimos, ¿verdad? Y aquí tal vez me voy a recargar un poco en una frase que dijo Michelle Bachelet cuando estuvo como alta comisionada de derechos humanos, que nos dice, bueno, en el 2019 dice que entre los múltiples retos a los que se han enfrentado los derechos humanos desde la Segunda Guerra Mundial, quizá sea la emergencia climática mundial la que representa una amenaza de mayor magnitud. Entonces vemos el reto al que nos estamos enfrentando. De acuerdo a las teorías que ha venido desarrollando, bueno, que desarrolló don Paul Crutzen, Premio Nobel de Química, respecto a la nueva era geológica en la que estamos viviendo, que se llama la era del Antropoceno. Por primera vez el ser humano marca un estrato geológico en la vida del planeta. Tenemos 9 grandes límites planetarios. Estos límites planetarios son aquellos 9 grandes procesos fundamentales que sustentan la vida en la Tierra y hacen que el planeta Tierra sea un espacio operativo seguro para los seres humanos y para las demás especies. Bueno, resulta que ya hemos traspasado 5 de esos 9 grandes límites planetarios que permiten que el planeta sea un sitio seguro para nosotros y para las demás especies. Es algo así como comprar en una rifa, comprar 5 de los 9 boletos que hay disponibles, ¿verdad? En algún momento nos vamos a ganar la rifa. Ok, ¿cuáles son esos 9 grandes límites planetarios que ya, perdón, 5 de los 9 que ya traspasamos? Integridad de la biosfera, el ciclo bioquímico, el sistema suelo, agua dulce, que lo traspasamos el año pasado, por cierto, lastimosamente, y por supuesto, cambio climático. El cambio climático supone una ampliación o amplificación de los riesgos para nuestra sociedad, para las personas y para las demás especies con las que compartimos el planeta. Por ello es que la lucha contra el cambio climático plantea problemas de justicia, problemas de igualdad, no solo entre las naciones, sino también entre las generaciones. Es un tema intergeneracional e interestatal. América Latina y el Caribe es la región más desigual del planeta en materia social y en materia económica. Somos altamente vulnerables a los efectos del cambio climático. O sea, todos los días estamos viendo noticias sobre sequías, inundaciones, olas de calor, huracanes, incendios, no sé, pérdida de la línea costera, entre muchos otros eventos catastróficos que estamos viviendo. Para nosotros, pasar de 1.5 grados a 2 grados, a 2,5 grados o a 3 grados de calentamiento a nivel global, como región, representará inseguridad alimentaria, aumento de la migración forzada, que ya la estamos viendo, y la proliferación, por supuesto, de enfermedades y muerte. Luego de la era COVID, ¿verdad? Si es que ya podemos hablar de que estamos pasando un poquito la era del COVID, o estamos en el post-COVID, digamos. Para nosotros, América Latina representa el cambio climático y la emergencia climática, retroceder en los avances que hemos tenido en materia social, en materia de desarrollo, en materia de salud y en materia de reducción de pobreza. Entonces vean que el tema es fundamental. Nuestra región no está ajena al tema. Podemos hablar de una especie de constitucionalismo climático latinoamericano. Hay 4 estados de nuestra región que han elevado a rango constitucional el sistema clima. Aquí estoy hablando de Venezuela, que lo hizo en el 99, Ecuador en el 2008, República Dominicana en el 2015 y Cuba en el 2019. De igual manera, nuestra región ha sido, ¿cómo se llama? Hemos priorizado el tema de cambio climático a través de leyes climáticas o leyes marcos sobre cambio climático. Aquí tenemos que México tiene su ley en el 2012, Guatemala en el 2013, Honduras en el 2014, Perú en el 2018, Argentina, Colombia en el 2018, Paraguay en el 2017 y el último fue Chile en el 2022. Y también nuestra región es un hervidero del experimento de litigios climáticos. O sea, la plataforma de litigio climático para América Latina que lleva a la Asociación Interamericana de Derecho Ambiental, la AIDA, dice que existen, al menos tiene mapeados 53 casos de litigios climáticos en nuestra región, todos ellos o en su gran mayoría relacionados con derechos humanos. Y es que existe una relación intrínseca de interdependencia entre cambio climático y derechos humanos. El cambio climático o la emergencia climática o la crisis climática tiene repercusiones sobre la vida, sobre la salud, sobre la alimentación, sobre el derecho al agua y el derecho al saneamiento, sobre el derecho a un medio ambiente sano, sobre el nivel de vida adecuada, sobre el derecho a la vivienda, sobre el derecho a la propiedad, sobre el derecho a la libre determinación, sobre el derecho a la cultura y al desarrollo, sobre el derecho a la paz y, por supuesto, sobre los derechos de acceso. O sea, no hay quite. El cambio climático tiene efectos directos sobre el universo de derechos humanos, especialmente aquellos que estamos llamando derechos humanos, bueno, que la Corte Interamericana llamó derechos humanos sustantivos y derechos humanos ambientales procedimentales. Y el cambio climático se ensaña con las personas o grupos en estado de vulnerabilidad, ¿verdad? Y aquí podemos citar a los que son muy comunes en nuestra región, los pueblos indígenas, los afrodescendientes, los campesinos que dependen de su tierra, e incluso en el caso de los pueblos indígenas y afrodescendientes, tienen un ligamen especial, ancestral, incluso religioso con sus tierras, que se verán afectadas por los efectos del cambio climático. Como grupos y personas vulnerables vamos a encontrar los niños y las niñas, los adolescentes, las personas adultas mayores, las personas con discapacidad, las minorías, los migrantes, las mujeres, por supuesto, y las comunidades costeras y las islas pequeñas. Aquí también deberíamos incluir a las personas o grupos que se dedican a la defensa de los derechos humanos, especialmente los derechos humanos ambientales, que están íntimamente relacionados con el bien jurídico que vamos a denominar bien jurídico clima, o lo que en algún momento podríamos llegar a hablar del derecho a un clima seguro. Si logran, digamos, en algún momento independizarse, como lo hizo el derecho al agua y al saneamiento como derecho autónomo. Les decía que los pueblos indígenas, las comunidades afrodescendientes y los grupos campesinos son poblaciones en peligro porque tienen una forma de vida que está íntimamente relacionada con su territorio. Esto lo ha entendido muy bien nuestra Corte Interamericana de Derechos Humanos. Y tomemos en cuenta que también, y eso es otro aspecto que a veces no lo vemos mucho, y es que todas aquellas medidas de adaptación y mitigación que nuestros estados están comprometiendo ante la comunidad internacional a raíz del Convenio Marco de Cambio Climático, a raíz del Acuerdo de París, pueden traer también consigo riesgos para el disfrute de los derechos humanos, ¿verdad? Entonces la transición hacia la transición climática tiene que tomar en cuenta o tiene que hacerse con un enfoque necesariamente de derechos humanos y tomar en cuenta el conocimiento tradicional. Les decía que el clima seguro, ya sea que lo veamos como un bien jurídico autónomo o como parte del contenido del derecho humano al ambiente, al menos esta última opción es la que ha venido desarrollando el relator de Naciones Unidas sobre Medio Ambiente y Derechos Humanos, el señor Boyd, en uno de sus informes, si no me equivoco, fue el del 2019, donde desarrolla el contenido del derecho humano al ambiente. El relator nos dice que el contenido actualmente del derecho al ambiente es aire limpio, agua segura, saneamiento, alimentos sanos y sostenibles, un medio ambiente libre de tóxicos, ecosistemas biodiversos y sanos y clima seguro. O sea, el clima como tal, como bien jurídico, forma parte, al menos hasta el momento, del derecho humano, del contenido o núcleo del derecho humano a un ambiente sano. Y es que en nuestra región contamos por supuesto, con el sistema interamericano, y ese sistema interamericano de derechos humanos contiene un acervo común o un jus común ambiental interamericano, que la Corte ya ha venido desarrollando primeramente vastamente en temas de pueblos indígenas, propiedad y vida digna. Luego todo ese acervo lo recopila en opinión consultiva 2317 y lo aplica a dos casos relativamente recientes, ¿verdad? Que son el caso La Cajona contra Argentina, casos contenciosos, y el reciente caso de la semana pasada notificado, Barahona Bray contra Chile. En la opinión 23, la Corte destacó que siempre que exista un nexo de causalidad entre los estados, deben proteger los derechos humanos si se ven afectados por daños ambientales, incluso aquellos daños fuera de su territorio. También la Corte reconoce que el derecho al ambiente es justiciable a pesar de no estar expresamente incluido en la Convención Americana. Y la Corte, bajo un enfoque ecocéntrico, nos dice que el derecho al ambiente, al menos en el sistema interamericano, y eso es un grandísimo logro, tutela no solo a los seres humanos, sino que también tutela a los ecosistemas, a los demás seres vivos con los que compartimos el planeta por su valor intrínseco. Entonces, sería completamente posible, de acuerdo al desarrollo de la opinión 23, repetido luego en La Cajona contra Argentina, sería posible que la Corte tutele a los elementos del ambiente y a los componentes del ambiente como intereses jurídicos en sí mismos, aun en casos donde no exista certeza respecto a las afectaciones sobre los seres humanos. Ese acervo común del que estamos hablando, interamericano, contiene una serie de estándares que dijimos que están en construcción, pero que van a ser súper importantes en materia de la opinión consultiva 30, se supone que ese va a ser el número, sobre emergencia climática. Ese acervo incluye no solo los instrumentos propios de nuestro sistema interamericano, sino el derecho internacional de los derechos humanos y el derecho internacional ambiental, al cual en la opinión consultiva 23, la Corte Interamericana, por decirlo así, los interamericanizó, los incluyó dentro del corpus juris interamericano. La opinión consultiva 30, ya para ir cerrando, podría tener efectos que llamamos un efecto dominó relevante sobre la gobernanza climática regional y global, y por supuesto sobre la protección de los derechos humanos. Podría generar innovaciones en el derecho internacional, en el derecho internacional de los derechos humanos, especialmente como lo veremos ahora más adelante probablemente, en materia de interpretación de las obligaciones de derechos humanos en materia de debida diligencia y de responsabilidades comunes pero diferenciadas, las cuales no fueron abordadas de manera extensa en la opinión consultiva 23. Entonces estamos frente a una oportunidad de oro para desarrollar estos temas en el sistema interamericano. Te devuelvo la palabra, Marco, porque creo que ya me pasé del tiempo.
Sí, así es, sí, por 2 minutos, profesor. Pero está todo bien, de todas maneras recordamos a los panelistas que traten de ajustarse al tiempo establecido. Y del mismo modo les recordamos a la audiencia que por favor interactúen con nosotros, que envíen sus preguntas, estamos atentos a ellas. Y también ahora les recuerdo a los panelistas, a las panelistas que complementen lo que ha señalado el profesor, disponen de 2 minutos para complementar lo que ha señalado el profesor en su intervención. Así que estamos atentos. Gracias. Si algún panelista desea complementar lo que el profesor ha señalado, por favor puede levantar la mano o tomar la palabra directamente. Ok, veo que nadie desea complementar lo del profesor. Último llamado. Ok, perfecto. Entonces podemos pasar a la siguiente pregunta. La siguiente pregunta va para Viviana Kristisevich. Y nosotros sabemos que del Centro por la Justicia y el Derecho Internacional han impulsado esta solicitud de opinión consultiva ante la Corte Interamericana. Entonces, quisiéramos saber si puedes contarnos más sobre este proceso. Y por otro lado, la pregunta es, ¿podrían estas opiniones consultivas empoderar o facilitar el acceso a la justicia de las comunidades más vulnerables en las Américas frente al cambio climático? Gracias, Viviana.
Diana, disculpa, no te escuchamos.
¿Me escuchan?
Sí, ahora sí.
Ay, qué bueno. Bueno, hoy mi personalidad magnética está interfiriendo en todos los electrónicos. Se murió mi computadora, ahora no funcionaba el audio, pero bueno, quería agradecerle al profesor Mario Peña Chacón la introducción que nos hizo, porque creo que fue muy comprensiva de los temas que tenemos que tratar para pensar en el proceso que se abre con esta solicitud de opinión consultiva a la Corte Interamericana. Y también quería agradecer enormemente la invitación de José, de Marco y la oportunidad de interactuar con juristas de alta talla como Patricia y Jorge también. Muchas organizaciones y personas nos hemos hecho la pregunta una y otra vez de cuál es nuestra responsabilidad frente a esta situación de crisis y de sobrevivencia y el enorme desafío de enfrentar a la crisis climática que tiene nuestra generación y las consecuencias que eso tiene para las generaciones futuras y para el futuro de la humanidad, ¿no? Y los impactos que esto tiene para el presente, para nuestra región, para el mundo, para distintas comunidades, naciones, personas, grupos que están siendo afectados, que estamos siendo afectados de manera directa por la emergencia climática. Y en ese espíritu, empezamos a pensar a partir de las estrategias que teníamos de trabajo con pueblos indígenas y con derechos de acceso y con el derecho a la naturaleza y los derechos a la tierra, qué más podíamos hacer para entender y abordar la emergencia climática. Y de esa reflexión surgió la profunda convicción de que no solo la emergencia climática tenía un impacto muy fuerte sobre una serie de derechos, como lo explicó muy bien el profesor Mario Peña Chacón, sino que los derechos humanos podían tener un papel fundamental en el tipo de soluciones que íbamos a tener, en que estas soluciones fueran más justas, más igualitarias, más sustentables, y es por eso que nos pusimos a trabajar con una serie de estrategias para entender cuáles eran los baches jurídicos que existían en el desarrollo del derecho internacional de los derechos humanos, del derecho constitucional, en el abordaje de algunos de los temas centrales para las afectaciones de derechos vinculadas a la emergencia climática. E identificamos algunos espacios de intersección y baches en el desarrollo de estrategias, estándares, comunidades de conocimiento. Iniciamos una serie de casos de litigio, pero también nos pusimos junto con juristas y científicos a pensar en si era posible trabajar ante la Corte Interamericana para que la Corte desarrolle estándares y guías, pautas orientativas que movilicen un debate mucho más interesante, intenso, interdisciplinario en nuestra región sobre estos temas, y también que nos dé pautas orientativas que nos sirvan para el litigio, para la implementación, para la definición de derechos de comunidades, países, personas. Y en ese espíritu nos acercamos a varios gobiernos, a la propia Comisión Interamericana en su momento, y finalmente, hacia fines del año pasado, logramos que 2 gobiernos que tenían una agenda fuerte de derechos humanos, de sistema interamericano y de derechos de la naturaleza y de abordaje del cambio climático, quisieran de alguna manera catalizar este proceso de debate y de elaboración de estándares a nivel regional, con la participación fundamental de la Corte Interamericana, pero que se va a dar a través de un proceso que en general, y Jorge y Patricia pueden hablar de eso en extenso, son procesos muy participativos, ¿no? En los que hay posibilidades de presentar distintos tipos de observaciones y hacer algunos tipos de intervenciones de carácter oral. Entonces, para contar una historia larga en corto, logramos involucrarnos en esta discusión acerca de cuáles podían ser algunos de los temas ejes para tratar, en los que la Corte Interamericana puede hacer contribuciones significativas, importantes para este momento de la región y del mundo. Y logramos que los estados de Chile y Colombia inicien este camino de manera conjunta, que luego termina con la presentación de la solicitud de opinión consultiva en el 8 de enero de este año. La manera en la que nosotros como defensores de derechos humanos y defensoras de derechos humanos pensamos en estos temas siempre es teniendo en cuenta a las personas, a las comunidades y a la situación, los impactos diferenciados que pueden llegar a tener algunas de estas, de las afectaciones, pero también de las soluciones sobre las comunidades que están en mayor situación de vulnerabilidad. Y la emergencia tiene, como planteaba el profesor Peña Chacón, dimensiones muy discriminatorias por a quienes afecta en mayor medida, no solo de personas y personas en función de características interseccionales o grupos en función de características interseccionales, sino también naciones, ¿no? Existen esos impactos diferenciados muy fuertes. A lo largo de las preguntas que se le está formulando como preguntas para resolver a la Corte Interamericana, se incluyen en cada una de esas preguntas consideraciones de impactos discriminatorios que pueden ser muy importantes para mejorar el acceso a la justicia y la protección de los derechos de las comunidades y de las personas que estén en situación de mayor vulnerabilidad. Ya como decía, en sí la opinión consultiva va a dar, al dar respuesta a la situación de emergencia climática, va a tener un impacto igualador, porque creemos que es una respuesta en derechos que va a afectar y beneficiar a aquellos que están en situación de mayor debilidad. Pero luego hay una serie de preguntas muy, muy importantes que dan la oportunidad de tratar temas centrales para cuestiones de igualdad. Por ejemplo, entre ellas, el tema de las afectaciones a generaciones futuras y a la juventud y la niñez. Esa es una pregunta clave. Las preguntas sobre acceso a la información y producción positiva de información, pero también de acceso y de medidas de mitigación y de la manera en la que tiene que llegar la información para la adaptación, para la mitigación a las comunidades en situación de riesgo o que pueden tener una afectación diferencial. Hay preguntas acerca de los medios para la participación de la juventud y de los niños en los procedimientos judiciales y administrativos que tienen que ver con cambio climático. O sea, hay temas de acceso a la justicia y cómo se pueden dar los temas de participación y consulta para tener en cuenta no solo los impactos, sino la voz de aquellos que están en una situación de mayor desventaja. Hay cuestiones que tienen que ver con personas defensoras, digamos, las personas defensoras del medio ambiente, de la tierra, los pueblos indígenas, las comunidades campesinas, tienen afectaciones diferenciales y hay una serie de preguntas que están destinadas a fortalecer la voz, la protección, la información acerca de afectaciones diferenciadas. Hay una pregunta, por ejemplo, específica sobre defensoras mujeres del medio ambiente y el territorio en el contexto de la emergencia climática. Otra pregunta sobre la necesidad de tener en cuenta factores interseccionales e impactos diferenciados en la defensa del derecho de defender derechos. Y por supuesto hay una pregunta muy importante que es la pregunta sobre obligaciones compartidas y diferenciadas. Esa pregunta también permite reflexiones a nivel nacional, comunitario, subregional, subnacional, cuál es la responsabilidad de las ciudades, de las provincias, de los estados, las obligaciones de carácter regional y las diferencias de impacto en lo regional y en lo global, y las consecuencias que pueden existir en derechos, en términos de derechos a la reparación, obligaciones de cooperación, entre otras. Entonces esas son como algunas de las dimensiones en las que la opinión consultiva va a permitir la mejor y mayor garantía y participación de las comunidades y personas, comunidades, naciones en situación de mayor desventaja en la elaboración de soluciones frente a la emergencia climática que tengan en cuenta los derechos y que lleven a soluciones más justas, igualitarias y sostenibles. Y creo que para nosotros, desde el CEGIL, como una organización que es una organización feminista también y es una organización que viene del movimiento de derechos humanos, es muy importante lo que nos vaya a dar la Corte en términos de el resultado de la opinión consultiva, pero también es muy, muy importante el proceso, porque creemos que en este proceso de debate que se va a dar en el próximo año, vamos a tener la oportunidad de aprender un montón, de debatir un montón, de generar más comunidades de conocimiento y práctica, escuchando a aquellas personas que están en situaciones de mayor riesgo, haciendo los puentes y escuchándonos con las expertas y expertos y ayudando como juristas también a traducir algunas de esas inquietudes, necesidades en función de los marcos jurídicos en mejores estándares para guiar lo que sigue y estar un poquito más a la altura del desafío que tenemos con la emergencia climática. Así que gracias por la discusión.
Muchas gracias, Viviana, por la interesante intervención. Le recordamos a la audiencia que pueden realizar sus preguntas, estamos atentos a ellas. Así como también le recuerdo a los y las panelistas que pueden complementar ahora mismo la intervención de Viviana. Así que nuevamente los escuchamos si quieren intervenir.
Marco, un simple comentario. Estaba revisando, ahora que la compañera Viviana dio su exposición sobre la opinión, sobre la solicitud de opinión consultiva. Estaba revisando la página web de la Corte Interamericana y hasta este momento no aparece alguna resolución o colgada en la ceja de opiniones consultivas. Veo que ya actualizaron y está apareciendo la opinión consultiva que solicitó México el 11 de noviembre del 2022. Aún la opinión consultiva que sería supuestamente la 30, una resolución de darle todavía el trámite respectivo. Se supondría que en este periodo de sesiones, y ahí Patricia es que maneja mejor esto que yo, que supone que en este periodo de sesiones que está ocurriendo en esta semana precisamente, podría venir esa resolución dándole traslado, trámite, como le queramos decir, o admitiendo para su conocimiento la opinión consultiva. Ese era mi único comentario. Te devuelvo la palabra, Marco.
Gracias, profesor. Sí, y justamente ahora pasamos con Patricia. La siguiente pregunta es para ella. Y la pregunta es, ¿cuáles son las principales limitaciones del marco jurídico internacional para abordar los impactos que el cambio climático tiene sobre los derechos humanos? Además, otra pregunta dentro de esta, ¿considera que las opiniones consultivas de la Corte Interamericana y la Corte Internacional de Justicia pueden servir para superar estas limitaciones? Muchas gracias, Patricia.
Muchas gracias a ti, Marco, y muchas gracias por esta invitación y por ser parte de este panel tan importante. Bueno, para dar respuesta a esta pregunta, creo que hay que refrescar un poco y resumir un poco el derecho internacional de cambio climático, ¿no? ¿Qué es lo que dice ese derecho para entender con qué es que tenemos que trabajar, ¿no? Ya sea en la Corte Internacional de Justicia o en la Corte Interamericana. Y aquí quisiera mencionar dos tratados, ¿no? El primero, la Convención Marco de Cambio Climático, que es esta convención que simplemente establece tal cual como su nombre dice, ¿no? Unos parámetros, un marco sobre los cuales la idea es que se generen nuevos acuerdos para que globalmente se logre, pues, en los estados poner de acuerdo en cuáles son estas medidas que van a tomar con respecto al cambio climático. Uno de esos acuerdos es el llamado Acuerdo de París, que a pesar de, como su nombre indica, pareciera que fuera como un acuerdo, pero no, esto es un tratado internacional que es vinculante para todos los estados que lo hayan ratificado, que son la gran mayoría de los estados del mundo. Entonces, este Acuerdo de París establece un punto importante, que dicen los estados se comprometen a mantener el aumento de la temperatura media mundial por debajo de 2 grados centígrados con respecto a los niveles preindustriales y proseguir los esfuerzos para limitar el aumento que ya se ha producido a 1.5. Entonces, el acuerdo es, tratemos de mantenernos en 1.5, pero no superemos 2. O sea, por nada superemos 2. Ese es el acuerdo. Pero ¿qué pasa? No es que cada estado aceptó comprometerse en una disminución específica de emisiones de gases de efecto invernadero. Ese es otro detalle importante. ¿Cómo logramos mantener esas temperaturas, digamos, y no subir las temperaturas? Bueno, lo que nos dice la ciencia es que la manera para hacer eso, ¿verdad?, es reducir las emisiones de gases de efecto invernadero, ¿verdad? Entonces, ¿qué dice el Acuerdo de París? Dice, bueno, cada estado debe comprometerse a reducir sus emisiones de gases de efecto invernadero y presentarnos un plan de cómo va a cumplir con este compromiso. Pero el Acuerdo de París no establece digamos, un artículo que diga cada estado tiene que reducir sus emisiones en un 20%, en un 30%, en un 40%. Eso no lo dice. Simplemente queda para cada estado comprometerse. La única obligación es, en general, no pasemos de el 2 y tratemos de mantenernos en 1.5 y luego cada estado va comprometiéndose. Entonces, esto es una gran limitación en el marco jurídico internacional, porque no tenemos obligaciones claras de cuánto es lo que cada estado debe comprometerse para mitigar el cambio climático. Hay más limitaciones, pero yo quiero enfocarme justamente en esta el día de hoy, porque pienso que en esta limitación específicamente pudiéramos tener alguna respuesta, ya sea por parte de la Corte Internacional de Justicia o por parte de la Corte Interamericana. En ambas propuestas de solicitudes de opinión consultiva hay preguntas que se relacionan con este tema. Quizás no tan claro como yo lo estoy presentando el día de hoy, pero sí están relacionadas. Por ejemplo, en la resolución, la propuesta de resolución para la solicitud de opinión consultiva ante la Corte Internacional de Justicia, hay una pregunta que dice, ¿qué obligaciones tienen los estados conforme al derecho internacional para garantizar la protección del sistema climático y otros elementos del medio ambiente frente a las emisiones antropogénicas de gases de efecto invernadero? Allí podemos meter esta discusión, ¿no? Y luego, dentro de la opinión consultiva, de la solicitud de opinión consultiva ante la Corte Interamericana, tenemos cuál es el de atención que tienen los estados frente a fenómenos climáticos generados por el calentamiento, incluyendo tomando en cuenta el Acuerdo de París y el consenso que al estar global más de 1.5 grados. Entonces, ¿qué pienso yo? Es que tenemos primero una laguna entre las obligaciones de los estados en el derecho, digamos, de cambio climático, una laguna de cuánto tiene que hacer cada estado para prevenir, o bueno, ya en realidad mitigar el cambio climático mediante las reducciones de gases de efecto invernadero. Pero tenemos otras obligaciones internacionales que nos pudiesen dar luz en cómo se debe llenar esa laguna, tomando en cuenta lo que nos dice la ciencia. Específicamente tenemos obligaciones específicas de derechos humanos de prevenir, ¿verdad?, afectaciones a los derechos humanos. En la opinión consultiva 23 que mencionaba el colega Mario, pues la Corte Interamericana ya dijo que los estados tienen una obligación de prevenir los daños significativos al medio ambiente que puedan causar una afectación a la vida y a la integridad de las personas, ¿ok? Eso por un lado. Y luego dice la Corte también, Y cuando hay no haya certeza científica sobre un posible daño grave o irreversible a la vida e integridad de las personas, los estados tienen que tomar medidas efectivas para prevenir ese posible daño. Y esto, digamos, es dentro del marco del llamado principio de precaución que la manera. Entonces, ¿qué está pasando? Opinión y en base a lo que está en la misma solicitud de opinión consultiva presentada por Colombia y Chile ante la Corte, que pudiéramos interpretar que ya existe, digamos, sacando de este principio de prevención y este principio de precaución, ya existe una obligación clara de que cada estado tiene que reducir fuertemente sus emisiones de gases de efecto invernadero. ¿Por qué? Porque sabemos que estamos muy cerca ya de llegar a este cambio que no quisiéramos llegar de 1.5 grados centígrados de diferencia comparándolos con niveles preindustriales de temperatura climática, ¿no? Y cuando eso pase, ya muchos científicos, y esto lo ponen los estados en la solicitud de opinión consultiva, muchos científicos consideran que esto pone en peligro a la vida e integridad de las personas. Y esto puede suceder entre el 2030 y el 2052. O sea, en el peor de los casos estamos a 7 años, ¿ok? 7 años de que esto suceda. Entonces, para mí es claro que aquí esto ya se activa claramente el nivel de prevención que habló la Corte Interamericana en la opinión consultiva 23, pero además se activa el nivel de precaución, porque los científicos quizás no están de acuerdo todos, porque la manera como lo dice los estados solicitantes en su solicitud de opinión consultiva es, algunos científicos consideran que al llegar ya solo con 1.5 grados de diferencia desde niveles preindustriales se pone en peligro la vida. Entonces digamos que no tenemos certeza científica, digamos que ese es el supuesto, entonces nos aplica el principio de precaución. Y si nos aplica el principio de precaución, los estados tienen que tomar medidas eficaces para prevenir, para evitar que se concrete ese daño grave e irreversible a la vida que nos genera esta falta de reducción de cambio de los gases de efecto invernadero. Entonces, bajo esta interpretación, ¿verdad? Yo considero que esta opinión consultiva ante la Corte Interamericana, si sigue los criterios que ya estableció en la opinión consultiva 23, y si sigue el mismo espíritu, que es rellenar con las obligaciones de derechos humanos esos vacíos que dejan otras áreas del derecho, entonces la Corte pudiera ayudarnos, la Corte Interamericana pudiera ayudarnos a determinar cuánto es que cada estado tiene que reducir en sus emisiones de gases de efecto invernadero. Lo mismo hizo la Corte Interamericana con el principio de precaución cuando estaba decidiendo la opinión consultiva 23. ¿Por qué? Porque con el principio de precaución hay un problema, digamos, a nivel internacional, no está consagrado en ningún tratado general de que exista un principio de precaución en materia ambiental. Está consagrado en diferentes tratados internacionales, pero no de manera general. Y ya había decisiones de la Corte Internacional de Justicia, del Tribunal Internacional de Derechos del Mar, estableciendo que no había una costumbre internacional. Entonces teníamos una laguna, como tenemos aquí en el caso de las emisiones de efecto invernadero, sobre qué es lo que dice el derecho internacional sobre el principio de precaución. Sin embargo, la Corte dijo, ¿no? Reconoció, dijo, sí, existe esta laguna, pero aquí estamos en un tribunal de derechos humanos y al tratarse de riesgos a la vida e integridad de personas, tenemos que aplicar un principio de precaución cuando hay una ausencia de certeza científica y un riesgo grave e irreversible a la vida y personas de los seres humanos. Lo mismo puede hacer la Corte Interamericana en esta situación, con esta laguna que nos está frenando tan fuertemente en esas actividades que tenemos que tomar ya para reducir los gases de efecto invernadero. Porque sí, es cierto, yo estoy diciendo 1.5, 2 grados, pero la realidad es que esto es una cantidad que se compara en relación con niveles preindustriales. Ya llevamos más de 1 grado. Entonces no es que nos queda mucho tiempo, ¿no? Si lo comparamos con este nivel, que es como se mide, digamos, científicamente de temperatura antes de niveles preindustriales. Entonces, este actuar es necesario que se haga ya. Además, ya la ciencia nos dice que puede que se llegue a 1.5 en el 2030. Entonces, bajo este supuesto, yo considero que la solicitud de opinión consultiva y la respuesta que dé la Corte Interamericana, en este caso y específicamente en esta pregunta, pudiera ayudarnos a dar respuesta y llenar ese vacío, al menos al menos con parámetros más claros que los que nos da el Acuerdo de París. Y lo mismo con la opinión consultiva que se vaya a presentar ante la Corte Internacional de Justicia. Sin embargo, digamos, claramente conozco más el trabajo de la Corte Interamericana que el de la Corte Internacional de Justicia y no pierdo mis esperanzas de que la Corte Internacional de Justicia también se pronuncie en este sentido, pero le tengo más esperanzas a que lo haga la Corte Interamericana porque ya lo ha hecho en otros casos, como en el supuesto que acabo de explicar del principio de precaución. Y ya con eso terminaría mi intervención. Muchísimas gracias.
Muchas gracias, Patricia, por esa excelente intervención. Nuevamente, como saben, invitamos a los y las panelistas que deseen complementar esta intervención, pueden hacerlo ahora inmediatamente. No habiendo intervenciones, entonces, recordamos a la audiencia que pueden seguir realizando sus preguntas y pasamos a la siguiente pregunta. Esta vez es para Jorge Calderón. Y la pregunta es, ¿cuáles considera que son los principales desafíos que enfrentarán la Corte Internacional de Justicia y la Corte Interamericana de Derechos Humanos al abordar estas opiniones consultivas? Gracias, Jorge.
Muchas gracias, Marco. Bueno, primero que nada, gracias a la invitación del Ware Climate Justice, particularmente a José Daniel y Marcos, y saludo a mis colegas de este panel, que les respeto muchísimo, Viviana, Patricia y Mario. Pues para mí estas opiniones consultivas son una gran oportunidad evolutiva realmente para el derecho internacional. Y permítanme comenzar con lo que consideraríamos un contexto de la carrera que se está dando en esta materia. Y para ello voy a señalar 10 antecedentes o hitos claves que desde mi perspectiva hacen que arranque esta carrera de derecho internacional. La primera de ellos es que hace 5 años tenemos la jurisprudencia DESCA de la Corte Interamericana a partir del caso Lagos del Campo, el 31 de agosto de 2020, que denota el reconocimiento de los DESCA, que es materia justamente de esta opinión consultiva en su integridad, y asimismo del derecho al medio ambiente como un derecho autónomo, lo cual se consagró meses después con el segundo hito, que sería la opinión consultiva 23 sobre medio ambiente y derechos humanos, que ya se mencionó, donde más allá de lo que planteó la litis, los peticionarios, en ese caso Colombia, vía abordes indirectos de las afectaciones medioambientales, en su párrafo 62 reconoció el derecho a un medio ambiente sano, es un derecho autónomo previsto en el artículo 26 de la Convención Americana, con una doble dimensión de protección. Por una parte, respecto a los elementos de la naturaleza en sí, y por la otra, por su afectación en perjuicio de las personas. Y también se reconoció una tendencia en la región sobre el reconocimiento de los derechos de la naturaleza. Y esto vamos a ver que termina siendo muy importante para el panel que representa la Corte Interamericana. Un tercer antecedente es que en el 2021 la Corte Interamericana decide su primer caso contencioso, el caso Indígenas, miembros de LACA JONAD, Nuestra Tierra contra Argentina, donde ya declara una violación directa al medio ambiente, particularmente al derecho al agua. Otro avance importante en el sistema interamericano es la resolución 3-2021 de la Comisión Interamericana de Derechos Humanos, particularmente de la relatoría DESCA, sobre emergencia climática, alcance y obligaciones interamericanas de derechos humanos, que ya pues da un esbozo de cómo se puede abordar esta temática. Un quinto punto sería que en 2022 la Asamblea General de Naciones Unidas reconoce por primera ocasión el derecho a un medio ambiente limpio, saludable y sostenible, con una votación de 161 estados a favor, 8 abstenciones y ningún voto en contra. Un sexto punto sería recientemente en el 2022, el Comité de Derechos Humanos de la ONU resuelve el caso asunto Daniel Billy y otros contra Australia, o sea, los habitantes del estrecho de Torres, determinando que Australia había violado los derechos al disfrute de la cultura y vida privada de los familiares bajo sus obligaciones del Pacto Internacional de Derechos Civiles y Políticos, al no haberlos protegido de los impactos del cambio climático. Este es el primer fallo de un organismo internacional ya con esta temática específica. Después tenemos que el Tribunal Europeo de Derechos Humanos se han presentado diferentes peticiones específicas para combatir el cambio climático. Entre ellas está Claudia Durante Agostino contra Portugal y otros 32 estados, miembros del Consejo de Europa. Otro que es la Asociación de Mujeres Mayores para la Protección del Clima contra Suiza y otro Greenpeace Norden contra Noruega. Estos recientemente, en 2023, a inicios, el Tribunal Europeo de Derechos Humanos, además de ya haberles dado trámite para que los conozca la gran sala, ya anunció que a finales de este mes, del mes de marzo, se van a ver 2 casos de justicia climática, uno de Suiza y otro de Francia. Y dijo que el caso Agostino se verá posteriormente. El octavo antecedente es que recién en 2022 se presenta también una opinión consultiva ante el Tribunal Internacional del Derecho del Mar sobre cambio climático y su impacto en el calentamiento de los océanos y el incremento en el nivel del mar. Y después ya tenemos estos 2 últimos antecedentes, que es el 9 de enero, esta solicitud de opinión consultiva 2023 ante la Corte Interamericana de Derechos Humanos y la potencial opinión consultiva que se presentaría ante la Corte Internacional de Justicia. Entonces, dentro de los primeros desafíos, el primer desafío que quiero identificar de 4 es que aquí podríamos llamarle primero en tiempo, primero en derecho. Desde mi perspectiva, va a haber una competencia por emitir criterios en esta materia o bien, ojalá, una complementariedad de criterios. Fíjense, entonces tenemos 4 tribunales que tienen que pronunciarse sobre el tema de cambio climático. Y aquí veamos rápidamente, yo creo que la delantera en tiempo la está tomando el Tribunal Europeo de Derechos Humanos con las audiencias que ya va a tener en este mes y subsecuentes sobre casos específicos y que la posibilidad de pronunciarse. Pero recordemos que el marco convencional del Convenio Europeo es muy acotado porque solamente tiene catálogo de derechos civiles y políticos para poder fallar sobre un tema muy amplio que desborda, digamos, esa categoría de derechos. El Consejo de Europa lleva ya como 2 o 3 años que no ha podido aprobar un protocolo facultativo que reconozca el derecho al medio ambiente sano como un derecho autónomo. Entonces, con el marco que tiene el Tribunal Europeo, pues se vislumbra un fallo más acotado, restrictivo, desde la perspectiva de las afectaciones exclusivamente al ser humano. Ahora, la Corte Interamericana ya avanzó en el reconocimiento de las DESCA de manera amplia y pues tiene un mayor abanico de posibilidades para atender esta emergencia. Por otro lado, el Corte Internacional de Justicia tiene algunos fallos interesantes sobre medio ambiente, pero pues camina más lento que el resto de estos tribunales. Algunos de estos fallos han sido Costa Rica contra Nicaragua, el Congo contra Uganda, sobre daños ambientales por deforestación, el caso de las papeleras de Argentina contra Uruguay, el caso de Ecuador contra Colombia por uso de herbicidas, entre otros, pero hay otras medidas que han sido más opiniones consultivas, como la de uso de armas nucleares o la de Kosovo, que terminó resultando quizás peor la petición de la opinión consultiva que no haber dicho mejor nada, ¿no? Pero bueno, los tiempos de la Corte Internacional de Justicia son un poco más lentos, a menos que se pida que se resuelva de manera urgente debido a la emergencia que representa este tema, y eso sí está contemplado en los estatutos y esto sí podría acelerar el proceso y por tanto el ritmo, digamos, en la carrera, ¿no? Y los ritmos del Tribunal de Derecho del Mar, eso sí, la verdad no los conozco, pero parece que las decisiones de pues son mucho más acotadas y tienen un menor eco. Entonces, en esta carrera jurídica será muy importante, pues, quién toma la delantera, pero también con qué marco y alcance se puede pronunciar sobre estos temas. Desde mi punto de vista, y como lo han dicho mis colegas, la mejor posición de marco para poder abordar esto la tiene la Corte Interamericana de Derechos Humanos, pero pues ojalá se puedan, como un concierto, una sinfonía, articular todos estos tribunales para que se puedan complementar unos a otros y eso forme un núcleo duro de derechos y obligaciones para los estados que mande un mensaje claro y alcanzable y general sobre esta temática pues, para todos los países del mundo, ¿no? Un segundo desafío rápidamente es el abandono del paradigma antropocéntrico al ecocéntrico y biocultural. Aquí ya tanto Mario como Viviana se han mencionado sobre los avances que hay en la región y también en Europa sobre los derechos de la naturaleza, o lo también llamado como la jurisprudencia de la tierra, que conceptualiza la idea de que los seres humanos no solo son una parte de una comunidad más amplia de seres y que el bienestar de cada miembro de esa comunidad depende del bienestar de la tierra en su conjunto. Desde mi perspectiva, si no se hace una perspectiva ecocéntrica de esta problemática, es poco lo que realmente los estados podrían hacer desde una perspectiva antropocéntrica para limitar sus emisiones de efecto de gas invernadero, etcétera. Esta es toda una temática muy amplia, pero tenemos ya muchísimos países que han reconocido en su constitución los derechos de la naturaleza, muchísimos fallos, y no solo en Latinoamérica, sino en Europa, Asia, etcétera, ¿no? Entonces, bueno, eso lo dejo ahí. Si quieren las preguntas lo podemos abordar a mayor detalle. Un tercer desafío me parece la distinción entre procesos abiertos y cerrados y las preguntas que se generan en estas opiniones consultivas. Entonces, como bien lo dijo Viviana, en la Corte Interamericana tiene un proceso participativo totalmente amplio, porque no solo hay un periodo para que se presenten amicus curiae por parte de estados, órganos dentro de la OEA o inclusive de otras partes del mundo, sino que también la sociedad civil puede participar, inclusive expertos a título personal, etcétera. Y después la Corte tiene una audiencia pública donde da participación a todas estas personas para que abonen en, digamos, la construcción de esta opinión consultiva. Y eso me parece que es algo totalmente favorable y que, por ejemplo, en la opinión consultiva 23 fue definitivo, porque el marco planteado por Colombia no fue lo que terminó resultando la decisión final de la opinión consultiva 23, que fue mucho más amplio. Entonces, aquí tenemos una Corte Interamericana que no se acote exclusivamente a las preguntas o a lo que le va a poner los estados de Chile y Colombia, sino que va a recoger realmente el corpus juris internacional y puede dar muchísimo mayores elementos. Más allá de las preguntas que están para